Tabling of documents. Dépôt de documents.
Tabling of documents.
Statements by ministers. Rapport de délégation.
Reports of it.
Introduction of government bills. Sorry, I missed that one. I'm reading the wrong column. Mr. Van Loan, seconded by Ms. Yelich, moves for leave to introduce a bill entitled An Act to Amend the International Transfer of Offenders Act. This motion is deemed adopted. Monsieur Van Loan.
Mr. Van Loan, seconded by Madame Yelich, moves that this bill be now read a first time and be printed. This motion is deemed adopted.
When shall the bill be read a second time? At the next sitting of the House. Déclaration de ministre.
Statements by ministers.
Reports from interparliamentary delegations. The Honourable Member for Leeds-Grenville.
Thank you very much, Mr. Speaker. I rise today pursuant to Standing Order 34-1, and I have the honour to present to the House in both official languages the following reports of the Canadian delegation of the Canada-US Interparliamentary Group respecting its participation at the Council of State Governments' 63rd Annual Meeting of the Southern Legislative Conference held at Winston-Salem, North Carolina, in August between the 15th and 19th of 2009. Thank you very much, Mr. Speaker. Happy to present this report.
Présentez,
Presenting reports from committees.
the Honourable Member for Abbotsford.
Thank you, Mr. Speaker. I'm presenting in both official languages the 14th report of the Standing Committee on Justice and Human Rights. In accordance with Standing Order 108, Sub 2, and the motion adopted in committee on Wednesday, November the 25th, 2009, your committee has considered the matter concerning a request for documents pertaining to Bill C-36, an act to amend the Criminal Code, and has agreed to report the matter to the House. Thank you.
The Honourable Member for Kildonan St. Paul.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour to present in both official languages the 7th report of the Standing Committee on Health concerning Bill C-6. Pursuant to Standing Order 108-2 and the motion adopted by the committee on Wednesday, November 25th, 2009, the committee recommends that the Standing Committee on Health report to the House its opinion that C6 is necessary to fill regulatory gaps and allow the government the power to issue recalls, and that the current framework for product recalls does not allow for timely and consistent action to protect Canadians, and that due to the committee extending its hours in order to ensure the timely passage of C6, as well as the House of Commons unanimously passing this important piece of long overdue legislation, this House should strongly encourage members of the Senate Standing Committee on Social Affairs, Science and Technology to act responsibly and in the interest of the safety and welfare of all Canadians, pass this crucial piece of legislation without delay. Thank you, Mr. Speaker.
Présentation de
Presenting reports from committees.
Introduction of private members' bills. Mr. Cochler, seconded by Ms. Jennings, moves for leave to introduce a bill entitled An Act to Amend the State Immunity Act, Genocide, Crimes Against Humanity, War Crimes, or Torture. This motion is deemed adopted. The Honourable Member for Mount Royal.
Thank you, Mr. Speaker. I am pleased to table an act to amend the State Immunity Act, the Redress for Victims of International Crimes Act, in support of the foundational principle that victims of torture and heinous international crimes deserve a right of redress against their criminal perpetrators. At present, the exercise of such foundational rights is precluded by the operation of the State Immunity Act, which immunizes the foreign states and their officials from civil suit. This legislation, the first of its kind ever, will allow Canadian victims to sue the perpetrators of international crimes in Canadian courts. Simply put, our present legislation criminalizes torture, war crimes, crimes against humanity, and genocide, the most heinous acts known to humankind. But Canadian law does not allow for a civil remedy for the victims of such horrific acts. Accordingly, this legislation will address the evil of such international crimes that are now shielded by Canadian law, target the impunity of those states and officials that perpetrate these crimes, remove the state immunity that operates to shield the perpetrators of such crimes, and allow Canadian victims to secure justice while holding their perpetrators accountable. Thank you, Mr. Speaker.
Mr. Cochler, seconded by Ms. Jennings, moves that the bill be now read a first time and be printed.
This motion is deemed adopted.
When shall the bill be read a second time? À la prochaine séance.
The next sitting of the House.
Mr. Julian, seconded by Mr. Bevington, moves for leave to introduce a bill entitled an act to amend the criminal code, cracking down on child pornography. This motion is deemed adopted. The honourable member for Burnaby, New Westminster.
Thank you very much, Mr. Speaker. Child pornography is nothing less than child abuse. What this bill does is substantially increase the penalties for those who are convicted of indictable offences around this child abuse, around distribution of child pornography, increasing punishment for making or distribution from 10 to 14 years, increasing the maximum penalty for conviction of possession or accessing child pornography would increase to 10 years from 5, and all other summary convictions would be met with a sentence of up to 3 years instead of 18 months. Mr. Speaker, as you well know, Canada has the sad record of being the second in the world for hosting child porn, for hosting this result of child abuse. We have to crack down, and that is why I am pushing forward this motion so that we can protect the children of this country. Thank you, Mr. Speaker.
Mr. Julian, seconded by Mr. Bevington, moves that the bill be now read a first time and be printed.
This motion is deemed adopted.
First reading of this bill, premier lecture de ce projet de loi.
Council approach.
When shall a bill be read a second time? The next sitting of the House.
Charlton, seconded by Mr. Alan Welland, moves for leave to introduce a bill entitled An Act to Amend the Parliamentary Employment and Staff Relations Act. Members' staff. This motion is deemed adopted. The honourable member for Hamilton Mountain.
Thank you very much, Mr. Speaker. I'm pleased to introduce this bill to amend the Parliamentary Employment and Staff Relations Act to ensure that staff of senators and members of the House of Commons who serve them in the capacity of member, leader, House Leader or whip would enjoy the benefit of being permitted, if they so choose, to organize a union, to belong to a union, and to enjoy the benefits of collective bargaining. This is a set of rights and privileges that is considered fundamental in modern democratic societies such as Canada. In fact, we worked long and hard to ensure that those rights are protected and advanced for all working people. I hope that all members representing caucuses in the House of Commons will see fit to support this bill. It is a matter of simple justice. Thank you, Mr. Speaker.
Ms. Charlton, seconded by Mr. Alan Welland, moves that the bill be now read a first time and be printed.
This motion is deemed adopted.
First reading of this bill, premier lecture de ce projet de loi.
Council approach.
When shall the bill be read a second time? At the next sitting of the House.
Vote of projet de loi.
First reading, introduction of private members' bills.
Motion.
Motions.
Presenting petitions. The honourable member for Western Arctic.
Mr. Speaker, and I have a petition here from numerous Canadians across the country, and we, the undersigned citizens of Canada, draw attention to the House of Commons to the following. It's a series of whereases dealing with the problems that are surrounding the safety management systems that have been put in place by Transport Canada, and therefore the petitioners call upon the Government of Canada to initiate a commission of inquiry headed by a Superior Court judge to conduct a judicial review into Canada's state of national aviation safety and government oversight of the aviation industry, to be followed by further reviews at defined intervals. Thank you, Mr. Speaker.
The honourable member for Tobic-Mactaquac.
Thank you very much, Mr. Speaker. And I have a petition here signed by a number of residents of Tobic-Mactaquac, as well as the riding of Fredericton, who are asking the government to issue a new Canadian Volunteer Service Medal called the Governor-General's Volunteer Service Medal for cadets, reserve forces, regular forces, who have served since 1947, who are not eligible for the Canadian Volunteer Service Medal between September 39 and March 1947, and June 1950 and July 1953. Thank you very much, Mr. Speaker.
Honourable member for Bramalea Gore Malton.
Thank you, Mr. Speaker. I rise today to present the following petitions on the behalf of my constituents who have been victims of violent crimes committed by the young offenders. In support of the family of 15-year-old Baden Wilcox, who was murdered on June 19, 2009, the petitioner called upon Parliament to implement these necessary changes to the Young Offenders Act for the benefit of the victims' families whose lives have been destroyed by the violent crime committed by the young offenders. Thank you.
The honourable member for Hamilton Mountain.
I have two petitions today, Mr. Speaker. I am pleased to table a petition today on behalf of hundreds of people on Hamilton Mountain who are outraged by the government's intention to harmonize the sales tax with the PST in Ontario. Despite the government's contention that the harmonization is a provincial matter, the petitioners are keenly aware that Ontario would not have acted if it had not been for the $4.3 billion of taxpayers' money that the federal government offered to pay the province as an inducement for harmonization.
Shame.
Working families and seniors are already finding it difficult to make ends meet, and the additional 8% sales tax on everything from electricity to vitamins to haircuts is something they cannot afford.
Shame.
The petitioners call on the government to demonstrate fair and responsible leadership on taxation policy by withdrawing the $4.3 billion bribe and abandoning its plans for harmonizing the sales tax.
Shame on the Conservatives.
I also have a second petition. Mr. Speaker, I am pleased to present yet another petition signed by residents of my hometown of Hamilton who are opposed to the Canada-Colombia Free Trade Agreement. The petitioners point out that Colombia has one of the worst human rights records in the Western Hemisphere, with dozens of labour activists and human rights advocates killed each year. They are outraged by the kill a worker, pay a fine provision, which make a mockery of human rights. As advocates for corporate social responsibility, the petitioners believe that all trade agreements must be built on the principles of fair trade, which fundamentally respect social justice, human rights, labour rights, and environmental stewardship as prerequisites to trade. Since the Conservative government has not done due diligence in this regard, the petitioners call on Parliament to reject the Canada-Colombia Free Trade Agreement until an independent human rights impact assessment has been done and the resulting concerns have been addressed.
Hear, hear.
Thank you very much, Mr. Speaker.
Honourable Member for Kildonan St. Paul.
Thank you, Mr. Speaker. And I'm just rising today on behalf of numerous of my constituents who are asking that this House vote against and reject Bill C-384, which is a bill that is presented here in Parliament to legalize euthanasia. And they consider this a deliberate killing. So they're totally against, as I'm representing them today, against euthanasia and assisted suicide. Thank you.
The Honourable Member for Yukon.
Thank you, Mr. Speaker.
I have about 10 pages of signatures from my riding of people that understand that animals can suffer, that all efforts should be made to reduce animal suffering, that over 1 billion people depend on animals for their livelihood. So my constituents petition the Government of Canada to support a universal declaration on animal welfare.
The Honourable Member for Elmwood Transcona.
Well, thank you, Mr. Speaker. My petition is a call to stop the Canada-Colombia trade deal. Violence against workers by paramilitaries in Colombia has been ongoing, with more than 2,200 trade unionists murdered since 1991. Much violence has been committed against the indigenous peoples, Afro-Colombians, human rights activists, workers, farmers, and journalists. While the agreement is similar to NAFTA, which has mainly benefited large multinationals rather than providing real benefits to working families, since NAFTA and Mexico has lost over 1 million agricultural jobs since the beginning of that trade deal. The murder of labor and human rights activists has increased in 2008 in Colombia and continues unabated to this day. All trade agreements must be built upon the principles of fair trade, which are fundamentally respect social justice, human rights, labor rights, and environmental stewardship as prerequisites to trade. Mr. Speaker, the petitioners call on the Parliament to reject the Canada-Colombia trade deal until an independent human rights impact assessment is carried out, the resulting concerns are addressed, and that the agreement is renegotiated along the principles of fair trade, which would take into account environmental and social impacts fully into account while genuinely respecting and enhancing labor rights of all affected parties.
Hear, hear.
Honourable Member for Saskatoon-Humboldt.
Thank you, Mr. Speaker. I have the privilege to present a petition on behalf of probably a couple thousand Canadians from across the country. They're particularly concerned about federal funding to International Planned Parenthood Federation because its promotion of abortion and its aggressive lobbying to promote abortion around the world, and their opposition to physicians' freedom. They're also very concerned because the federal government has been giving $18 million, $6 million a year to this organization, which, Mr. Speaker, pays its chief executive close to $500,000 instead of spending it on needed health care for women.
Honourable Member for Vegreville-Wainwright.
Why, thank you very much, Mr. Speaker. I'm honoured to present a petition on behalf of Albertans, Mr. Speaker, who note that in Canada we respect life, and in fact in the Canadian Charter of Rights and Freedoms we note that people have a right to life, and they note that it's been 40 years since May 14th, 1969, when Parliament changed the law to permit for abortion, and since January 28, 1988, there's actually been no law on abortion. So they call upon Parliament to pass legislation which would protect human life from the time of conception until the time of natural death.
The Honourable Member for Edmonton St. Albert.
Thank you very much, Mr. Speaker. I'm honoured to rise today and present on behalf of 187 constituents in Northwest Edmonton and in the City of St. Albert a petition calling on the Government of Canada to support a universal declaration on animal welfare. These constituents appreciate that billions of people rely on animals for livelihoods and for companionship, and I'm honoured to follow this petition on their behalf.
Presentation de petitions.
Presenting petitions.
Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, if question Q463 could be made in order for return, this return would be tabled immediately.
Is it agreed that question Q463 be made in order for return? Agreed, and so ordered. The Honourable Parliamentary Secretary.
Thank you once again, Mr. Speaker. I ask that the remaining questions be allowed to stand.
Agreed, and so ordered. Order. The Chair has received a notice of a question of privilege from the Honourable Member for St. John's East. I'll hear the Honourable Member now.
Thank you, Mr. Speaker. I have a question of privilege which is related to the government's action in suppressing evidence that was to be presented to a committee of this House. It's a question of privilege based on all members of this House. I'm not a member of this committee, but I will read the question of privilege, and should you agree that it meets the prima facie test, I would be prepared to make the appropriate motion. Mr. Speaker, as we know, questions of privilege arise where a member or the House of Commons as an institution has been prevented from carrying out its duties. These privileges include freedom of speech, freedom from obstruction, interference, and intimidation, and the right to institute inquiries, call witnesses, and demand papers. So important are these privileges of the House that they are rooted in the Constitution and contained in Section 18 of the Constitution Act of 1867. Mr. Speaker, the Special Committee for Afghanistan has for some weeks been attempting to exercise its parliamentary functions in relation to the hearings on allegations of detainee abuse in Afghanistan. Evidence that was submitted to the Military Police Complaint Commission on the same issue was suppressed by the government under the provisions of Section 37 and 38 of the Canada Evidence Act. The Special Committee wanted to obtain this evidence using its powers to call persons and papers, and so it called Mr. Richard Colvin, a senior diplomat, to testify. In order to assist in its work, the committee first called Mr. Rob Walsh, law clerk for the House of Commons, to testify and advise the committee. Mr. Walsh confirmed the privileges of Parliament in relation to hearing evidence, requesting testimony, and receiving documents. He confirmed that the Canada Evidence Act did not prevent Mr. Colvin or any other witness from testifying and providing documents to support that testimony. And he advised that parliamentary privilege overrules Sections 37 and 38 of the Canada Evidence Act. On the morning of Mr. Colvin's proposed testimony to the Special Afghanistan Committee, he received an email from a representative of his employer at the Department of Foreign Affairs and International Trade. In this email, the Department of Foreign Affairs and International Trade advised Mr. Colvin in writing that the Government of Canada does not accept the law clerk's legal opinion on parliamentary privilege. I quote, "Government of Canada does not share the clerk's view of the effect of the laws adopted by Parliament on parliamentary proceedings, and as a public servant, we trust that you will conduct yourself according to the interpretation of the Government of Canada. Should there be any concerns expressed by members of the committee, those concerns should be referred to Government Counsel." This email makes it clear that the Government of Canada does not accept Parliament's privileges and will not abide by the law clerk's confirmation of these privileges. The Government of Canada, in this email, attempts to intimidate a witness prior to his testimony in front of the committee. The Government also instructs the witness on how he is to answer questions from members of Parliament. As his employer, the Department of Foreign Affairs and International Trade, and the Government is in a position of power over Mr. Colvin, and this is a clear attempt to intimidate him. In 2005, the Federal Court of Appeal ruled that parliamentary privileges such as freedom of speech and freedom from intimidation and obstruction extend to witnesses testifying at committees. In addition, the official from the Department of Foreign Affairs and International Trade appears to expect that the members of Parliament must address their concerns about the issue of privilege to the Department of Justice rather than to their own counsel. This is a very disturbing situation, Mr. Speaker, and I'm perturbed that the Department of Justice and the Department of Foreign Affairs believes that all concerns by MPs on the admissibility of documents to Parliament should be referred by the witness to Department of Justice lawyers. These are lawyers who have already stated that they do not believe parliamentarians have the rights and privilege the Constitution accords them, as outlined by Mr. Rob Walsh's opinion in writing to the committee. Members cannot receive unbiased advice from the Department of Justice, nor are they obliged to report to the Department of Justice. Mr. Speaker, I regard this as a clear violation of members' privileges. It attempts to restrict their right to free speech and counsel, and it is an affront to Parliament. In silencing witnesses, interfering with and obstructing a person who is carrying out the lawful order of the committee, and denying parliamentarians' rights, the Department of Foreign Affairs and the Department of Justice are in contempt of Parliament. In addition, Mr. Speaker, the government's attempt to willfully ignore a constitutionally enshrined right of Parliament to oversee it and hold it accountable is deeply worrying. In turning a blind eye to this contempt of Parliament, a precedent is set that allows the government to withhold any evidence from Parliament that it seems embarrassing under the guise of national security. It also sets a precedent of ignoring rights of parliamentarians and their constituents. This goes right to the heart of government's accountability to Parliament and through that to Canadians. And Mr. Speaker, while this particular breach relates in some way to a committee, and I know that Your Honour would be very well aware of that, I'm not a member of this committee, and I'm not seeking a relief for the committee. I am talking here as an ordinary member of Parliament whose own privileges are breached by the failure and the lack of following the relationship between Parliament and the government that this breach speaks to. Mr. Speaker, the intimidation that we're talking about as well is intimidation that did not take place in the committee itself. It took place in private correspondence prior to committee hearings. I might add that it has also taken place in the public domain by the government, of course, with the character assassination of Mr. Colvin in recent weeks. The government's complete refusal to recognise the privileges of the House also did not take place in committee, nor is its refusal restricted solely to a committee. The government's blanket refusal to recognise the power to call persons and papers, regardless of the Canada Evidence Act, relates to this chamber. Members' affairs and their overall ability. I raise this issue in the House because it goes to the very core of the purposes of this House, and I believe that the government is trying to set a very dangerous precedent that actually threatens the work of parliamentarians in all its areas. When the government can take this approach to the parliamentary privileges and the advice being given to parliamentarians by the Parliamentary Council, it is in fact interfering with the rights and privileges of Parliament and the work of Parliament. Your Honour, is my submission as a point of privilege, and I would leave it to Your Honour to make a finding.
The Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. Mr. Speaker, I would just point out to my honourable friend that the motion requesting documents to be provided only was made yesterday and passed yesterday in committee. That request last evening, Mr. Speaker, went into the department for a response. We expect that response to be coming forthwith and will be provided as soon as possible. But, Mr. Speaker, I should also just make comment on one of the inferences that my honourable colleague made in his submission, and that is dealing with what he called a character assassination on Mr. Richard Colvin. Mr. Speaker, I would point out to you that it is the right of every parliamentarian during testimony in any committee to have the ability to question the witness and the content of that testimony. That is what our members on that committee did, Mr. Colvin. They did so respectfully, or I should say, Mr. Speaker, they did so respectfully, And Mr. Colvin, in his testimony, at the conclusion of his testimony, actually admitted that by thanking committee members from all sides and thanking them for their fairness in the way that they dealt with him during that committee appearance. I should also point out, Mr. Speaker, as most Canadians know by today, that in yesterday's testimony, 3 of the most eminent Canadians who represented this country admirably in the Canadian Armed Forces disputed almost entirely the testimony of Mr. Colvin. Yet I don't know whether my honourable colleague would call that or characterize that character assassination. Mr. Speaker, if you compare the testimony in yesterday's hearing with the testimony from some of the government members in questioning Mr. Colvin at his appearance, you will find that there is a connect. In other words, Mr. Speaker, the questions that our committee members raised and posed to Mr. Colvin were not only legitimate, but they were accurate in their assessments. So, Mr. Speaker, I would ask my honourable colleague in his submission that he would perhaps stand once again and retract that portion of his testimony that he called it a character assassination of Mr. Colvin. It was anything but, and that was proven yesterday. Thank you, Mr. Speaker.
Honourable member for Montmorency, Charlevoix-Côte-Nord. Thank you, Mr. Speaker. I would like to echo my colleague from the NDP, which is where he is complaining about the government's attitude in this file. It is a question of fundamental principles and natural justice. In a legal process, when the other party has documents that could move an investigation forward and be used to question witnesses, basic courtesy requires, and I'm fully aware that I'm talking about a minimum when I talk about courtesy, the principles of natural justice require that if a witness has documents that are provided to one party, they have to be provided to the other party. That is a basic principle. Why should the government have an unfair advantage by having documents that the witness does not provide to us so that we can play our role effectively? Once again, Mr. Speaker, this Conservative government is muzzling the truth and concealing information. This government has things to hide. It is maintaining a culture of secrecy by preventing a witness from providing us with documents ahead of time so that we can ask appropriate questions. My colleague, the Honourable Parliamentary Secretary, talked about the credibility, once again, of Richard Colvin. Once again, we see how hypocritically this government is acting. How can it pat itself on the back by saying that it protects whistleblowers when the party was in opposition? The Conservatives were always lashing the Liberals for their lack of protection of whistleblowers when they were just doing their job. If we have any respect for our public service that is so dedicated, then the government has to protect them because they make for effective administration. They should not attack their credibility and disparage them. Even if we have 15 former generals who appear, we need to put an end to this type of activity. I just want to give you a quote from the new procedure manual. Marleau and Montpetit seem to have been forgotten now. We have O'Brien and Bosque. And I'm on page 111, other examples of obstruction, interference, and intimidation, and I'm quoting here. I'll give you my references. It is impossible to codify all incidents which might be interpreted as matters of obstruction, interference, molestation, or intimidation, and as such constitute prima facie cases of privilege. However, some matters found to be prima facie include the damaging of a member's reputation, the usurpation of the title of Member of Parliament, the intimidation of members and their staff, and of witnesses before committees, and provision of misleading of information. So the witnesses before committees is the key issue here. End of quote. So I would submit that for your reflection, and thank you for introducing the new procedure manual last week. Thank you. The honourable member for Notre Dame de Gaz-Lachine on the same point. Yes, on the same point. Thank you, Mr. Speaker. I believe that the evidence is clear that the government, the ministers of the Crown, the Minister of Foreign Affairs and of Defence, the Minister of Public Safety, and others have violated parliamentary privilege. The question as to whether parliamentary privilege extends to witnesses who are duly called to appear before a committee that is constituted under the authority of this Parliament is clear on page 114.
Bosque, where we see a quote in a ruling given by the Speaker on February 20th, 1984, the Speaker stated, "A threat emanating from any government department or public corporation to withhold information or cooperation from a Member of Parliament would undoubtedly hinder that member in the fulfillment of his or her parliamentary duties and therefore constitute a breach of privilege." Goes on. In 1992, a witness who had testified before a subcommittee was advised by a Crown Corporation employee that the issue of her testimony was being referred to the corporation's legal department. If I look at the footnote 240, it says in the journals, December 4th, 1992, page 2284, Don Boudria, Glengarry Prescott Russell, contended that witnesses before the committees enjoy the same privileges as members of the House and are accorded the temporary protection of the House. In the member's opinion, if such threats were to go unchallenged, it would imply that witnesses before committees could not testify without the threat of being sued or intimidated. And that's the debates, December 4th, 1992, pages 14,629 to 14,631. If we go on to page 115, it was referred, the Speaker found a prima facie case of contempt, referred it to the House of Commons Standing Committee on, at that time it was called House Management for consideration, and the committee reported to the House on the question of privilege, and here is what the report of the committee stated. The protection of witnesses is a fundamental aspect of the privilege that extends to parliamentary proceedings and those persons who participate in them. It is well established in the Parliament of Canada, as in the British Parliament, that witnesses before committees share the same privileges of freedom of speech as do members. Witnesses before parliamentary committees are therefore automatically extended the same immunities from civil or criminal proceedings as members for anything they say before a committee. The protection of witnesses extends to threats made against them or intimidation with respect to their presentations before any committee. It is clear Mr. Colvin was duly called as a witness before the Special Committee on Afghanistan, which itself was duly constituted by this House of Commons under our rules and procedures, our standing orders. That committee called Mr. Colvin. Mr. Colvin came to testify. The committee also required documents from Mr. Colvin, and Mr. Colvin received a letter from the representatives of the Minister of Justice, a Minister of the Crown, informing him that they would take legal action against him should he file the documents before the committee. Mr. Speaker, it is a prima facie case of violation of privilege, breach of privilege. It is willful obstruction and intimidation, willful obstruction of the members of Parliament of that committee in the performance of their duties and functions and responsibilities, and it is a prima facie breach of privilege of the privilege which is extended to the witnesses before that committee. Thank you.
The Honourable Parliamentary Secretary of the Government House Leader once again.
Yeah, very quickly, Mr. Speaker, I'll reiterate what I had said in my earlier intervention. That is that, Mr. Speaker, at committee yesterday, at the Special Committee on Afghanistan, a motion was made following testimony by General Hillier, Lieutenant General Gauthier, and General Fraser. Committee members made a motion, which was passed, that documentation would be requested, and the government has already stated, Mr. Speaker, on several occasions, both by the Prime Minister and the Minister of Defence, that any legal documents available would be presented. And that, Mr. Speaker, is still the government's position. But I will also point out, in the overall and overarching question or insinuation by members opposite of intimidation of witnesses, Mr. Speaker, that one of the witnesses yesterday, Lieutenant General Gauthier, said that he was, quite frankly, shocked to find out, watching television a few days ago, that a member of Parliament of this House would go out on national television, in effect accuse the Lieutenant General of war crimes. Now, Mr. Speaker, if the members opposite want to talk about intimidation tactics, there can be no greater example of that than what Lieutenant General Gauthier mentioned yesterday. It is reprehensible, it is shameful to try and accuse one of Canada's finest public servants, charged with the responsibility of protecting our fighting men and women, with war crimes, unsubstantiated allegations, Mr. Speaker, on national television. So I would suggest to all members opposite, if they want to start making accusations about intimidation, they take a look in the mirror, Mr. Speaker.
Honourable Member for St. John's East. This will be the last submission on this matter.
Thank you, Mr. Speaker, and I appreciate the submissions by other parties, but I do want to say to the government member who spoke, the character assassination I was talking about was the character assassination that took place in this House and in the public by members of the government. And I want to thank the member for Notre Dame de Grace Lachine for her reference to the Parliamentary Procedures book that I see Your Honour is assiduously reviewing at the moment. But I do want to add that the effect on this witness goes further, Mr. Speaker, that in fact he was also instructed 2 days before to surrender any reports from Afghanistan in his possession to the Department of Justice. So we've got not only telling him that we don't agree with what the Council to the Parliament says in its interpretation of the parliamentary privileges, we're not going to allow you to present the papers that they're looking for because we're going to instruct you to give them to us. Now that's clearly, Mr. Speaker, an attempt to interfere and obstruct with the operations of this Parliament by preventing an individual under pain as an employer to prevent them from presenting papers to this House that the committee is clearly looking for. This goes well beyond the activity of the committee itself, and is in fact the whole of Parliament is affected by this. If the government can operate in this way to thwart and defeat and remove the privileges of members of Parliament by their actions as employers in giving instructions to its employees. That is the thrust of what we're saying here today. What I'm saying here is my breach of privilege, and I thank the members on this side who supported my motion.
I've heard enough on this point.
I'd like to thank the honourable members who've raised this point of order, especially the honourable member for St. John's East.
In my view, this is not a matter of privilege for the House at this time. And I say at this time. It may become one, but the witness in question is testifying before a committee of this House, not before the House. The question of privilege, in my view, is one that should be raised in the committee. The committee has full power to decide whether or not its privileges have been breached, and it will want to do so when it sees what information is submitted by the witnesses to the committee. They may not have had all the papers with them on the day they appeared, but they may be tabled later before the committee or brought to the committee later, and the committee can decide whether or not it's got what it was entitled to receive and whether or not there has been a breach of its privileges, and it can then give a report to the House. And if a report comes to the House, it's up to the Speaker to decide whether that report then allows a member to raise a question of privilege arising from the report, which then will get priority treatment in this House as befits a question of privilege. And I refer honourable members to page 151 of O'Brien and Bosk. If, in the opinion of the chair, and this is in a committee, if, in the opinion of a chair, the issue raised relates to privilege, the committee can proceed to the consideration of a report on the matter to the House. The chair will entertain a motion which will form the text of the report. It should clearly describe the situation, summarize the events, name any individuals involved, indicate that privilege may be involved or that a contempt may have occurred, and request the House to take some action. The motion is debatable and amendable and will have priority of consideration in the committee. If the committee decides that the matter should be reported to the House, it will adopt the report, which will be presented to the House at the appropriate time under the rubric presenting reports from committees during routine proceedings. Once the report has been presented, the House is formally seized of the matter. After having given the appropriate notice, any member may then raise the matter as a question of privilege. The Speaker will hear the question of privilege and may hear other members on the matter before ruling on the prima facie nature of the question of privilege. As Speaker Fraser noted in a ruling, and I quote, "The Chair is not judging the issue, only the House itself can do that. The Chair simply decides on the basis of the evidence presented whether the matter is one which should take priority over other business." End of quote. Should the Speaker rule the matter a prima facie breach of privilege, the next step would be for the member who raised the question of privilege to propose a motion asking the House to take some action. And should the Speaker rule there is no prima facie question of privilege, no priority would be given to the matter. And so, in my view, this is clearly a matter that the committee can consider. If it decides that its privileges and its members' privileges have been breached, it can report the matter to the House, and we can deal with the matter when that report arrives here in the chamber. But in my view, the privileges of the House itself at this moment have not been breached. Possibly there has been a breach in the committee. I'm making no judgment on that matter. But when the committee makes a report, I'll hear argument on it if necessary and give a ruling in accordance with practice at that time. But I believe it would be premature for the Speaker of the House to decide a matter that is currently before a committee, has not come back to the House from the committee, except in submissions by the honourable member, and the committee will have to decide on its own initiative whether or not the privileges of the committee or of its members have been breached by what has transpired. So we'll leave the matter there for the time being and move on, I believe, at this point to orders of the day. Oh, okay. The
honourable member. The honourable member for Terrebonne-Blainville on a point of order. Thank you, Mr. Speaker. I'd like to ask for the unanimous consent of the House for the following motion. That notwithstanding any standing order, the debate provided for under the standing order be deemed to have been done, and that the standing committee, that the report by the standing committee presented June 17, 2009 be concurred in. Does the honourable member have unanimous consent to present this motion? Agreed. The House has heard the question. Is it the pleasure of the House to adopt the motion?
Orders of the day. Orders du jour.
Order émanant du gouvernement, projet de loi.
Government orders, government bills, commons.
Reading of Bill C-58, the Child Protection Act.
Resuming debate, the honourable member for Leeds-Grenville.
Thank you very much, Mr. Speaker. Pleased to rise today on second reading of Bill C-58, an act respecting the mandatory reporting of Internet child pornography by persons who provide an Internet service, and to reiterate this government's commitment to protecting our children. Mr. Speaker, evolving communication technologies like the World Wide Web have proven to be of clear benefit to Canadians. Sadly, these same technologies have also provided new and easier means for offenders to make, view, and distribute child pornography. As a result, there have been a significant increase in the availability and volume of child pornography. It has also enabled criminals to coordinate and plan a wide range of other crimes. Unfortunately, despite its undeniable benefits, today's advanced technology not only makes these crimes easier to commit, but also harder to investigate. And while technology has advanced rapidly, it is a challenge for law enforcement to keep pace with new technologies when it comes to investigating crimes. There are also reports of an increased demand for material with violent content and/or material showing children who are very young. This increased demand is being met with increased supply. Child pornography constitutes a very serious form of child victimization. Not only are children sexually abused and exploited, but the continuing demand for production and use of child pornography objectifies all children as sexual objects for the sexual gratification of adult predators. Mr. Speaker, according to the recent report by the Federal Ombudsman for Victims of Crime, Every Image, Every Child, the number of images of serious child abuse quadrupled between 2003 and 2007. And as I mentioned, these images are becoming more violent and feature younger children. Mr. Speaker, I was appalled to discover that 39% of those individuals accessing child pornography were viewing images of children between the ages of 3 and 5, and 19% were viewing images of infants under 3 years old. And I'm sure that most law-abiding Canadians would be just as horrified at these statistics. In addition, Mr. Speaker, cybertip.ca, which is Canada's national tip line for reporting the online sexual exploitation of children, receives more than 800,000 hits and more than 700 reports to its website each month. Mr. Speaker, to help in our goal of putting a stop to the growing problem of sexual exploitation of children, the Minister of Justice introduced the other day legislation that will create a more uniform mandatory reporting regime across Canada. It will require persons who provide Internet services to the public to report certain information about Internet child pornography. Failure to comply with these duties would constitute an offence punishable by fines and, in some cases, imprisonment or both. Mr. Speaker, our efforts are focused on the Internet and on suppliers of Internet services because the Internet is largely responsible for the growth in child pornography crimes over the last 10 years or so. Mr. Speaker, this legislation covers more than just Internet service providers, or ISPs as they are known. This is a term which, of course, is commonly used in relation to those who provide access to the Internet. The legislation would apply to all persons who provide an Internet service to the public, including Internet access, electronic mail services, Internet content hosting services, and social networking sites. Mr. Speaker, this new reporting regime would complement actions that this government has already taken earlier this year. Our government introduced legislation that proposes to update certain existing offences and create new investigative powers to help law enforcement officials to deal with crime in today's technological environment, as well as legislation regarding investigative tools for enforcement agencies to quickly respond to crimes such as child pornography. These pieces of legislation acknowledge that the same communications technologies that benefit our day-to-day lives also provide easier ways of committing crimes, as well as shielding perpetrators from investigation efforts. Mr. Speaker, Bill C-58, which will be a new act, complements well the measures already in place in the Criminal Code. The Code's existing child pornography provisions prohibit all forms of making, distributing, making available, accessing, and possessing child pornography, including through the use of the Internet. At the same time, Mr. Speaker, I must also applaud the efforts of provincial and territorial governments who have already enacted or are contemplating legislation on mandatory reporting of child pornography. Children are also protected from sexual exploitation through provincial and territorial child welfare legislation, which permits the voluntary reporting of child pornography and makes it mandatory in 3 provinces. The approaches adopted in Manitoba, in Ontario, and in Nova Scotia require all citizens to report all forms of child pornography. Mr. Speaker, Bill C-58 is a new federal criminal legislation that is narrower in scope than those in these 3 provinces. Nevertheless, it would provide for uniform mandatory reporting regimes across the country, one that would complement provincial and territorial efforts under their child welfare legislation. Mr. Speaker, I am also encouraged by the actions of the many suppliers of Internet services who have been good corporate citizens in voluntary reporting of child pornography. And the reports to cybertip.ca have resulted in a number of arrests as well as numerous children being removed from abusive environments. Mr. Speaker, our government takes the safety of our citizens, particularly children, very seriously, whether in cyberspace or out in our communities. The creation and distribution of child pornography is appalling, and it is an odious crime in which children are brutalized over and over again. A mandatory reporting regime across Canada will improve law enforcement's ability to detect potential child pornography offences, help reduce the availability of online child pornography, facilitate the rescue of victims, and help identify and apprehend offenders. Through this legislation, Mr. Speaker, our government is continuing its progress in protecting Canadians, improving our justice system, and ensuring that it keeps pace with modern technologies. And at the same time, we are reiterating our commitment to protect children against sexual exploitation. Thank you very much, Mr. Speaker.
Questions and comments? Question de commentaire. The Honourable Member for Malpeque.
Thank you, Mr. Speaker. I am indeed pleased to speak on Bill C-58, and just to summarise so that people.
We're on questions and comments. I'll come to the Honourable Member for Malpeque in about 5 minutes. We'll go first to the Member for Elmwood-Transcona.
Well, thank you, Mr. Speaker. And I wanted to ask the member who had just spoken whether the government had done some best practice searches across the world to see whether there's other jurisdictions and, that have maybe had dealt with the matter more effectively, and ask him if he looked at Sweden, Brazil, or Germany, or other countries in the EU as examples of where more effective options may be found.
The Honourable Member for Leeds-Grenville.
Well, Mr. Speaker, I know that there has been a number of countries and provinces and territories. There's been a look at what they've been doing, because I know that, Mr. Speaker, Canadians treat this as something very serious, and I know that we need to look at all of the possibilities to ensure that we do protect our children, because this bill does so much to accomplish what we have been stood in the way of being able to investigate and being able to get at the perpetrators of this very terrible crime.
Questions and comments? The Honourable Member for Lethbridge.
Well, thank you, Mr. Speaker, and I have a question for my colleague, but just maybe to preface that a little bit. It was a number of years ago I brought the private member's bill to the House to deal with with child pornography. We had noticed in the criminal code there was no provision to take away the equipment and materials that were used to create child pornography, and we brought that forward, and to the government's credit at the time they put it into a bill and it became law. So we feel pretty strongly about some of these issues. Well, I just wanted to ask my colleague how many cases of internet child pornography are investigated annually in Canada. That he indicated that the ISPs are offering information now, but I'd just like to know what's happening presently in Canada.
The Honourable Member for Leeds Grenville.
Well, thank you very much, Mr. Speaker. I'd like to thank the Honourable Member from Lethbridge for that question, because it is very important, and I know it's something that's very important to him. But, Mr. Speaker, the latest statistical data we have relating to child pornography is from 2007, and during that year there were over 1,400 police-reported child pornography incidents, of which 440 of those resulted in charges. Now, unfortunately, we have no way of knowing if any of these cases were initiated by an internet service provider report. But what we do know, Mr. Speaker, however, is that the proliferation of images over the internet really is a growing problem. And according to the Federal Victims Ombudsman special report that I spoke about in my presentation, Every Image, Every Child, the number of images of serious child abuse quadrupled between 2003 and 2007. And the images are getting more violent, and the children in the photos are getting younger. So, Mr. Speaker, I know that this is something that the Honourable Member from Lethbridge takes very seriously, and I do too, and I know that our government does, and that's why this legislation was introduced.
Questions and comments? The Honourable Member for Elmwood Transcona.
Well, thank you, Mr. Speaker. And yesterday, the member for Moncton Riverview, Dieppe, in his speech, had outlined the information that in Sweden the child porn is actually blocked. In Germany and the EU, they also block access to the child porn sites there. And then, in fact, in Brazil, they had set up ethical rules which the ISPs have then signed into. And I wonder if the member might see these options as perhaps more effective than, or maybe in addition to the effects of this bill.
The Honourable Member for Leeds Grenville has 30 seconds.
Well, thank you very much, Mr. Speaker, and this is actually excellent input, and I think that we are right now on second reading. I encourage all members. I think that there's strong support amongst all parties for this to move to committee so that we can get it to the committee and get it looked at, because I know that members of Parliament will want to hear about all of the possibilities and making sure that we do everything possible to fight child pornography.
Resuming debate, the Honourable Member for Malpeque.
Thank you, Mr. Speaker, and I am pleased to speak on Bill C-58, and I just think it's important in beginning to summarize again what this bill is all about. This bill imposes reporting duties on Internet service providers, ISPs, and on those who offer Internet services to the public when child pornography appears in accounts provided to their subscribers, or if they have reasonable grounds to believe that their service is being or has been used to commit a child pornography offense. That basically summarizes the bill, Mr. Chair. As a party, we are certainly in support of second reading and sending it to committee. I think it's important as well, Mr. Chair, to look at a little history, because the governing party tries to leave the impression that they're the only party that believes in law and order. I can tell you that this has been on the agenda a long time, and we looked at it when we were in government. When I was Solicitor General, we were very worried about child pornography and how the Internet, although it's a wonderful tool in terms of providing information to citizens, it's also a tool that those for other reasons can use to, in this case, exploit children and exploit people in many other ways. So I just want to outline the fact that this, although the government tries to indicate that it is not the only party that believes in law and order. I think we all in this House believe in law and order, but when we pass these laws, they have to be laws that are balanced and do what they are intended to do without creating other on-scene consequences and on-scene complications for others in society. As with all legislation, Mr. Speaker, that mandates a third-party actor to report online dealings to the police, a balance needs to be struck between policing and privacy concerns to protect net neutrality. We intend to examine these questions at committee, and so that's why it's extremely important that we get it to committee, that we allow the proper witnesses to come forward who work on the Internet system, who understands the technicalities and the difficulties of imposing this new burden on providers for all the right reasons, albeit, but we need to understand the implications of that in terms of the laws that we make as well. I might point out as well, Mr. Speaker, another reality, and the member for Moncton Riverview Dieppe mentioned this yesterday in somewhat similar tone. The reality is, in 2005, the mandatory minimum sentence of 1 year for an offence of possessing and creating child pornography was instituted by a Liberal government. The definition of child pornography was broadened by a Liberal government to include depictions, digital or otherwise, in order to trap more perpetrators of the crime. That took us up to late 2005. Then we take the canvas over to January 23, 2006, as the Honourable Member for Moncton Riverview Dieppe said. I have sat, and I quote him, "I've sat through the Justice Committee meetings and read the literature since that time without interruption. I have not attended every meeting, but I have been there for the whole agenda. There has been nothing on child pornography in that time. If we are all united in Parliament to try to do some good and combat the ill effects of the web and child pornography exploitation in particular, we ought to say to each other that this is not good enough." End of quote. I think the key point, Mr. Speaker, that the member is making, and I agree with it, is that we have to come together quickly, that it's been a long time since, as I said, when I was Solicitor General in 2003, this was then an issue. And each and every day or month that passes, the Internet system is used for exploitation of others out there, and so we have to get this committee and get this issue dealt with. So it's been a considerable amount of time for the government to bring this forward. As well, I would point out that all Attorney Generals across Canada, from the Attorney General meetings with the provinces, all Attorney Generals basically support the move in this direction. And because of the slowness of the federal government in terms of moving forward, some of those governments are taking action on their own. And if you're going to have good laws in Canada, Mr. Speaker, there has to be coordination across the piece, and that's why it's so important that the federal government take the lead in terms of the implementation of these laws. So I do think it's important, then, Mr. Speaker, that we get this bill to committee, Bill C-58 to committee, have our hearings, and get it acted on. But while I'm on my feet, Mr. Speaker, and talking about law and order issues, and I've mentioned it before in the House of Commons, there is an area that I'm really concerned about, and I think it fits into this in some fashion. We will see, and that's the whole way that the Minister of Public Security is undermining the rehabilitation aspect of inmates by abolishing the prison farms. Mr. Speaker, I've said before, this is an extremely important issue. We have a government that's talking about law and order, but their law and order agenda just seems to be to go out there and build super jails, put more people in prison. If we're going to have a justice system that works, Mr. Speaker, it has to be one that rehabilitates people. And one of the best rehabilitation aspects of that system is in fact for those inmates to be able to work on farms, and there's 6 of them across this country. And one of the most productive farms is in the Kingston area, and I have been there, Mr. Speaker. In fact, it is the Speaker's home riding. 6 institutions in that area. The Penn Farm in that area has one of the best, most productive dairy herds in Canada. And this government is talking about closing it down. A farm in which inmates get up and get out there and work with cattle and produce crops, supply other institutions in the Kingston area and across the country to Laval, Quebec, with food, productivity, of which they take pride in. And they do contrary to what the Minister of Public Security states, that skills of farmers are no longer worthy. They are, in fact, worthy. Because they don't just learn how to be a mechanic or how to milk a cow. They learn teamwork. They learn management. They learn computer skills. And they learn how to relate through the use of feeding and working with cattle and livestock. So I just want to take the opportunity while I'm on this bill to emphasize this point again, Mr. Speaker, that the decision of this government, with no data, with no supporting data, to close those prison farms across the country, lose that productive ability, lose the rehabilitative aspects of working on farms for inmates, is a terrible decision. It's a wrong decision, and I'd encourage the minister, to come to a sensus and recognize that they're an important part of our correction system and should remain. So, Mr. Speaker, I will admit that I've got a wee bit off track from Bill C-58, but my point in expressing the prison farms and the seriousness of the decision of the government is that while they talk about law and order, while they're great on messaging, their actions are not always in the same direction that they're leaving the impression they're moving forward with. So just to conclude, Mr. Speaker, on C-58, the bill is important. It does stem from an agreement reached at the 2008 meeting of federal, provincial, territorial justice ministers to enact mandatory reporting requirements on ISPs and online content providers for child pornography cases. The major components of this bill that we support are mandatory reporting of all website addresses that they are aware may contain child pornography. And secondly, mandatory reporting to police when they believe that a child pornography offense is or has been committed using their services. The provider must also preserve the relevant computer data for 21 days after notifying police. Unless required by judicial order, that data is to be destroyed after that 21-day period. Mr. Speaker, I think those are valid reasons, and our party is certainly willing to give support to this legislation, to get it to committee, to be studied further, and to be implemented, I hope, quickly, so that this terrible issue of child pornography and exploitation of children on the Internet can, in fact, get dealt with. Thank you very much.
Questions and comments? Questions and commentary. The Honourable Member for Lethbridge.
Well, thank you, Mr. Speaker. And I just pose a question to my colleague from Malpeque. When he did get around to talking about the bill, it's good to hear that they are going to support this, because I think when it comes to the issue of child pornography, we as members of Parliament need to stand united in any kind of a fight to stop this most terrible of crimes. I think the fact that we're willing to work together to protect the most vulnerable of our society is important. I just wanted to relay to the member opposite that a number of years ago we had I think it was Detective Matthews from the Ontario Provincial Police came on the Hill with some others to talk to us about this issue. And we were in a room, and he set up his computer, got on the internet, and went into, I don't know where they go, a chat room or something, and indicated that he was an underage person looking for some company. By the time our meeting was over, where we reviewed some disturbing images that none of us will ever forget, related to child pornography, and I don't know how these people that deal in this day after day can keep their focus, because it's just absolutely terrible. There were a number of hits on that, in a matter of an hour, there's a number of hits on that website from people wherever to take advantage of this child. So I think the more we can do, the faster we can do it, the better off our children will be. Just a comment to the member.
The honourable member for Malpeque.
Yes, I thank the honourable member for the point he raised, and just to re-emphasize his point, because Detective Matthews, and that was a considerable number of years ago, who is one of the leading people on, I think, getting not only Canadian governments but governments around the world to deal with this serious issue. And I think any of us who were sitting in the room that day will not forget those images, because it is. I mean, as you sit there and look at, you just wonder, how can human beings do to human beings what they sometimes do? I guess I could put it that way. And it reminds me as well, the member's comments reminds me as well of a meeting I happened to attend in Paris as Solicitor General on the same subject of where internationally they're trying to, because this exploitation can take place anywhere in the world, and then it's viewed right across the world, and absolutely shocking, and in terms of the abuse of human beings and of children for, I guess, somebody's thrill, or in some cases financial gains, Mr. Speaker. And it is, I think it's one of the worst crimes out there. And it has been on deck a considerable time, and very definitely has to be dealt with if we're going to do the right thing for future generations. So I just want to agree with my honourable friend that what we seen that day was very disturbing, and also I think we would all agree in this House, those police officers and others who try and deal on a daily basis on tracking these kind of crimes down, they need to be congratulated, because mentally it has to be such a drain on their being in order to see this, to try and track it down and try and deal with it constructively.
Questions and comments. Questions et commentaires. Reprise du débat.
Resuming debate.
Kildon and St. Paul's.
Thank you, Mr. Speaker, and I'm very pleased today to stand in this House of Commons with parliamentarians from all parties to talk about Bill C-58. You know, Mr. Speaker, in this Parliament, probably one of the most important things we are doing is addressing the protection of our most vulnerable citizens, and those are our children. This bill, Bill C-58, is a bill. It provides a level of certainty for all those who supply an internet service to the public, that they're held to the same reporting standard with regard to child pornography. Child pornography, we've heard in this House, is on the increase. The images that are displayed are becoming more and more violent. And our government recognizes the efforts of major internet service providers in voluntarily reporting this type of material. However, creating a uniform mandatory reporting requirement with respect to internet child pornography on all who supply internet services to the public across Canada will strengthen our ability to protect children from sexual exploitation. And as I've listened to all the speeches, there has been a thread through all the speeches. And this thread has been that all members feel that this is just a horrendous crime against children. I know, Mr. Speaker, you have small children, and I know that it must touch your heart, because our children are our most precious things that we have. So here our government now is improving a law and improving
the law enforcement's ability to detect potential child pornography offenses and help reduce the availability of online child pornography. It'll also facilitate the identification of victims so they may be rescued and help identify and apprehend offenders. This is a very, very important piece of legislation, Mr. Speaker. And you've heard before in the speeches that there are 1,400 police-reported child pornography incidents, of which 440 resulted in charges. And that isn't even up to date. There are more today in the year 2009 going into 2010. You know, Mr. Speaker, there are many, many good people across this nation that are watching and putting the lens on what this Parliament is doing in terms of protecting our children in this country. Because traditionally speaking, Parliament is a place that sometimes, Mr. Speaker, can go wonky. Even though there's a good bill up, sometimes we find out that it doesn't get passed. So we have a lot of unnamed people making a lot of unnamed speeches and sound good, but in the final end, the laws sometimes do not get passed. And as we know, Mr. Speaker, after we deal with the laws here in the House of Commons, they then go into the Senate and have to be examined before they can receive a passing. Now, across this country, there are people that I want to talk to this Parliament about, people that have made a big difference and are watching what our government is doing in terms of child pornography. And I must say, Mr. Speaker, I'm so proud that our government also introduced related bills, Mr. Speaker, that has supported Bill C-58. So there's a concerted effort with our government to address this our most vulnerable citizens and to protect our children. Our government has recently produced 3 hard-hitting related bills, and one is Bill C-46. It was brought up on June 18th, 2009, and that bill requires Internet service providers to provide police with email and ISP addresses of those viewing child pornography, and requires ISPs to freeze child pornographic data for 21 days. It also requires cell phone companies to assist police in trafficking child porn on cell phones and BlackBerries. And again, Bill C-47, Mr. Speaker, which was passed on June 18th, 2009 as well. It was also a bill that permitted police to obtain information about clients from ISPs and requires companies to acquire the technical ability to allow police to intercept information. So Bill C-58 is just another building block on this foundation that helps to protect our children. You know, Mr. Speaker, I have met many, many people in my travels over the past decade working on this issue of human trafficking and child porn in our country. And as a mother of 6 children, and as the mother of an RCMP officer, and one who used to be in the Integrated Child Exploitation Unit, I have seen firsthand the cost that a lot of these police officers have paid because they sat there and they viewed those images and they went out and they tried to get the bad guys. I pay honor and respect to all the police officers out there who have done that. There is many projects across this country that are outside of Parliament Hill that have really put pressure on all of us as members of Parliament to pay attention to stopping this horrific crime. And when we talk about child porn over the internet, it brings to mind Mr. Brian McConaughey. Brian McConaughey was the founding director of the Ratanic Foundation, and he was a forensic, and he is a forensic scientist with the Royal Canadian Mounted Police. He served the Royal Canadian Mounted Police actually for 22 years. Now, he was the gentleman who worked significantly to help build the case against Donald Baker. For 19 of those years, he performed his duties with the RCMP while setting up and running this foundation, and then after that, he continued on. Now, I was talking to Mr. McConaughey yesterday, and he and I work on different things. But when we're talking about the Olympics, we're talking about human trafficking, we're talking about child porn, Mr. Speaker, it's all connected. And you know what makes a lot of these people, these police officers and these frontline workers working with these victims and with the victims of internet child porn, what makes them so special is their heart. And I want to tell you, you know, the Baker file has kind of been, you know, in some cases forgotten, but other files keep coming up that come and go, and they're horrendous, yet they're forgotten. And I know everybody remembers the Willie Picton file, because in Vancouver, in BC, that was a horrendous case that hit the front pages all along. But the RCMP officers and the police vice officers that were working on the child porn over the internet and on these cases were touched very, very deeply by the victims of this crime. So when you have the internet and you have people watching the images, when you have them going across the ocean and acting on those images, acting on those fantasies, and then they come back and they continue that appetite for acting on the fantasies because they've allowed themselves to go into that dark place that human beings often have with child pornography. But when you talk about that and you talk about the frontline officers who actually work and you talk about the victims, I want to talk about one victim just to impact our Parliament today to understand. I want to talk about Serena Abbotsway. Serena Abbotsway was killed by Willie Picton. She was a kind young girl who was on the streets helping young people who were the victims of human trafficking and child pornography. And she underwent many beatings trying to rescue people, many beatings herself because she was a street girl. And I have to say that when I was talking to Mr. McConaughey yesterday, or day before yesterday, I guess it was, because he's off to Cambodia right now, he was telling me as a forensic scientist how he became not only attached to the cases, but also attached to the victims. He told me what it felt like to look at the skull of Miss Serena Abbotsway and to look at the picture. There's a picture he had of her. She was baptized at a church on the east side, and yet she worked on the streets and was involved in all sorts of different things. But there before him was her remains. And you know, he treated her remains with respect. And as he went through her particular case, when he finished doing his forensic science work, he put her skull away and said goodbye to her, but that he would never forget her, and that he would do the best he could to ensure that other victims were not hurt. We can talk about people like Matt Logan, Mr. Speaker, because I think in this Parliament, the public needs to know about these heroes, these unsung heroes, who work so hard every day. He's a recently retired RCMP officer, Matt Logan, and he's penetrated the psyches of countless psychopaths, pedophiles, and hostage takers. He's spent time in the jail system, Mr. Speaker, assessing predatory sex offenders. And he is one of only 17 people, Mr. Speaker, in North America who are both police officers and qualified psychologists, and one of even fewer who specialized in the criminal mind. Now, the member opposite mentioned about the toll it took on the police officers. I know many police officers who have taken that toll because of their work. Matt Logan knows an awful lot about pedophiles and about the minds of pedophiles. He knows how to get into those minds and how to rescue the victims. Mr. Speaker, Mr. Logan has done so much to bring this issue to the forefront here on our national scene. And Staff Sergeant Matt Logan said, he said, I have a hard time believing that given an opportunity that child predators, when after watching victims, wouldn't act on their fantasies. Child pornography, he said, exists primarily for the consumption of predatory child molesters. So it's the beginning of something that can grow. Logan, who is a criminal psychologist in the RCMP's behavioral science group and has done extensive work with sex offenders, has been called on more and more to consult on child exploitation cases. And RCMP Matt Logan describes two types of child molester, the situational and the preferential. And I have to tell you, he says that most molesters fit into the situational category, and what that means is, he says that most are male and are indiscriminate with victims, committing sexual assault based on accessibility to a victim. So, Mr. Speaker, if they have a pornography collection, child porn is usually a small portion of it. The preferential child molester can be of any age, driven by fantasies centered on a specific age, gender, or even the look of a child, Mr. Speaker. Most gravitate, Mr. Speaker, to prepubescence. Isn't that shocking? And RCMP Logan said, although he has worked with some of them whose fetish was newborns, preferential child molesters also have long-term pattern of behavior and almost certainly collect child porn. So the images and erotic stories fuel fantasies that drive the bus to hunting and molesting a child. Now, this is a statement from a seasoned 22-year RCMP officer who worked in this area. So Bill C-58 is extremely important. And talking about close to home, I know my own son, who's RCMP and who was in the ICE unit, on his days off, goes all over this country talking to associations and groups about how to protect their children against child molesters. In fact, this Friday night, or next Friday night, he and I will be doing a joint presentation at one of those locations. But there are other people, Mr. Speaker, like Leanna MacDonald, who's the head of the Canadian Centre for Child Protection. She does so much to try to get the cyber tip lines up and running, and she works hand in hand with Beyond Borders, with Roz Prober. And I have to say that now we're seeing for the first time businesses across this country who are actually putting money toward organizations who are fighting child trafficking and child porn. And one of them is the Body Shop. They have recently launched a huge initiative about hand cream. So I can tell you my Christmas baskets are going to be filled with their hand cream because of their support of protecting child victims from human trafficking and from child porn. I want to talk about, too, Paul Gillespie from Kensa. Paul Gillespie was on the streets protecting children, victims of child abuse, and has worked, he worked on the ground all the time with a lot of these young women. And I've met some of the young women who he has rescued, and now he's with Kensa, the Kids Internet Safety Alliance, and he works with Canadian law enforcement and other partners to deliver training and build capacity amongst police in developing nations to help them find and rescue children of child abuse, victims of child abuse, whose images are shared on the internet. And once rescued, he helps the victims and their families receive support to help them heal through the Mothers Online movement. It's called MOM. It's a powerful community network. So these are the unsung heroes that are listening today to what's going on here in Parliament. We talk about Paul Gillespie, this former police officer who built and led the child exploitation section of the Toronto Police Service Sex Crimes Unit, has become widely known as a world leader on this issue. I consider him a very good friend of mine and someone who is one of those unsung heroes who has never been brought to the forefront for his work. And today I want to do that and to thank him. And then you have the small groups that are springing up all over our nation. Those groups that don't receive any money from anybody, but they find out about human trafficking and child porn, and they go out and they educate people. I've always said that education is our greatest tool, Mr. Speaker. We talk about Naomi Baker from Canada Fights Human Trafficking, who has got so many people together and educated so many people on how to protect their children. We talk about Natasha Fall. Natasha Fall is my hero because she was a trafficked girl. She was a victim. And she was the daughter of a cop. But she has got off the street. She's helped so many people. And she now runs Youth Unlimited. And you will never find a more articulate, more beautiful, more grounded person than Natasha Fall. And I have to tell you, she is the poster girl for getting programs in place that will protect and help these victims because they can be restored. And we talk about the beautiful Temple Committee in Montreal, the Temple Committee Against Human Trafficking, who Rabbi Lerner started. There's so many people here are working so hard, Mr. Speaker, to ensure that this horrendous crime is suppressed. Even today, in the other chamber, I have Bill 268 that is awaiting the passing of that bill in the Senate, and we look forward to all the people there supporting that bill. And one other thing I think, in closing, that has to be said, Mr. Speaker, that over and over we hear in Parliament about this issue has to be a non-partisan issue. When it comes to the protection of our children, we as parliamentarians, Mr. Speaker, have to work together. It is so important. We have the Olympics that are coming on us in a very short time. And I happen to know that the bad guys now are getting all the girls together. I actually know some towns where they've actually taken some of these girls from. So we can't wait and sit. This is Canada's hidden secret. This is one of our darkest spots in history when child sex slavery is allowed and when child porn has become something of a joke to some of the people in our country. We have to take this seriously. We have to speak out. And as parliamentarians, we can't afford the luxury of in-house bickering. We can only afford the luxury of the privilege of putting laws forward that will protect our most vulnerable victims. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? The Honourable Member for Lethbridge.
Well, thanks again, Mr. Speaker, and I want to thank my colleague from Kildonan St. Paul for her message today and for her tireless work on the issue of human trafficking. She's chosen that as a focus of her efforts, and she's done a tremendous job on it. But I would like to ask her her opinion and her thoughts on the fact that our government has passed legislation to increase the age of sexual consent from 14 to 16. I was certainly in favor of that, and we worked at that for many, many years to make that happen. And I always viewed it as just helping to protect our children for 2 more years of their lives. And in her focus and her specialty on human trafficking, has this bill worked, this raising of the age of sexual consent or age of consent, has that helped our police officers and our authorities in this fight on that terrible crime of human trafficking?
The Honourable Member for Kildonan St. Paul's.
Thank you, Mr. Speaker, and I thank my colleague for that very timely question. Raising the age of consent is long overdue. I wish we could have raised it to 18 or 21, but we did get it raised to 16, and I'm grateful for that. Throughout this country, Mr. Speaker, children are now being targeted. Children who are virgins get a higher price when they're sold to predators. And I think this is alarming and unconscionable. We always thought it happened in other countries. Well, it's happening here in Canada. So our government has put a lot of very strong laws in place that are very, very important to protecting our most vulnerable citizens. And I applaud members opposite who have supported these bills and supported these initiatives, because I know there are many good people opposite that take the welfare of our most vulnerable citizens instead of their own personal gain. And that's what it's about here in Parliament, Mr. Speaker. It really doesn't matter who's up in front of the cameras. It really doesn't matter who gets the credit. But what we have to do is stand very firm as a federal government and have support of all our opposition members to help these bills go through.
Questions and comments? Reprise du débat.
Resuming debate. The Honourable Member for Argenteuil-Papineau-Mirabel. Thank you very much, Mr. Speaker. I'm pleased to speak on behalf of the Bloc Québécois to Bill C-58. This bill denounces respects the mandatory reporting of Internet child pornography. To begin with, I want to say that the Bloc Québécois supports the principle of this bill. We will vote in favor of it at this stage so that the bill can be carefully considered in committee. When a bill comes from the Conservative Party, I always feel that it has to be looked at on an individual basis. We have to be very vigilant knowing their approach to crime. I want to say that for the benefit of those watching. We do need to be very cautious. The government wants to deal with crime. It says it has decided to take away judicial discretion and impose minimum sentences. We know that the public is widely against this type of change. The judges are also being influenced, and the government is trying to get them to take a more right-wing approach. So they are losing their discretion. They are being imposed this minimum sentence regime. They are in favor of abolishing the gun registry, and that means that all Canadians can have long guns, but the sentences are going to be longer. With respect to the gun registry, I have just renewed my owner's license. I used to be a hunter, and I say used to be because I no longer have time to go hunting. There are a number of things I am not able to do because I don't have time, but I do have a hunting rifle. We know that I asked my wife to sign my form, and she could certainly do that because I don't have any violent history. I think, Mr. Speaker, that this is a good way of making sure that there is harmony on the domestic front, but also that people with violent dispositions have more difficulty, because certainly my wife would not have signed if I was violent.
Because this was a way of fighting violence, and it's hard for me to understand, but they are conservatives, and they have this Republican way of seeing things. And I think from a point of view of logic, there are these requests for a firearm permit. Well, I think it's only logical that we should do this sort of thing in order to possess a firearm, but this is the conservative logic, this Republican logic. here we have conservatives who are tearing their shirts saying we want to fight violence against women, but they don't understand that we have to watch a firearm possession, but they won't do that. So in the Bloc Québécois is asking the right questions, and we would hardly base ourselves on a conservative analysis of the thing to agree to a bill. But the Canada Child Protection Agency has carried out studies in order to find out how today in 2009 there are companies that offer internet services and who have no policy to prevent child pornography on their site. It's horrible, Mr. Speaker. But here we are. That's the situation. I discussed this with one of my teenagers, and he's part of the internet generation, and they're a generation that wants everything to be available, everything to be on internet. It allows for everything to meet people from across the world. So we had some very good discussions on this, and I said, well, yes, there should be a lot of freedom, but not for this sort of thing. And that's what C-58 means, to fight. So, Mr. Speaker, we would have hoped that this situation of child pornography didn't exist, but I do agree that we have to fight it. Here are some statistics, and these come from polls and analyses on the part of the Canada Child Protection Agency, just to give you an idea of where we are. And child pornography is one of the main concerns of parents, and child exploitation is another main concern for Canadian parents. And they would like us like there to be a way to protect their children. Mr. Speaker, it's hard when you're a parent to be told by an association like this Child Protection Agency that the means we have are now outmoded in protecting against child pornography. It's because the internet didn't exist when this legislation was drafted. So parents today, and I am a parent myself, parents of my age, and I'm in my 50s, well, we just weren't used to this kind of technology. Of course, I use it now, but for me and my friends, it's not easy. It wasn't easy when the internet came on the scene. We did learn how to use it. So perhaps the Canadian Child Protection Centre is right. And we have to bring forward more efficient ways, more effective ways of educating children and protecting them. So in 61 cases of sexual assault, the victim is a child. So many of these cases of assault are committed regularly against children. Many Canadians feel it's too easy to find child pornography online. And 76%, or rather 96%, think there should be a way of preventing child pornography on the internet. So again, this is from the Child Protection Agency. There are more than 8,000 calls about complaints on child pornography. In 74% of cases, people can use the internet without any supervision. Children can. And this Centre for Child Protection felt that parents were overwhelmed by this phenomenon. Many children or many parents will say that there is no supervision. The centre says there's not enough supervision. Now, there is some software you can use to prevent certain things, but you can't use it to block everything. There's all kinds of information available, and there are all kinds of people online who are able to get away with child pornography, and that's why in 2009 we have to remember that the owners of internet sites in 2009 will allow child pornography. It's unimaginable for most of us, but when you've got money, when there's a demand, it's clear that there are people who will do this for the basest monetary reasons. And they provide information on child pornography, and we don't have the means, or we haven't spent the money necessary to make sure that this sort of thing is blocked. So it is there are site owners who are responsible, but in many cases they haven't taken the means necessary to prevent this kind of thing. And often we legislators are accused of passing legislation that doesn't go far enough. And in this case, these site owners or site operators have just gone too far. And we in the Bloc Québécois think that this bill should go to committee and be properly and thoroughly studied, because there are problems in Quebec and Canada, and we have to make sure that people's rights are respected. But when it comes to child pornography, we may have to bend people's rights and freedoms, because it has to do with protecting children. And so the charter may be a bit bruised, but we have to make sure that people responsible for operating these sites assume the responsibility for it. Because according to the Child Protection Center, they say that a great number of children actually meet the people in person that they've met online. These are statistics from 2005. 21% of children have met these people in person, people they've met on the internet. And this was in 2005. These children say they actually met physically the person that they met on internet. And with statistics like that, we really can't do otherwise than deal with these base predators. We cannot remain insensitive to these statistics, because children are innocent, and we have to remember I have these discussions with my teenager, and he thinks that everything has to be permitted. But when we see that 21% of children who have been online meet someone in person that they've met online, well, that's fine if they're meeting someone their own age. But sometimes these are people who are trying to pass for someone their own age, and they're actually adults. So given that we have this situation, and given that 74% of children who go online are left to their own devices, well, parents think that it's not a dangerous thing. But forget about it. They are. They have to talk to their children, because often children can be targeted by predators online. And we have to take action against this sexual exploitation of our children. And that's what this bill, C-58, aims to do. But I also wanted to read to you something published by the Canadian Child Protection Agency. They issued a press release recently, and I'd like the House to hear this. Here's an extract. We see that since already at a very young age, children can find these sites, and they often don't know the people who will victimize them. There is often internet abuse, and we want to make sure that the people of Canada understand that this abuse exists, to blow the whistle on any suspicion of abuse, and to make sure that that this kind of thing is not marketed. Child pornography is not marketed online. Mr. Speaker, we ask the question. We all ask this question. How is it that in 2009 the internet has not dealt with this problem? Well, it's because, here again, technology allows for this kind of thing to get around any means of blocking these sites, and they are able to get these child pornography images online. So we have to legislate it. We have legislated, but because there's money involved, people will find a way to get this kind of thing online, and it's exploitation, because when we're talking about images of children, sexual images of children on the internet, we have to find a way to get a hold of these abusers and make sure that they can't exploit children anymore. And that's why the Bloc Québécois will support this bill. But we also have to realize all this, and this is why I want to get back to the study I've been quoting, because they have 12 recommendations. This is the Child Protection Agency, and they talk about education, awareness raising, but it goes far beyond bringing in legislation and nabbing the people who commit these horrible crimes, and having very specific penalties for the people who own these sites. But people have to be made aware of what's going on. And I wanted to discuss, first of all, the importance of this bill, because there are situations that we have to talk about. First of all, ISPs, those who host certain sites, they will have to blow the whistle on anyone who puts this kind of thing on their site. I think that, this will go to committee, and then at some point it'll go to the Senate, which should be abolished, but that's another question. So it will make people, it will oblige people to blow the whistle on anyone who uses their service to create child pornography sites. ISPs will be obliged, the service will be obliged to blow the whistle on these websites. And secondly, they will have to advise the police and provide them with any evidence they have of child pornography on the internet. And here again, we shouldn't have had to adopt this bill. They should be doing it on their own without having to be forced, but they've pushed their luck a little too far. So anyone who has this within their network will have to pay so many thousands for a first offense, $5,000 for a second, and then other amounts of money for other offenses. and there will be a regime for companies, and there will be a progressive range of fines. So this legislation targets more than ISPs, as generally understood. They would also target anyone who offers internet services to the public. I see that you're signaling that I have a minute, Mr. Speaker, but I think our fellow citizens have to be made aware of the situation, and we have the Canadian Centre for Child Protection, which has made very important recommendations. Parents, families, everyone has to understand and do everything necessary to find these pedophiles, these pedophile criminals who are using cyberspace to commit their crimes. And this is an absolutely hateful, odious crime, and you can be assured of the support of the Bloc Québécois. The Honourable Member for Mississauga South.
Thank the Honourable Member for his contribution to the debate. I must admit, when this member gets up, Mr. Speaker, he always adds to the debate. And I was most interested in, and I'd like to speak as well, with regard to other things that we should be doing, and particularly in the area of prevention. We need to anticipate, Mr. Speaker, much more than simply punish after we have the problem. We need the dollar best spent in most situations is a dollar spent on preventing a problem in the first case. The member outlined a couple of items, the need for public education and awareness, etc. I wonder if the member would like to simply highlight some of the other approaches that would be appropriate in regard to the matter before the House.
The Honourable Member for Argenteuil, Papineau, Mirabel. Thank you, Mr. Speaker, and I thank my colleague for his excellent question. Yes, he's giving me an opportunity to talk about the recommendations of the Canadian Centre for Child Protection. They recommend making people aware and coming up with a way of educating young children about the dangers of exploitation, and to cooperate internationally on fighting cyber pornography. And we should also have gender-specific ways of targeting these problems, because little girls and little boys sometimes need different approaches. We should be able to request from servers to make sure that new internet owners cannot buy domain names and reuse them for other purposes. There are going to have to be far more investigations on these servers. We have to facilitate cooperation between organizations, and we have to go after these sites that host child pornography. And there are other things that I could talk about later, but the main thing is to make the public aware of this child pornography. The sexual exploitation of children is a terrible thing, and we want to help fight it. Questions and comments? The Honourable Member for Elmwood Transcona.
Mr. Speaker, and the member for Mississauga South had talked about prevention being the answer, and I think he's totally right here. It seems to me this bill, while it's well-intentioned and one that we can all support, in fact is just going to basically maybe slow the problem down a little bit because, depending on how many people report. The fact of the matter is we had a member in the House report yesterday that there are better practices in other jurisdictions such as Germany, Sweden, and Brazil, and I asked the government member earlier today whether in fact it even looked into those cases, and he couldn't answer the question as to whether they had or they had not. But in the case of Germany, for example, they simply block access to the sites. Now, to me, that makes sense because that's the final, that provides a solution to the problem rather than simply tinkering with the problem, and when we already know you're not going to get very solid results, or at least not as good a results as you get if you simply block the site in the first place.
The Honourable Member for Argenteuil, Papineau-Mirabel. Mr. Speaker, my colleague is quite right. This is why in committee there will be an in-depth analysis. Our problem is the Charter of Rights. In Quebec and in Canada, clearly, you have operators of the internet, the service providers who feel they too have their rights. This is what I'm saying. Perhaps we will have to have a look at that in terms of the sexual exploitation of children on the internet. Yes, we'd like to see this issue resolved very quickly, but with the legislation that protects charter rights and freedoms, we have to have an in-depth look at it. Questions and comments. The Honourable Member for Chambly-Bordura. Mr. Speaker, thank you. I want to congratulate my colleague, the member for Argenteuil Papineau-Mirabel, for his speech. My colleague raised this issue, the position of the Conservative Party with respect to the firearms registry. It's difficult to follow the rationale that can be explained here. The attitude of the Conservatives is such that even if you agree with this bill, and I think it goes without saying that we all are, it's difficult to see how they could tolerate the detention and the torture of a child soldier in Guantanamo and what's going on in Afghanistan, apparently. The Honourable Member for Argenteuil Papineau-Mirabel, my colleague is quite right. Each justice bill that they bring forward, the Conservatives, we have to look at carefully and try to see it in all its parts. This whole issue of the justice bills is to try to win a public opinion poll, a campaign to win over people's views. We have always been very respectful of Quebec here. We have been totally against any type of attack against children, against pedophilia, against and we have also trusted in the legislature. We have trusted in the system. We trust the justice system. We have never been led astray by demagoguery, by the media's interpretation. No, the Bloc has always been against torture, but not just when the media's attention has been drawn to the issue. We have always brought this up and been concerned about it. We have been against the torture of prisoners, the abuses against children, all these and we have stood up for Quebec values. This is what we have always done in the House and will continue to do so. Questions and comments?
Moncton Riverview, Dieppe.
Thank you, merci, Madame la Présidente.
Thank you, Madam Speaker. I do have a very quick question for the Honourable Member dealing with Quebec specifically and the sufficient reserves for police officers in regions. It's always the case with new governments that they bring in legislation with respect to crime, but often there's not enough information at Justice Committee to see whether or not there would be enough money. There would be enough money to enforce this legislation when it comes about. Can I ask him specifically with respect to Quebec? Are there enough resources in Quebec to enforce this legislation? The Honourable Member for Argenteuil Papineau-Mirabel. Well, Madam Speaker, thank you. I thank my colleague for his question. Before I came to the House, I was president of the Union of Municipalities of Quebec. We also have the police forces that are very important as part of this. The Minister of Public Safety would say, I'm sure, that there's a fine balance here, a third for the Sûreté of Quebec, a third for the cities and municipalities, and a third for the municipal boards. So the question raised by my colleague is a good one. The legislation will probably pass, but will there be enough resources there to see that it is enforced? To fight the sexual exploitation of children on the internet, you have to have the necessary monies. And because the Conservatives have as their goal to win political points on the short term, in terms of polls, while we wonder what it's going to be when this type of legislation will actually be implemented. Will there be enough money there so that all police forces can become coordinated, and so that the SQ and the police forces in municipalities will be able to band together to fight this scourge? Resuming debate.
Well, member for Mississauga South.
Thank you, Madam Speaker, and I'm pleased to participate in this debate at second reading of Bill C-58, which is the latest bill that the government has brought forward. Madam Speaker, it struck me as peculiar that the bill was just tabled and all of a sudden it's before the House to be debated without briefing notes from the Minister, without a legislative summary, without consultation or somehow engaging the members to consider the issue before us, which really is not internet laws or something like that. It's about the protection of children. That's what the bill is about. And if you put it in that context, Madam Speaker, you understand that this specific bill related to child protection is a very, very small piece of the discussion. And it concerned me, Madam Speaker, and I think it's slowly coming out. We are at second reading. And Madam Speaker, the reason that I wanted to rise is that I would like to encourage members to put on the table as many as possible recommendations for the committee to consider. Not just the bill as it stands, this very narrow bill as it stands, but to examine how this bill could have been part of a comprehensive approach to child protection beyond simply those who happen to have detect child pornography on the computer, whether they be individuals or organizations. When I saw the penalties for a first offense in this particular case, Madam Speaker, being $1,000, I thought, my goodness, child pornography probably generates millions of dollars. $1,000 just doesn't seem to be in the ballpark. And my premise, Madam Speaker, is that if you are not part of the solution, you must be part of the problem. And the previous speaker from the bloc raised for members' consideration the issues of prevention and of course, from the Canadian Centre for Child Protection, the need for us to be doing much more. Much more. Madam Speaker, whenever you have a criminal justice bill before you, I always like to assess it from and not being a lawyer, I can enjoy the luxury of saying, what do I know and how do I feel about this bill and what it does to address the problem before us? And I look at what's the issue we're talking about, why are we doing that, what are the elements of the penalties and the incarceration, what are the issues with regard to rehabilitation, if possible? And what are the issues with regard to prevention? Because, Madam Speaker, when you talk about criminal justice issues, you've got to deal with it from the after you have the problem and before you've got the problem. The prevention, and we know from all of the work that's ever been done on health and justice issues and wherever we have social problems, is that understanding and admitting we have a problem, that admission and accepting it is the first step. And then the next step has to be, how do we prevent that? How do we prevent some of these problems? So, Madam Speaker, I think the government, now I should say at the outset, the bill in its narrow way is worthwhile to support to go to committee, and I suspect to support to become law. But it is so narrow, Madam Speaker. It is so narrow in its approach. It's tinkering. It's like, why, how many times have we asked, why doesn't the government come forward with comprehensive legislation that addresses the issue? The issue is child protection. And we have problems. And so when I looked at the Minister of State for Status of Women, gave the government's position, the speech on this, and I'm pretty sure somebody wrote it for her, but at least 2 or 3 times it mentions in here, Madam Speaker, it refers to Canada having the most comprehensive framework in the world to combat child pornography. Comprehensive to combat child pornography. And we can and must do better. Okay. Well, most comprehensive. You know, I went a little later in the speech. My goodness. Canadian criminal laws against child pornography are among the most comprehensive in the world and apply to representations involving real and imaginary children. And it comes on again, and it's repeated again. You know, Madam Speaker, you can say that if it's the truth. You can say that's the truth. But if you look at the statistics, and it says Canadians should know that 39% of those accessing child pornography were viewing images of children between the ages of 3 and 5 years of age. And 19% were viewing images of infants under 3 years old. Madam Speaker, the public doesn't really know that. But when you consider that we are talking about a problem, a significant problem, of children 5 years of age or younger. The vast majority of this problem is 5 years of age or younger. Madam Speaker, why doesn't the government ask themselves, how is it that a child under 5 years or under, how is it that that child could actually be a victim of child pornography? Can you imagine in your own lives that your own child, in your own life, could your child be involved in that? If so, why? If not, why not? We have, collectively, in our knowledge and our experience, we know the conditions which are fertile for wrong things or for bad things to happen. We understand those things. But, Madam Speaker, we're tinkering. We have a serious problem. The minister admits it. Minister of State admits it. But we have the most comprehensive receipt. Well, we don't, Madam Speaker. When you have a problem as pervasive as that, and you look back at some of the history, we had a report, for instance, a Joint Commons Senate report. It was called For the Sake of the Children. Madam Speaker, it dealt with issues of family breakdown, and it recommended things like, if there is a dispute, a custody dispute, and an acrimonious debate, that there must be a parenting plan in place. Parenting plan in place before a divorce would be granted by the courts. That was a Joint Commons Senate, and that's years ago. And, Madam Speaker, it never happened. It never happened. But I'll tell you something. I spent a fair bit of time working on children's issues. I wrote a book called The Child Poverty Solution, dealing with child poverty causes. And Madam Speaker, child poverty is one of those things that tugs on the heart. Okay? Who could be against dealing with child poverty? But, Madam Speaker, it is family poverty. Every child is poor. It's family poverty. And, Madam Speaker, why are families poor? Well, I mean, if you have a scale from, and divided into quartiles, no matter how much anybody makes, somebody's in the 4th quartile. And under the definition that we have right now, if you're in the 4th quartile, you're basically counted as one of Canada's poor. Well, Madam Speaker, poverty needs a definition. But I'm not going to get into that because the bill isn't about child poverty, other than this is a contributing factor.
is a contributing factor, Madam Speaker, to why a child would in fact be accessible and vulnerable to being a victim of child pornography. Madam Speaker, I also wrote a book called Divorce: The Bold Facts, and it dealt again with family breakdown and the impact on children. And Madam Speaker, the research that I did, it's just amazing. The implications to children of family breakdown is enormous. And where those children land up, and the quality of care that they get, and the circumstances that they have to live in, Madam Speaker, tells me that this is a fertile area for bad things to happen. I wrote another book called The Strong Families Make a Strong Country. It was going on the same thing, showing statistically that the intact family of child with biological mother and biological father had the least incidence of bad outcomes for children. The statistics show it out. It's not a subjective opinion. It's objectively determinable, and it's been shown so many times. And one other related book that I wrote, Madam Speaker, was called The Tragic Tolerance of Domestic Violence. And we're in a period now where, and I'm wearing my white ribbon because we're talking about right now an area that is extremely important, that domestic violence and violence against women is still rampant in our country. I spent 5 years on the board of my shelter for battered women called Interim Place and helped them get a second shelter built. But you know, Madam Speaker, I'm hoping that these shelters will go out of business. In the perfect world, we wouldn't need shelters for women and children who are abused. And Madam Speaker, you know, we just had this faint hope clause bill, Bill C-36. And, you know, Madam Speaker, 4 out of the 6 women who applied for the faint hope clause were abused women who killed their husbands and were convicted of first-degree murder. And all of them had children. And Madam Speaker, 4 of the 6 who had applied actually were granted early parole and continue to be under the care, and they have a life sentence. They still have a life sentence, but they were granted early parole, Madam Speaker, because that is the compassion that we show, that we understand that bad things happen. And in a couple of those cases, the husband was having an affair on the side. There were consequential things, but there was a first-degree murder. And it's terrible that murder occurs, Madam Speaker. But Bill C-36 eliminates the opportunity for parole after 15 years. It says if you commit first-degree murder, you are going to serve 25 years before you get the first opportunity. Can you imagine what that does to a family that has children? I don't understand why that's going to happen. I don't understand. I don't support the elimination of faint hope, but that's not before us right now. Madam Speaker, I have said so many times in this place that public education, public education is always, Madam Speaker, public education is always part of the solution to our problems. All our problems, Madam Speaker. When you have social problems, you have to understand them. You have to look at them. You have to look at... Canada cannot pretend to be the creator of all good ideas. They do come from other places, Madam Speaker. Other countries have done a lot of work on this. And yet this bill was so hastily put together that it actually is anemic in its approach to the issue of child protection. It's okay to do this. I don't think it won't harm things, but I don't think it's going to help as much as people think it is. It's because the velocity of information, we have a situation even with regard to how do you police this? How do you make this happen? Madam Speaker, when we pass laws in this place, by and large, it is not the federal police, the RCMP, who are going to be responsible for enforcing the laws that we pass. It is going to be the provincial and regional policing forces across the country. They are the ones. Ask them today. Ask the province by province, region by region, territory by territory, what is the shape of their budgets with regard to policing? Madam Speaker, why pass laws that you can't enforce or that you can't actualize the potential that those laws have. If you can't support the policing, is it there? Have we talked about concurrent with this that there is going to be a special fund set up, or special task forces, or special policing forces? Because, Madam Speaker, when you find a little nest, that nest may be part of a whole colony. Madam Speaker, it's going to take time, but if you're serious about dealing with child protection in the context of child pornography, there has to be a strategy. And the strategy is not, let's tinker with it with this one and tinker with it and we'll do something else. But then boast. You cannot boast that we've got the most comprehensive strategy and we're the best in the world. It is misleading Canadians. And the previous member from the Bloc who spoke, he said, we have to make people aware. We all have to be part of the solution, Madam Speaker. We all have to be aware. We need the tools and the information, but here we are as parliamentarians, and what we have is a bill. Here's the bill, okay? And this document is after you rip out all of the boilerplate pages that have nothing to do with the law, it comes down to 4 items, Madam Speaker, 4 items of where there may be an offense, okay, for individuals or persons, and then there is punishment, offenses and punishment, and for the first offense for an individual who knowingly but does not disclose that there's child pornography on a particular site can be fined not more than $1,000. And when I read that, Madam Speaker, I said, we're not serious. We can't be serious. If we're worried about, well, maybe they just didn't realize what their legal obligation was, and that probably will be the case, that in itself is a reason for us to launch a major national public education and awareness campaign that this is a problem, and these are the tools that we have, and we're asking Canadians to be part of it. But that's not there. It's not there in this bill. This bill is... Somebody decided that maybe we ought to do this just because of what's happening in the world, about domestic violence and about, children. Let's get tough on crime. This is about punishing people after the problem occurred, after people got sick. Madam Speaker, when I came to Parliament, the first committee I wanted to be on was the Health Committee, and I was there, and I remember the very first committee meeting that I attended. We had the officials before us, and they were going to give us the State of the Union of the healthcare system in Canada. And what they said to me, what they said to the members of the committee, was that 75% of what we spend on healthcare is dealing with curing after you've got the problem, okay? 25% was spent on prevention. And their conclusion, Madam Speaker, at the time was that model of 25% prevention, 75% remediation after you got the problem was not sustainable. And they built on this to say that the the benefits of $1 spent on prevention was worth 3 times more than $1 spent on cure and remediation. In other words, the value of prevention has a multiplier effect in terms of good outcomes, better outcomes. And the same principle applies to criminal justice. Madam Speaker, it's not good enough to say, if you do the crime, you do the time, throw people in jail, throw away the key, and you're a bad person. But Madam Speaker, if we could reduce the number of people that are in jail and that have to be fined, etc., that's a good outcome. And we know that things like conditional sentencing, the statistics were there. It said that people who qualified for conditional sentencing, house arrest or whatever, actually had a lower recidivism rate than those who had to serve all of their time in jail. I mean, that's not just my opinion. Those are the facts, Madam Speaker. Less people in jail coming from people who got conditional sentencing or early parole, if you wish. Madam Speaker, it makes some sense. But we don't make sense when we come forward with bills that are so narrow. They're almost political documents as opposed to, justice documents. This is a political advertisement. we'll support the bill. But why not come forward with notes and information for members of Parliament so that they can discuss it and make recommendations to the whole House so that the committee, when it receives this bill, it will be able to address some of the items that we address. That's what we should be doing at second reading, Madam Speaker, is telling the committee that I'm concerned about this, I'm concerned about that. Please look at this. They have the opportunity to do it. I know that the members on the Justice Committee will look at it. But, Madam Speaker, we have to stop bringing bills forward that don't have they're not our best work. They're not our best work. It could be much better, Madam Speaker, and I hope that honourable members will get engaged, start debating this bill, start instructing the committee on the kinds of approaches we should take to make this legislation better, and to recommend to the House further, Madam Speaker, that there are other areas that we should consider bringing forward legislation for the protection of children.
Questions and comments? The honourable member for Edmonton St. Albert.
Madam Speaker, I'd like to thank the honourable member for his contribution to this debate, which I listened to with some interest. A couple of questions. He talked about the faint hope clause. I'm not sure that there's a clear nexus or relation to the bill under consideration, but he spoke in favour of the faint hope clause and by definition against what happened yesterday where this House voted at third reading to abolish it. I'm curious as to why he didn't vote against Bill C-36 yesterday if he felt so strongly. And secondly, with respect to his rhetorical question as to why a child under 5 could be subject to sexual abuse, which I think is a very good question, but I'm curious as to what his thoughts are with respect to this government's universal child care plan, a plan that provides families with support to make choices and to provide balance between work and home, and allows more parents to be more interactive in the raising of their children.
For Mississauga South.
All right. Madam Speaker, we shouldn't be talking about the faint hope clause. I used it as the issue had to do with the process that we feel that, you have to punish rather than prevent. Okay? Prevention, and in some cases with regard to children, the faint hope clause, and I gave the example of 4 out of the 6 women who were abused women and murdered their husbands, after going through the very rigorous process, were able to apply for early parole. And I voted in favor of the motion to strike out everything in the bill and refer it back to committee. That was my vote to negative the bill. Okay, and that was a clear vote. I voted to just scrap the bill and throw it back to committee. With regard to the universal benefit, I don't know. It's not universal if in the same sense, but Madam Speaker, $1,200 a year is not enough for a family to be able to afford to put one child into child care for more than about 3 or 4 weeks. So, Madam Speaker, I would suggest to the member that it's a very weak argument in regard to child protection issues.
The honourable member for Elmwood Transcona.
Well, thank you, Madam Speaker, and I want to thank the member for his comments. And yesterday, when the minister was introducing the bill, she said that $42.1 million over 5 years was being provided to law enforcement as more resources to deal with the problem. And when I asked her whether that was new money or not, she said she didn't know and she was going to get back to me. And I guess that just points to what the member for Mississauga South has said, that the bill has been rushed, the notes are not available, and really the government is not done the research it should. For example, earlier on today I asked one of the members from the government side whether or not they'd done any research as to best practices in other jurisdictions. It's a logical thing to do. Clearly they haven't been doing that in some other cases where they follow the California prison system, which has been a total failure for 20 years. So they haven't really had a history of checking around the world for best practices. But the member for the Liberal Party yesterday very clearly pointed out that in Sweden, they block child porn. In Germany, they block access to the sites. That, Madam Speaker, takes care of the problems. And so this bill is only going to take us part way. It's a bill that we're going to support and should be supported. But, I mean, the horse is out of the barn here. And the way to deal with the problem is to look at what works in other countries.
The honourable member for Mississauga South.
Well, certainly, Madam Speaker, I think the member is quite right. First of all, this was not a best effort of the government, quite frankly. They haven't thought it through carefully. They haven't taken the opportunity to look at ways in which we can have legislation that's going to deal with the incidents. And the way you deal with the incidents, for some odd reason, the government seems to think if you put a tough enough penalty out there, it's going to be a deterrent. Well, Madam Speaker, it doesn't work. It doesn't work. You know, bad criminals, they don't respond. They don't think of what's the penalty under the criminal code. I'll see whether I'm going to do this crime or not. That's not the case. Now, with regard to the money, the member's quite right. I mean, if you've got a bill and you're prepared, you have got the anticipated questions, and you've got your answers out. Here is what the typical. We didn't even have it with regard to C-36 in committee. They didn't even get the answer about how many people actually applied under 745. I mean, why is it that the government doesn't get it? They don't get it that if you're serious about legislation, you better bring forward the facts and the information, put it all on the table, and let it stand on its merit. That's good legislation.
Questions and comments? The honourable member for Moncton Riverview, Dieppe.
Thank you, Madam Speaker. I want to thank the honourable member for his question. He will recall, I will not, I was not here, but in November of 2005, in the last days of the last Liberal government, there were changes to the criminal code which broadened the definition of child pornography, which included more offences out there, which was a good thing, and mandatory minimum sentences were introduced for this crime. That's 4 years ago. And he's been sitting in Parliament with me for 4 years when we've heard train after train of the crime agenda of the Conservative government come in and out of the station so often. Why is it, does he think, that they forgot this very important aspect? We know from cybertip.ca, and everybody in the House admits that because of the burgeoning distribution through the Internet, this is a very fast-growing crime. Why did the Conservatives wait 4 years to do something about it? Why haven't they moved the minimum mandatories, and they seem to love minimum mandatory sentences, from just to making pornography, minimum sentence 1 year, possessing pornography 45 days? Why haven't they attacked those in a bill like this rather than going after the Internet providers in a private out of the criminal code bill? And why did they keep the defense? There are defenses to making child pornography. Why did the Conservatives not take that out of the code?
The honourable member for Mississauga South.
Couldn't say it better, Madam Speaker. It's further evidence that I question why this bill and why now, why so weak. Is it just another facade? Is there any commitment to the issue of child protection? I mean, you can use all the words that you want to say, oh, we really care about that. But, Madam Speaker, I bet you I could pick a half dozen people out of this place, get together with a committee, look at best practices around the world, get the facts, hold some public hearings, and come up with a draft piece of legislation, Madam Speaker, draft legislation for the government to consider. I'd love that opportunity, Madam Speaker, because I think that members in this place who aren't muzzled and be forced to follow a linear thinking on criminal justice issues, members who are free to openly discuss and deal with these things, Madam Speaker, would come up with much better legislation. Thank you, Madam Speaker.
Questions and comments? The honourable member for Kamloops, Thompson, Caribou.
Thank you, Madam Speaker. And I've listened both to the speech and questions and answers, and you know, you talk about prevention at lengths, and prevention, of course, comes through your health transfers, your social services transfers, which, of course, we've increased every year compared to what the Liberals did when they were actually in power, because it's a provincial government that is doing a whole host of issues in that area. I have a number of things that I've done in my own riding where the federal government has funded in terms of prevention. We're not talking about prevention here. We know prevention's important. What we're talking about is protecting children, so we really need to focus on, instead of sort of ambling into many areas, this is an important bill, and if you could clearly talk about the importance of this bill to protecting children, I'd really appreciate it. Thank you.
The honourable member for Mississauga South has about 30 seconds to talk about the bill.
Madam Speaker, protecting children by fining someone who has pornography on their website that's available for distribution. The member's got to admit, $1,000 fine for a first offense is anemic. The member has to admit that this has nothing to do with protection. It has to do with punishment. And somehow the member thinks that this bill and its anemic response to the problem is going to reduce the incidence. It is not. That's the difference between the government's thinking on criminal justice issues. They think that there is going to be some sort of a prevention or deterrence. It just isn't the case.
Resuming debate, the honourable member for Elmwood Transcona.
Well, thank you, Madam Speaker, and I'm very pleased to speak to this bill today, Bill C-58. And it's our second day of debate, and I would expect that we'll be moving this bill to committee in very short order, because it seems to me that all of the parties are on side. There's certainly some criticisms as to the government's role and how they promulgated the legislation and how they presented the legislation to the House, because as a member for Mississauga South has just said that there's been no legislative summary, no briefing notes, no nothing. As a matter of fact, the first we heard of it was CTV News, 24-hour news coverage from Monday morning on, and we never got a copy of the bill until, I would think, yesterday. But nevertheless, it's a bill that's going to be supported and hopefully will be approved in committee. Certainly the government member, when the minister announced it yesterday, the minister said that the $42.1 million would be provided over 5 years to provide law enforcement more resources. So I asked her about that, because it seemed to me that that's got to be the focus. We have a very effective law enforcement system in this country, and as a matter of fact, the police tend to be the ones who do catch the guilty people up to this point anyway. And so our concern is that they do have proper resources, and so I really want to know, was this another $42 million on top of what they're already getting, or is this simply previously announced money that they were dealing with that she was not aware? As a member for Mississauga South said, you'd think that on a basic information piece like this, that they'd have those answers available. Best practices is another area that you should always look at when you're going to look at legislation, and I've made the argument that while the Conservatives claim to be tough on crime, we on this side of the House want to be smart on crime, and we're prepared, and we have examples where jurisdictions have used best practices and looked around the world and picked examples of where a certain action works, and simply adopted that, as opposed to the Conservatives who simply rely on old, outmoded crime initiatives from Ronald Reagan's days in California, which have proven not to work. So they seem to be still very ideological in their approach to government. I know that it's dissipating over time. They're moving slowly but surely to the middle, and I think we're going to see more of that over in the future. But what I wanted to do, Madam Speaker, is just to give a brief history of this problem, how it sort of developed as regards to dealing with the web. It wasn't until 1995, I guess, that email became prevalent. I mean, it had been used, in universities for a few years before that. but in fact email became prevalent right around 1995, and the web started after that. But at that point, most people still had, monochrome screens. Your frame rate was very low. It was, started at like 15 frames a second, and then they got it up to 30 frames a second. I recall the Rolling Stones, just about the time they were appearing in Winnipeg a number of years ago, the Rolling Stones claiming to be the very first rock band to put one of their shows, I think it was just one of their songs, on the web. And I looked at it, and it was very, very slow, people here will remember the webcams, when the first webcams came out, the frames where people were trying to talk to their relatives in other parts of the world, and the voice didn't match with the picture, and the picture was very choppy. And so there was a period there where this really wasn't a problem. In fact, bandwidth became a problem in the around the mid-90s, and once again, to make this system work successfully, they had to get faster speeds, and they had to have better bandwidth, and the ISPs had to do that in order to be able to transfer the material that we're talking about right now. But what has happened, and other speakers have alluded to this, is that we've had a virtual explosion of child pornography on the web just in the last 5 years. And once again, clearly, the horse is out of the barn. And as usual, the government is in a reactive position. The governments rarely lead. They're usually found to be following. And in Canada, over the last few years, we have had a lot of instability with a change of government, an election every 2 years, starting back from scratch again on legislation, and certainly a fairly substantial slowdown. It was mentioned yesterday that the development of peer-to-peer computing, that was a very big development that basically just sort of exploded overnight. And you all heard of Napster. It's out of business right now, but that was basically the beginning of peer-to-peer computing and making file sharing easy. So logically, when the technology developed the way it did and as fast as it did over time, it was just common sense that organized crime would be getting involved in the system, and the police forces are aware that it's not only child pornography, but also organized gambling rings set up their servers outside of your U.S. jurisdiction because they didn't want to be prosecuted and put in jail by the United States laws. So clearly laws have had some effect, and there was a Bloc member yesterday who was pointing to this bill, and it was touting the fact and saying, well, I think that these offenses are going to, slow these people down. But as mentioned by the member for Mississauga South today, and others, the fact of the matter is, and we'll go through the penalties later, but the fact of the matter is the penalties are not that large at all, considering the money that's involved. When you're dealing with organized crime and you're dealing with drug dealers, I mean, the fines of, $100,000 are probably just part of the cost of doing business for these people, right? So these are not particularly strong fines in any sense. And so that's what I think we have in here. We have the organized crime syndicates in here. And so a system of penalties, and fines and imprisonment and so on will, in fact, deter some people. It will deter some people for sure. But I think at the end of the day, because it's increasing, if, we pass this legislation and we find after a couple of years, hopefully we monitor its results, if we find that the that the legislation isn't working, that in fact the fines are not high enough, we'll have to increase them. If we find that the child pornography is still being produced at an increasing rate, then I think we are going to have to look at something, more drastic. And I certainly, have mentioned this, that I asked one of the members of the government today whether or not they had looked at, best practices in other jurisdictions, and the member said no, he wasn't aware that the government had looked at other jurisdictions at all. And yet, just yesterday, the member for Moncton Riverview Dieppe was very clear in his presentation on this bill when he pointed out that in fact there are other jurisdictions who have taken action that have dealt with the problem. And these are his words and his claims, and I would assume that he's correct in making these assessments. It should be easy to check. But for example, he'd mentioned, drawn our attention to Brazil, where he said that the ISPs in Brazil have to follow a very a set of ethical rules that govern what they accept on their sites. He mentioned Sweden, that in fact in Sweden they had a policy of blocking child porn. He mentioned Germany and the European Union as the best examples, and once again he said that in Germany they were blocking access to the sites. So, Madam Speaker, who are we trying to kid here? If the answer, and if it works in Germany, is to simply block the sites, then why are we getting ourselves tied up in knots here, spending huge amounts of money on police forces, $42 million over 5 years, and that's probably on top of what they're already spending, and they are doing great work, there's no doubt about it, to basically play a hide-and-seek game with these perpetrators over the internet. I mean, it would be just to me, would be a far more decisive, a far more effective, certainly cost-effective way of dealing with this would be to simply go and block the sites completely, and it's done. And I don't know what the rules are. I'm in Cuba, but I believe there is no internet porn there either. In other parts of the world, it's certainly technically possible. And I know the members, may not agree with that, and that's fine. But the fact of the matter is, I know that when the United States set up its penalties, what happened was that the people simply went offshore. To get around the American penalties, what happened is they simply moved to take the path of least resistance and move to a country that doesn't have, penalties and doesn't have these laws. Another member yesterday pointed out that Canada is very high up in terms of not only sales of child pornography, but also the production of it. So in this country, we are we're like number 2 or number 3 in not only the production, but the distribution and the selling and the possession of child porn. So it's certainly a major problem in this country, and it's certainly growing. And another fact to mention here is that certainly locally, computer repair depots have been reporting child pornography when they find it in laptops and computers brought in for repair. Recently, the customs people have been finding it on laptops. They're checking routinely for the last 3 or 4 years now at the airports, at the customs sites. They are checking there for, especially when people come from Thailand and places where there's a lot of sex tourism. They are checking the checking the computers, the laptops, of travelers. And so this is basically, I think, just probably providing a small dent into the to the problem. As a matter of fact, I think the stat that I picked up in the conversations over the last couple of days was that Canada was second in the world for hosting these sites. So, Madam Speaker, on September 2008, the federal, provincial, territorial ministers responsible for justice agreed that Canada's response to child pornography could be enhanced by federal legislation requiring any agency whose services could be used to facilitate the commission of online pornography offenses to report suspected material. And I know this was an initiative of the provinces, and I do give the provinces top marks, and I know that, you know, regardless of the stripe, I know yesterday we had the couple of Liberal speakers pontificating about how it was they who, you know, started the ball rolling in this whole area, and how the irresponsible Conservatives in government, you know, didn't do anything for 4 years, and you know, here we are today, and that's fine for, you know, parties to pick their own little victories here and there, and try to embarrass the other side. But the fact of the matter is that there has been activity. There's been activity at the federal level over the years. There's been activity too at the provincial level over the years. And in fact, my home province of Manitoba was certainly one of the three provinces that you know, has rules on this, that all people must report child pornography. I believe it's Manitoba, Nova Scotia, and Ontario who have laws in place right now. And certainly, what I wanted to say was Manitoba was an early mover in this area. Now, the Government of Canada has proposed legislation that would enhance Canada's capacity to better protect children against sexual exploitation by making it mandatory for those who supply an internet service to the public to report online child pornography. This legislation would help safeguard children by improving law enforcement's ability to detect offenses and reduce availability of child pornography on the internet. Now, when we get into the bill, we will see that, you know, it's a requirement, but they have no obligation to search for it. So it's if they happen to notice it, then they're under obligation to report it. And not only that, but there's a 21-day rule, I believe, in the bill too. That I don't know that is a long enough time frame. I'm looking at a lawyer here who probably could tell me whether that is or is not. But once again, when it goes to committee, the committee might look at making that a longer period of time, because 21 days might be too short a period. But under the proposed legislation, suppliers of internet services to the public would be required to report to a designated agency tips that they might receive regarding websites where child pornography may be available to the public. They are required to, Madam Speaker, notify police and safeguard evidence if they believe that a child pornography offense has been committed using an internet service that they provide. And by the way, I'm told that the ISPs, the well-known large ISPs, are fairly cooperative in this area. It's there's smaller ISPs around that are evidently less inclined to want to report, and so they're the ones that are going to have to be, given a little bit of extra attention. The legislation was carefully tailored to achieve its objectives while minimizing the impact on privacy, and of course that'll be an issue that we will want to deal with when we go to committee as well, because certainly members in our caucus are concerned about that aspect. Suppliers of internet services would not be required to send personal subscriber information under this statute, and that would be something that would be helpful as well. Now, failure to comply with the duties under the Act would constitute an offence punishable by graduated fines of up to $1,000 for the first offence. And, you know, the member from Mississauga South, among others, have taken exception to that as being too low. So once again, at committee, we might be looking at an improvement there, maybe a higher limit. $5,000 for second offence, and for subsequent offenses, the possibility of a fine up to $10,000 or 6 months imprisonment, or both for sole proprietorships. If it's a corporation, now, if it's a corporation, I would suspect that there probably is some sort of organized crime involved in it, but I may be wrong in that. But if it's a corporation that fails to comply with its duties under this Act, the graduated fine scheme would be up to $10,000, $50,000, and $100,000. And once again, I don't have a comment about that as to whether that is a high amount or a low amount, but it seems to me that would be awfully low too, because if it's a criminal organization producing the child pornography, you know, and it's making, you know, huge amount of money. I have no idea how much money they would make on something like this, but you know, $10,000 might be nothing more than the cost of doing business. So, Madam Speaker, once again, I am finding that I am short of time, and once again, only about halfway through. I'm used to those 40-minute speech slots that we had in Manitoba for many years, and once you get into the habit, it's hard to break it. As a matter of fact, in the House of Commons here, just 30 years ago, we had longer periods here too than the current. But mind you, I do like the current time allotments as well. So thank you very much, Madam Speaker.
Questions and comments? Questions and comments? The Honourable Member for Welland.
Thank you, Madam Speaker, and I thank my honourable colleague for his intervention in the bill today. And I think he's right when he said at the statement, when we think about the internet and pornography and child pornography, I think we all agree in this House that it's an odious thing that happens to young children, and we need to put a stop to it. But you know, as he's articulated, and I would like him to articulate a little further about, you know, how do we address the issue to make sure that it actually ends, that we actually protect our children, because that's in the end what we really want to do. And clearly, the bill is lacking in some areas where perhaps it needs to be stiffened and could be helped out. So it seems to me, you know, the honourable member can sort of started out to explain to us where there's some jurisdictions in the world where they're making progress on this very, you know, heinous crime that's perpetrated on our young.
Exactly.
And I was hopeful that perhaps he could take some more time, because I know he indicated that in other legislatures in this country you get a little more time. Perhaps he could now, through my questioning, take some more time to explain to us what other countries are doing and how effective they are in making sure that these crimes aren't perpetuated against children. Thank you, Madam Speaker.
The Honourable Member for Elmwood-Transcona.
Well, thank you, Madam Speaker, and I want to thank the member for that excellent question. And you know, I think that it does, from what I've been able to glean from the comments of pretty much all of the speakers on this side, you know, no one is super critical of this bill. I mean, we're all saying we're going to support it, but we just don't think that it really is tough enough to deal with the problem. And you know, it's like we've already gone for this. Probably would have been the measure to take back 5 or 6 years ago, when the problem wasn't as big as it is now. So I think that the member from Mississauga was right, that we should be looking at best case scenarios, best practices it's called, and the best practices that we find, and you know, there may be others, but we mentioned Sweden, that they simply block the porn sites there. In Brazil, they set up ethical rules. Now, if they don't want to follow Sweden's example and block them, then maybe look at Brazil, where the ISPs have an ethical rules set up, which somehow must restrict access to them, or in Germany, where we're told that's the best system, and where they block access to the sites completely. To me, that is going to grind it to a halt, at least as far as our jurisdiction is concerned. And I, you know, wasn't born yesterday. I know that the criminal elements will try to find a way around it, and maybe they'll move their servers to some other country, right? And then at a certain point, we'll have to chase down the perpetrators somewhere else. But the bill covers the whole range. It covers, you know, the production of, the possession of. So, you know, once again, I'm still saying we've got to have this bill. This bill is an important piece. The province has agreed to it. The province has wanted it. It's all part of a package. And I know the member for Mississauga South thinks that, oh, yeah, we should have a complete package and add even more things into it, even beyond the scope of the bill. I don't think we have to look at that right now. But in terms of this bill, I think the government should really seriously look at possibly other alternatives that they could throw into this as a package and move along together with this bill. Thank you very much.
Questions and comments? Questions and comments? The Honourable Member for Welland.
Thank you, Madam Speaker. And again, I thank my colleague for his articulation to my questions. And I know at the beginning of his speech he was talking about some of the questions he'd asked the minister on the other side around the resourcing and asked some other members around the sense of, you know, have they done this or have they done that when it comes to resource allocation, new monies, old monies, and couldn't get a response in the sense that they weren't sure. Which leaves one to question if the bill is so serious in the sense of the need for it, and I think we all agree, then one would think that they would want to actually resource it appropriately so indeed we can act on it. Not only just get this done, but can resource those law enforcement agencies who indeed, as my colleague pointed out, I mean, we can go after and get ethical rules around ISPs, perhaps follow the Brazil examples of where they do that or the German examples. And then what happens if there's a criminal element? We then need resources and a police function that will actually attack that. And what we've seen from some of the police agencies across this country, they've said we're underfunded, under-resourced, and we don't have the ability, we don't have the people because of the resource part of it to get the job done that we need to do to actually curtail this heinous sort of crime. Because all of us are in agreement in this House, it's heinous, and we need to stop it. So I asked my colleague, what does he think the government should do when it comes to resource in the sense of making sure that if it indeed slides towards the criminal element and away from the legitimate providers, that how will they be resourced and how should they be able to tackle that particular crime group that would want to do those sorts of things?
The Honourable Member for Elmwood Transcona.
Well, thank you, Madam Speaker, and I think that too is an excellent question, and I simply draw, back to the original speech by the minister in the House when she said that, $41.1 million over 5 years was being provided to law enforcement to give more resources. Now, I know that is something that we on this side of the House are particularly interested in, is properly resourcing the police force, because we know that the police are the people that are going to catch the problem, or that they're going to be the ones that deal with the problem. But I think that this bill was so hastily drawn together. I think the government just basically lurches back and forth like a ship in a sea here. They one day they're doing one thing, another day it's another thing. The bill starts being reported on CTV News on Monday morning. Every half hour it's being reported on, and the Parliament doesn't have a copy of it. We have no notes to go on. Then when the minister does make the statements, I ask her about the $41 million of resourcing for the police. She has no idea whether that's new money, whether that's old money, whether it's enough money, what it's going to do. I mean, surely you'd think they would have the members that are going to speak on the issue well briefed. They'd be given their notes. They'd be given, their answers to possible questions. And even today, when I asked the member for Leeds, I think it's Leeds Grenville, the question, and he made a very, very well-informed, very nice speech. I certainly give him that. But when I asked him for best practices, he couldn't tell me whether they'd even looked at any other best practices. And I know whenever you do legislation, I worked on Bill 31 in Manitoba, which at the time was the electronic commerce legislation, the most comprehensive of its kind in Canada at the time, about 10 years ago. And I know that what we did was we used the uniform law template to put this legislation together. You don't just make things up as you go along. There's always some sort of basis upon which you start when you're doing legislation. So we know they must have looked at other jurisdictions. I mean, I'd be shocked if they didn't. I'm just trying to ask them, who have they looked at? If they have looked at somebody, who have they looked at, and why did they reject? For example, Germany. If you looked at Germany, and you looked at the rules in Germany, then why did you decide to, not follow the German example? If you looked at Brazil, why did you decide that their system was not what you liked? If you looked at the Swedish example, why did you decide that their system was not what you wanted? Now, the member talked about organized crime. And, we tend to somehow think that the people that are involved in the child pornography are just, average people. And I'm sure there's, thousands of them that are. But I think that given the amount of money that's involved in this business, that there has to be the long tail of organized crime. And if we don't know that, we better start looking. And I think it's, I think if you talk to the police forces that deal with organized crime, they will tell you, certainly in my home city of Winnipeg, we know that we're constantly chasing, because that's where I want the focus of the criminal justice system to be on, is chasing the Mr. Bigs. We keep chasing the little guy at the bottom of the totem pole who gets nailed for a little bit of cocaine or distribution. But reality is the guys at the top are the ones that are making the big money. Those are the guys wearing the suits. And matter of fact, most of them don't even own motorcycles in Winnipeg, and they live in fancy houses in the suburbs. That's the kind of criminal that I want to see us focus on. And I think we're going to find some of them involved in this area as well.
Resuming a debate, the honourable member for Pickering Scarborough East.
Merci, Madame la Présidente.
Thank you very much, Madam Speaker. It is with some joy that I rise to speak to this bill that has been long awaited, that shows that this Parliament finally is going to assume its responsibilities with respect to the protection of children.
For myself as a member of Parliament. It's not a new issue for some of my colleagues who were here with me in 1999-2000 when a decision was made in British Columbia. Justice Duncan Shaw, with respect to the Sharp decision. That decision created, I think, a panic throughout Canada. The protections that had been passed by this Parliament in the past were now subject to judicial review, and many provisions meant to protect children were knocked out. Madam Speaker, it became very clear to parliamentarians and many of us who took these issues very seriously on a bipartisan basis, I might add, that what we were witnessing at the time was a lack of understanding and appreciation of those who are excited, those who will offend, and those who will continue to use any means that they have at their disposal, including technology, which I'll come to in just a moment, the purpose of which this bill has been created, to feed their addiction of exploitation of children. And it would appear at the time that there seemed to be a lot of misunderstanding, if not innocent ignorance, as to what was behind this. Many people thought this is a matter of expression, that you couldn't ban some of this information, particularly if it was written, because you might be analogous to banning the book Lolita. No one, of course, wanted to put those two imperatives of protection of children against the right of privacy, one against the other, and rather what we've seen, Madam Speaker, in the past 8 or 9 years is from parliamentarians, from Canadians, from psychiatrists, from our police forces, not only a coordination to our crowns and to our judges, a better understanding of the pernicious nature of child exploitation and child pornography. And I want to give a message here, Madam Speaker, of a much stronger Parliament. And I know that there's been some discussion about Canada where it falls short, but I can tell you, in my experience working with the Toronto Police Force, going back to 2001, and with the Ontario Provincial Police under Project P, and of course with the RCMP, I think today we are further ahead than we actually give ourselves credit for. And I'm not here to simply toot our horn, but we are teaching other countries how to coordinate and how to build capacity to combat child exploitation, particularly through cyberspace exploitation through the internet. And so part of what is being addressed here today is about obligations. Many colleagues have spoken, Madam Speaker, about how internet service providers are in fact responding to the call and in fact helping our law enforcement agencies trap and to monitor and to detect those who are engaging in the distribution of this information, which no doubt leads at the one end to exploitation, at the other end to dealing with providing people who need medical, if not other kind of interventions, the help that they need. And so, Madam Speaker, what we have before us today is a very, very important first step in terms of ensuring and compelling Internet service providers if necessary. Now, Madam Speaker, some of this didn't just happen in a vacuum. You'll recall in April of 2002, I convened a meeting in which about 40 or 50 colleagues from all parties joined in a film or a demonstration or a depiction of the seriousness of the problem. And I recall full well Paul Gillespie, who is now with the Kids Internet Safety Alliance, preeminent advocate, as well as Detective Sergeant Gary Ellis, who later became Inspector Gary Ellis before his retirement, coming before, along with Bob Matthews, Sergeant Bob Matthews from Project P, Roz Probert from Winnipeg, and others at a conference held very quickly by members of Parliament. And believe me, Madam Speaker, after that 30-minute presentation, we got it. Not only did we get it, but within about 2 months of that, our good and capable Parliamentary Secretary at the time, Paul Macklin, former member for Northumberland, was able to convince the government to provide the first initial fund and the first tranche of some $50 million to create a cyberspace network to help and facilitate so that in smaller communities across Canada, police could get the kind of training that they needed to detect, to share, and of course to arrest the behavior. And so we've done a lot over a period of time, Madam Speaker, dealing with Internet service providers. We've also encountered some very unsavory examples of where there has been reluctance by carriers not to provide information for whatever reason, that they might cite privacy, cost, etc. We've come around some of those. But I suspect the biggest stumbling block that we faced then and we continue to face today is that when a police officer is confronted with all of these images, perhaps in the thousands at any given time, and a charge is brought against this individual, in order for the process of the charge to be laid and to be heard in a court, you have to have the evidence sworn through each and every image. Because of a decision, the Stinchcombe versus the Queen case, it makes the job of our police force practically impossible. And so we are at a stage now, I think, Madam Speaker, where while there's better understanding of how to help police do a better job, we need to do more, and certainly this bill goes in that direction. But I want to talk about something I think is far more important to where we're going. When the Minister was asked by several reporters that once the domain is identified of someone distributing child pornography, the URL, the question is, what are they doing with it? We have no way of breaking down or knowing how to combat, how to address this issue. It's great you have a database and you're able to provide and get this information. Can we go after each and every one? I'm not sure, Madam Speaker. I think we need to look at whether or not we do have, in fact, in this country, the ability, the resources to be able to tackle the numbers, the great numbers that we're seeing out there. This leads me to a bigger point, which I hope the committee is going to be able to address. And I would ask the colleagues, the indulgence of all colleagues in the House, to understand that more than just Internet service providers and people downloading information, it is really the peer-to-peer expression or the peer-to-peer sharing of files that is the most pernicious part of this. And I'm not sure the legislation is going to be able to cover this, let alone get our minds around the more modern way of distributing this information, which is undermining the integrity of young children and destroying their futures. It seems to me, Madam Speaker, that short of going to the Orwellian perspective of big government watching everything you're doing, we have to come up with a better solution, not just for Canada, but around the world. I salute those many organizations in our RCMP and the Toronto Police Force, of course the OPP in my province, who have been doing yeoman's work training the rest of the world. But I think we have to begin to look more fundamentally, more specifically, at the underlying new way in which information is being shared file to file. And how you get around that is going to require a little bit of dexterity to look at these networks. We're going to have to find ways to train them. We're going to have the best practices, but we're also going to have to avail ourselves of the greatest technology that's out there. And yes, there are going to be questions that are going to be raised about privacy. But if I were to suggest to you, as the RCMP has done in the past, that the number of people who may be sharing this information is not 65,000. There was some information a little while ago from the RCMP that there may be as many as 65,000 people in this country who are in receipt of this information, who share this information. That number could easily exceed 1 million. And I'm not one to giving himself to the notion of throwing numbers around, Madam Speaker, but I think the committee looking into this piece of legislation is going to have to know and be comfortable at knowing the size, the dimension, and the seriousness of this issue, and that while we have a number of solutions, it's no point in talking about solutions if you don't have a better understanding of the problem. And so I encourage colleagues, as we are looking not only at trying to provide best practices and building capacity in other countries and recognizing the mandate that Parliament, we're prepared to give, I hope, a very strong and important blank check to our legislators, to our, not our legislators, but our law enforcement officials, to those on the front end, the smart people, those who understand how the Internet works. We need a forum and a focus to match what the private sector is doing. I think of the Kids Internet Safety Alliance, who's going it alone. They don't have support from the government. We have nice words coming from the government about how they're going to do this and they're going to set up a facility here and there, but frankly, this is taking off. Canadians understand this. Agencies that are involved in goodwill recognize the ability for us to use our collective strengths, the brains that we have out there, the technological wherewithal to be able to understand the complexities by which child pornographers are trying to hide and disguise their craft and their evil. And so I'm suggesting to all of you here as members and colleagues, this is an issue that each and every one of us can talk about. But I think we do ourselves a service as members of Parliament if we actually anticipate the road ahead, not just for the purpose of protecting our children, but to be able to help other countries that do not have the capacity, the technological capacity, yet alone the resources. On the road of goodwill here, we've lost a few things along the way, and that's, frankly, we're going down a road and we don't know where this is taking us. But I think it's very clear to us that if we are not prepared to recognize that this bill, several years late, and I won't get into the politics of it, is really to address an issue that took place some time ago. The next big challenge for this Parliament will be to deal with new technologies in the digital age that are being used to circumvent and to get ahead and to continue exploitation. And Canada does not play a minor role in this regard. We have heard stats provided by a number of colleagues in the House of Commons as to the number of Canadians who may be involved with this, where we are in terms of protection of children. The statistics look on the surface grim, but there is no doubt that there is a will within this Parliament, and I think there are other very good statistics that demonstrate that our frontline men and women, psychiatrists, police officers, those in the judicial system who are doing yeoman's work and are trying to find what is the best way in which to approach this ever-changing challenge. Someone said to me it's a little bit like trying to tack Jell-O onto a wall, but the frank reality is that we have to continue in this country to be aware of where the emerging problems lie in order to provide the kind of solutions I think that we owe to our to the next generation. Madam Speaker, behind the technology are broken individuals who exploit. These are individuals who, short of legislation, also need therapy. These are people who cannot help themselves. These are individuals who need the state, they need society, they need rehabilitation. We can talk about penalties, but we also have to talk about prevention, as my good colleague from Mississauga South alluded to a little earlier. And I can't think of a better example of where we've got to get it right to the benefit of all the children out there who might otherwise be exploited. And these are not comments that we simply take as members of Parliament wanting to do good. We recognize in this country and around the world that the issue of child exploitation is a greater threat than perhaps most against the next generation. We have to marshal the collective forces in this country and around the world to work cooperatively. And I don't see that in this bill. I see that we're going to do our own job from the ISP's perspective. And that's only ISPs, by I should point out, who exist within Canada, because we have no international reach. But I'm suggesting that that is, in fact, the way we ought to go. And I want to point out something that, Madam Speaker, if you'll allow me, that we did say in 2002 with a number of colleagues present. I recall the one colleague who was also very big on this, I miss him a lot, Myron Thompson, the member for Wildrose, who, with myself, made it abundantly clear that on both sides of the House we would work very hard to see that this legislation would someday be a reality. And though he's not here today, I'm sure he's very pleased to see that we've moved down this road. But in, Madam Speaker, in 2001, and to be specific, in 2002 rather, we suggested that there ought to be some changes on retention of information by Internet service providers. And I'm going to read to you what all colleagues at the time, or your predecessors, would have known and were participating in. Legislation required, or an amendment to the existing legislation at the time was Section Bill C-15, concerning the retention of client information records by Internet service providers. ISPs must be able to furnish police with data, records on suspected child pornographers. We also urged at the time to make it mandatory for ISPs to keep client logs for at least 1 year, following the U.S. model in subjecting ISP to substantial fines for non-compliance. And those were some of the ideas that flowed from a very quick meeting that members of Parliament had. And there's no doubt that the train is, in fact, or the intention of this Parliament has been focused on that ever since. And yes, there's been several elections in between, but thank heavens that we continued in this belief that we can continue to stand up for those who have no voice and who would otherwise see their lives destroyed by those who truly need our help. Madam Speaker, I am also convinced that the proliferation, the sophistication, the pervasiveness of technology. I just had my BlackBerry here a few minutes ago. When I was elected as a member of Parliament in 1993, such devices didn't exist. The ability to communicate good and bad is ever present, and as I suggested earlier, pervasive. This requires parliamentarians, I think, of all parties, to stand up and to recognize that the changes that are taking place are not challenges that we cannot overcome, particularly if they're used for nefarious and heinous ends, such as exploiting children, not just in Canada but around the world. We have an obligation to listen to those who can point and demonstrate a better way. There's only so much bandwidth in this world. Here in Canada, as an example, I won't go down the issue of telecommunications. I'll leave that for a consumer story at some point down the road. But I think we have the ability to know and to monitor the traffic that's out there. And we cannot be seen as intrusive, but on the other hand, we have to be ever vigilant. If we know something is taking place and it's being done by certain modalities, from file sharing, from network to network, from computer to computer, I think the government has an obligation to look and to test judicial, perhaps chill, or Cartesian charter chill, with a view to saying what must be done here is in the higher and best interests of Canadian citizens. It's not good enough to say, well, we'll adopt from other countries best practices, or that we're going to look around the world and vicariously get some form of child protection in Canada. We've got to be at the table. We've got to recognize the changes that are taking place. And I'm afraid in none of the speeches that I've heard today have we been focused on the next concern, which is, in fact, the existing means by which child pornographers are disseminating their material. And I'm asking parliamentarians, as they go through the committee process and as they ponder and consider this, to become a little bit more focused on what I think are some pretty obvious challenges to us, but I think that they can overcome.
I would like to take a few moments as well to salute the former parliamentarians who helped us in this area and the decisions made by the Liberal government. I was proud to be there to see these changes, as well as the amount of money that was injected into supporting the police officers and the Crown, so that people are not only aware of the problem, but also able to continue to train those responsible so that other police officers around the world would have the information they needed. Last month, I was in Durham at a conference at the University of Technology, or the Institute of Technology. And yes, I understand, Madam Speaker. I just have a minute or so left. We had representatives from the police authorities in Indonesia, Brazil, and elsewhere. Other countries know how to do certain things, and we have practices here that are the envy of the world. We are trying to continually improve them.
To believe that on committee that you will bring forth the experts that I'm referring to, the psychiatrists, those who understand technology, the software program writers, those who know how the exploitation, the devices used to exploit are being used against us and against the next generation. These are the people we should be hearing from. If you really, Madam Speaker, all of us, want to protect and stand up for the next generation, for posterity, I suggest we get with the program, we understand the technology, bring in the bright lights, and Madam Speaker, we will guarantee to the next generation a much safer future, and at the same time remain and keep Canada where it ought to be, defending the interests of those who have no voice. Merci, Madame la Présidente.
Questions and comments? The honourable member for Saskatoon.
Thank you, Madam Speaker. I appreciate that. I appreciate the good work that the member opposite has done over the years, too. I know he has put a lot of time and effort into this. He's had hosted various seminars on the Hill here, which we have members that were around in those days definitely benefited from in terms of the specific help, the specific expose, if you will, that the police gave in those occasions. I would ask the member opposite, because I know he's mentioned the very important need of monitoring, keeping on top of this, the ever-changing technology. We need to be vigilant so that we can truly protect our children, the vulnerable, innocent children of the future, the present and the future, against these heinous crimes against these most innocent, vulnerable children. And so, having said that, I would be interested to know if at this juncture, though, he has, were it in a private member's bill, were it even maybe some very specific amendments for that committee, what might be the major outlines going ahead from here, acknowledging, as you did, the good benefit of this particular government bill, but what might be the major outlines of a bill that you would do to even improve upon this, or that you might see into the future in terms of things that we could yet further do to get at and stomp out this very pernicious evil that we have in society today?
The honourable member for Pickering-Scarborough East.
Madam Speaker, I want to thank the member for Saskatoon. Wetaskiwin. No, is that Wetaskiwin? Wanaskewin. Thank you, Madam Speaker. Sorry. I know the honourable member was there back in 2001, 2002, so I know that it's a reflection of the genuine belief that we can do better. Madam Speaker, I think that we should be looking at a full-time committee, blue ribbon panel, that would be reporting to the Minister of Justice, but more importantly to Parliament, as to the evolution of best practices. It should be something that provides an annual report on the state of cyber crime in Canada, and a state on the level of exploitation in this country. And, Madam Speaker, it shouldn't be used to panic people, but to actually give some focus and perspective. I think this kind of commissioning of information, and some of it is done through the Victims of Crime organizations that are there, but I think to put this in proper perspective, RCMP, a number of agencies involved with child exploitation nationally, internationally, domestically, who hold conferences, could also perhaps bring in the efforts of what is being done internationally, relate them to whether Canada is a hindrance or whether it is in fact part of the solution. But I think we need annual reports, updates. It seems to me that by the time we get through elections and parliaments get around to doing good work, often those who exploit children have moved on. We need to continue to have a rapporteur, if I can use, for lack of a better term, to Parliament each and every year that will bring an update on the best practices and, most importantly, what we're doing and what we're not doing to make it better. I appreciate the honourable member's suggestions, because I think that's an area the committee should look forward, saying, yeah, we got a bill, that's great, it deals with a problem today or perhaps over the past few years, but we need to look ahead. Thank you, Madam.
Questions et commentaires. L'honorable.
Questions and comments. The honourable member for Elmwood Transcona.
Well, thank you, Madam Speaker, and I want to thank the member for Pickering-Scarborough East. I remember him way back. He said he was elected in 1993, but I used to be the consumer critic for gas prices, among other things, in Manitoba. And I used to marvel at him on the radio. I'd listen to him quite often, actually, and because he was a very knowledgeable guy. In this particular bill, I'd like to ask him. I noticed that the definition is more than just ISPs. It also includes those who provide electronic mail services, internet content hosting services, and social networking sites. And I want to ask him whether he thought that was the all-encompassing, all-inclusive group, because I'm not up on all these issues as much as I used to be. And second of all, I'd like to ask him about peer-to-peer. Now, peer-to-peer came in really big time with Napster, and peer-to-peer is still around, but you seem to think that that is the most difficult area to work with, and I'd just like you to take some time and explain to us why you think peer-to-peer is the biggest problem here.
The honourable member for Pickering Scarborough.
Those are excellent questions, Madam Presidente, and I'm very happy to answer at least some of them to the best of my knowledge. A cursory discussion with those on the front line will tell you that the peer-to-peer is in fact the way is de rigueur. It is the new means by which file sharing and downloading is now occurring. And yes, it does require you work through the networks, but that seems to be the favored way of doing things. When police attempt to try to break a cyber network, what they're actually finding is a lot of mirrors and a lot of sites that come up and exist for 3 hours and then move on to another. So it's like a very elusive game. Does this legislation cover this? Yes and no. It talks about things in generalities, but doesn't get to the specifics that my colleague from the member from Moncton and I discussed over the past few days. It does not actually get into where I think many of those who are on the front line are actually pointing to as being an area that we need to actually mention, to focus on. The honourable member talks about Kazaa and Napster and other things, and of course there have been ways in which they've regulated those. I don't want to get into the issue of music or content, but rather to deal with where is the infrastructure that is being used to deliver this information. It makes the job of trying to cover so many angles that much more difficult. And so I want to focus on this. Madam Speaker, as you know, ISPs aren't just the hosts and whatnot, those who host websites. You think, for instance, of Google, and others also have, and I'm thinking, of course, of URLs that you'll use with any one of Hotmails. All of these are now caught by this legislation. But I really, really want to have our committee members on that committee focusing on where the problem exists as it stands today. I don't think this is hot off the press, but I also think that we have to be purposeful. We should be asking what we're doing with the information, too. It's good enough to say, yeah, we're going after ISPs, URLs, we get the domain names, we find out how are you prosecuting them. And I don't think that question's been answered, and I think it's important that we look at that as well.
Here, here.
Comments of the honourable member for Moncton Riverview, Dieppe.
I want to thank my friend to get right to a question involving the criminal code. This act is outside of the criminal code. But, Madam Speaker, the criminal code in section 163.1 makes it an offense for any person who accesses child pornography. How is it different, and why is it a lesser offense that the people who allow and set up the system and don't report the fact that child pornography exists is somehow less than someone who accesses it? I want to know if he thinks that's proper. Does he also think in the criminal code, in Part 5, when there's a hierarchy of offenses, sexual offenses, public morals, and disorderly conduct, why is it that the government is leaving these offenses in the realm of public morals and not sexual offenses? Because at root, Madam Speaker, these images are evidence of criminal sex abuse or rapes. The images reflect a crime. And those images, therefore, should be in a higher section of retribution for us to say that we feel is not a proper conduct in this realm. So why isn't the criminal code used? Does he endorse using the criminal code?
The honourable member for Pickering Scarborough East.
Absolutely, Madam Speaker, and I agree wholeheartedly with the member from Moncton Riverview, Dieppe. I also think that there is a question of, which he's raised, which I had not considered up to this point, the question of hierarchy of harms. I think we all agree that there is child exploitation. It is the destruction of human life. whether we like it or not. And if the criminal code is not able to reflect that, or this legislation is not consistent with the opprobrium, I think, that Parliament and the criminal code holds against those who exploit children, then that also would have to be, I would propose, a decent recommendation or amendment that the party should, as on behalf of our critic, propose at committee. But I am not on the committee. I'm simply trying to provide some guidance with the latest of information that I think parliamentarians who are going to be looking at this from all parties are going to have to look at more intensely. I say these things because I think it's anticipating where we ought to be, and it'll put Canada back where it must be. And I think, yes, internet service providers have been helpful, some have not. Some have charged, some have obstructed, some continue to use issues of privacy, I think, indiscreetly. But I agree with my colleague that optimal legislation would also include the ability to have a reasonable expectation of conviction, a reasonable expectation of stopping the practice in Canada, and as well encouraging through this legislation. What I think is the maximum of and the importance of this legislation is to help give enforcement agencies the resources that they need. And if we have agencies in this country, Madam Speaker, who are creating true centres of cybercrime, who are in fact protecting Canadians and the international community, we ought to be backing them with resources by Parliament, not leaving it to the private sector to shamefully do what we as parliamentarians want our government to do.
Resuming debate, the honourable member for Sackville Eastern Shores.
Well, thank you very much, Madam Speaker, and I'm proud to rise to debate on an issue that is extremely imperative to anyone who's a parent, Madam Speaker. Madam Speaker, child pornography has been with us in many forms for many, many years. But on the Internet, it's extremely despicable because a lot of it goes underground, Madam Speaker. And first of all, I want to congratulate my former colleague, a long-term member of Parliament here, the former Attorney General of Saskatchewan, Mr. Chris Axworthy. Mr. Axworthy introduced a child Internet pornography bill that was supported by many police organizations across the country in early 94-95. And, Madam Speaker, when he left the House of Commons, I resumed that bill, and I've re-entered it on 4 separate occasions. And every time I've done, I've handed the bill over to the current Justice Minister and the former Justice Ministers to get them to do something about the scourge of child pornography on the Internet. And I'm pleased to see today that the Conservatives, under their Justice Minister, has tabled a bill that mentions child pornography and what may or cannot be done. But, Madam Speaker, we have to make sure that it's simply not window dressing. It just can't be for political optics that we say we're going to do something about Internet pornography and then don't give the people who look at this, who operate under these confines, the resources and human material to be able to do it, Madam Speaker. Madam Speaker, I want to tell the House an event that happened a few years ago when we were presented by the Ontario Provincial Police, and there was a particular officer whose job is it, for the 8 hours a day that he works, to snuff out child pornography on the Internet, to find out these the scourge of our society and bring them to justice. Well, Madam Speaker, for over 3 hours he explained how quickly young children can be trapped on the Internet to these professional lures, is really who they are, and be able to entice these young children into acts that are beyond their comprehension. And, Madam Speaker, at the end of that conversation, and basically he said what he does is he poses as a father that has an 8-year-old child, and they're both willing to swing in this regard. And what they do is they put that out on the Internet, and they try to get people to see if they'll latch onto it. Well, in the 3 hours he was there, Madam Speaker, he put that on the Internet, and by the time he was finished, he had over 50 hits, 20 of them from Ontario alone. So that meant, Madam Speaker, that in those 3 hours there were 50 people out there wanting to partake in this type of activity. Now, I don't know how sick we've become as a society, Madam Speaker, but the reality is something needs to be done and needs to be done quickly. We've got the bill that we've had in the House for many, many years through the NDP, and we've given it to the Justice Minister. We ask him and his department to carefully look at it, to see what parts they want to take out of it and use it for their own. But, Madam Speaker, nothing will come about this if the government doesn't put the financial and human resources to allow our police forces, the RCMP, the OPP, the Sûreté de Québec, and municipal and regional police forces across the country, Madam Speaker, the tools with the technology to be able to do their job effectively, which is the end goal, Madam Speaker, which is to protect our children. Now, Madam Speaker, child abuse and child pornography, as I said earlier, has been with us for an awfully long time. We heard the issue of the Christian Brothers in Newfoundland. We had the residential school abuse. And, Madam Speaker, I just cannot imagine what it would have been like to have been ripped out of your community, out of your parents' arms, put into a residential school, and then abused for many, many years. And, Madam Speaker, I'm glad to see that there's a Truth and Reconciliation Commission coming forward in order to help those First Nations, Inuit, and Métis people deal with what happened at that time. And I only pray to God, Madam Speaker, that they find some solace and peace when they're able to get their stories out. But, Madam Speaker, on the Internet, and it's rather quite ironic that a guy like myself would stand up and talk about the Internet because I don't use a computer. I don't have a BlackBerry, and if I was responding to the member from Pickering, I'd still wish that BlackBerries were banned, Madam Speaker, because I find them a sort of lazy way to communicate. But the reality is the Internet, Madam Speaker, can be a wonderful tool for information. But it also can be a very, very dangerous place, Madam Speaker, for unsuspecting individuals. And, Madam Speaker, what we need to do at the end of the day is make the ISP providers, large and small, partially responsible for assisting and monitoring their sites. And I don't mean to say to them that you have to do it all on your own. This is where the federal government has to take proactive action and make sure that they themselves get the additional resources so that they indeed, Madam Speaker, can monitor their sites and with judicial oversight, Madam Speaker, so that we can protect the privacy of all individuals and make sure that they have legal rights to ensure that if the ISP provider suspects something's happening, to be able to forward that information on over to the police. And that, Madam Speaker, is the nub of what we should be doing. Because, Madam Speaker, as a father of 2 young girls, and I know many of us here are parents, it would be just a horrendous, horrendous feeling to know that possibly your child was sexually abused because of something on the Internet. And, Madam Speaker, I do not understand for the life of me. I've tried to understand, I've tried to comprehend the thinking of an adult individual who thinks that it's pleasurable to have sex with infants or very young children. I just do not understand that type of thinking, Madam Speaker. I don't know if there's any type of rehabilitation that could happen to those types of individuals, Madam Speaker. But what's most important, and we're pleased that the government has recognized this as a scourge in our society. And I remind everyone, Madam Speaker, that the #1 goal of any government is the protection and security of its citizens, including those that are most vulnerable, our children. And, Madam Speaker, we will work with this government through the committee process. I know my colleague, the Justice Critic from the NDP from Windsor-Tecumseh, is one of the most knowledgeable people in the country and in this House when it comes to justice issues, and I'm sure he will be offering recommendations and amendments to make the bill even stronger, Madam Speaker, so that at the end of the day, what the government purports to do, which is to rid ourselves, or at least as best as possible, eliminate child pornography on the Internet, we will ensure that the Justice Minister gets the help that he needs on that. But, most importantly, the Justice Minister then, in turn, has to provide those financial and human resources to all those police agencies across the country that need the technology, they need the human element, and they also need the financial commitment to ensure that they have the tools to do the very, very really dirty job that we ask them to do, which is to protect our children from child pornographers. And, Madam Speaker, if we do that, we'll not only compliment the Minister, but we'll compliment this House. And at the end of the day, Madam Speaker, maybe one less child will be subjected to child pornographers on the Internet. Thank you very much, Madam Speaker.
Questions and comments? Questions and comments? Resuming debate, the Honourable Member for Windsor-Tecumseh.
Thank you, Madam Speaker. Madam Speaker, I rise to speak to Bill C-58 today with, I guess, with mixed emotions. We've been dealing with this issue in the Justice Committee since 2006, late 2006, early 2007. So better than 3 years now. And actually had some consideration of it in the 2004-2006 Parliament as well, so going on 5 years. And Madam Speaker, one of the concerns I have, and that's why I say I rise with mixed emotions, is we are supportive of this legislation as far as it goes. And that's really, I think, our major concern with C-58 is that there are a number of other issues that should have been addressed excuse me, should have been addressed long before this, and some of them have now been addressed in this bill, but there's a number that have not been addressed. And addressing those issues, building a framework so that our police, prosecutors, and judges would have greater ability to try to stamp out child porn on the internet and the technological transmission of it would be a really major step forward. And we haven't gone far enough on this, and I'm going to address at least some of those points. But I do want to set this in its historical context, that when we were dealing with the legislation that really dealt with luring of children over the internet, what came forward at that time was a good deal of evidence from various police forces, particularly from the Ontario Provincial Police and the City of Toronto police force, who were probably, and I don't want to disparage other forces, but were probably at that period of time the most advanced forces in trying to combat child porn on the internet. And what came forward at that time, and I'm now talking 3 to 5 years ago, was the problem we're now addressing of how do we deal, and I'd have to say, Madam Speaker, we're addressing to some lesser degree in the bills that are before the Public Safety Committee now, C-46 and C-47. But being able to get at the service providers who are the mechanisms, the methodology by which the producers and the traders in child porn, it's their mechanisms, their technology that they're using to trade and sell, in most cases, this child porn. What came out in the course of those hearings was that there were a number of the service providers who were refusing to cooperate with police forces, both here in Canada and internationally. And I think as a result of a number of fairly strong comments that came from members of that committee at that period of time that we had to deal with this, we've seen an increase in the cooperation from the service providers in terms of giving police officers information, putting them on notice when they identify child porn on their service technology, and cooperating as fully as they can with the police. That's not universally true to this date, and that is why we're seeing this legislation. We really should have seen this legislation at least 3 years ago, because it was very clear at that point that we had a problem. And it was only, I think, because of some of the threats that came out of that committee, the Justice Committee at that time, that we got greater cooperation from the service providers here in Canada. It is still, Madam Speaker, a major problem when we try to deal internationally. There are certain countries who, again, are very cooperative with us, are actively engaged in trying to shut these sites down and to prosecute those who they can trace the child pornography back to. But there's other countries in the world who have no mechanisms at all to deal with this. Madam Speaker, in that regard, I think it's worthwhile noting the assistance we got from Bill Gates and Microsoft, that they assisted the police forces in developing a technology at quite a substantial expense to that corporation, in the range of about $10 million in human resources to develop the technology and actual expenditure of funds to produce it. Madam Speaker, it's important to note this, both with regards to this bill and just generally of how the child pornographers work. And what they do, Madam Speaker, is they put the information on one service provider and then skip it through a number of service providers. We've been told as many, in some cases, this material will go through up to as many as 50 service providers around the globe. And this technology that was developed by Microsoft through Mr. Gates' initiative I should say the Toronto Police Force initiative, but with which he funded, they've been now able to develop this technology that we are generally able to trace it back to the source. So we may skip through a whole bunch of service providers, but we eventually can get back to the source and get the site shut down. And also, on some occasions, and we've seen that, there's been at least several major busts in Canada as a result of this technology being deployed. A number of people charged and in some cases convicted. Now others, the cases are still working their way through the courts. But that technology was crucial, and it was the first time it was developed in the world. And we've now been sharing that technology with other countries with whom we're cooperating for them to be able to use it to track back the child pornographers. That was a major step forward, Madam Speaker. But it was interesting to see, Madam Speaker, in the media this week that some of the other technology that we've been working on in terms of registering sites has not been developed. We had a 5-year program that I think was initiated in the 2004-2006 Parliament, so it's close to being ended. And this really is where people identify the site, they advise the police, and then we have a registry of that. That registry is still not up and running because of technological problems. According to the article in the Chronicle Herald of the 25th, so yesterday, as much as 40% of the budget that was allocated over that 5-year period has not been spent because we don't have enough police officers actually working on this, and we have not seemed to have been able to put enough resources into fully developing that technology. And as I say, that 5-year period is just about up. I have no idea what the government's going to be doing in terms of continuing that funding on until the service is up and running effectively. It's quite clear from the article as well that more police officers should have been specifically designated, trained, and designated to work in this area, and that hasn't happened. And Madam Speaker, with regards to the bill itself, it's one of the concerns that I've got. It's typical with the government. They're out front. They sort of promulgate that this is the be-all and the end-all. I'm being a bit too harsh on them, I'll admit that. But the reality is that the real work that needs to be done here by governments is to fund our police force. There are very few large police forces in this country now who don't have at least 1 or 2 police officers specifically designated to deal with child pornography, mostly on the internet, but in print as well. Madam Speaker, we need more of those officers. We need a lot more of those officers in order to be able to deal with this problem. This is a growth industry. It continues to grow. It's because of the internet. We've always had child pornography in print and even in paintings. We can go back hundreds and hundreds of years, maybe even millenniums. The explosion occurred with the internet because what it provided for was easy transmission of this pornography and tapping into a substantial market that was unavailable before. Crossing international boundaries, very difficult for national police forces to be able to deal with it. There has not been, and I have to say this not just about this government, previous government, Liberal government, but also in a lot of other countries. There are very few countries we can point to, England may be one of the exceptions, who have in fact dealt with this problem in an efficient manner, that is moving enough resources, human resources, into combating this. And we know, Madam Speaker, both the province of Manitoba was one of the provinces here that moved on this in terms of a snitch line. England has done the same thing and funded it. Seems to be fairly effective in getting the public, who when they're scanning various websites and identify child pornography, a very effective way that they can get that information to the police, and the police then can deal with it in an efficient and rapid fashion, to shut the sites down and to try to track the producers of the sites. So it's working in that regard in terms of we've got a methodology. We don't have enough resources. And it's really a shame that we are still struggling with that, as our police forces are, because they have nowhere near the capacity to combat just the sheer volume of what they're having to deal with on the internet. And in that respect, I urge the government in this coming budget to take another look at this area in particular. And if we're really serious about protecting our children, we need to put more resources into it. This legislation will help a little. I don't want to downplay that completely or deny it completely, but it is a very small step by comparison with how much more effective we would be in combating this scourge if we had more police officers working on it and also developing technology. The police officers need training, and they need companies like Microsoft to come into the field to cooperate with them to try to develop better technology to track this right back to its source. That's the only way we can effectively shut it down. Madam Speaker, with regards to the bill itself, I do have some concerns. There was a lot of debate before this bill got to the House over whether the service providers would have a legislatively mandated responsibility to monitor their sites. We did take back to that bill that on child luring, internet luring, we took some evidence that it was going to be difficult for the smaller service providers to be able to do that. On the other hand, Madam Speaker, it may quite frankly be possible to develop technology so that the computer will be doing the monitoring. There are any number of other technologies where we use on the computers services that can do the search on a random basis. That technology needs to be developed and deployed. If that was the case, and maybe that's something we have to impose on the industry, but in any event, Madam Speaker, we just gave up. This bill does nothing to require the service providers to do any monitoring at all. All they're required to do by the bill is if somebody tells them that they've got a site on their service provider technology, they have to report that to the locator and to a police force. They are under no affirmative obligation to monitor their websites that are on their technology. Madam Speaker, I think that was just too much of a back down by the government. At the very least, we should be looking at imposing some responsibility on them. And I'm hoping that it appears quite obviously this bill is going to go to committee, that at committee we can look at this again and perhaps strengthen the bill in a meaningful way to impose some responsibility. The other problem I've got, and I see my time is just about to run out for the statements and question period, but Madam Speaker, I want to make this point about the penalties that are in the bill. The penalties assume that the service providers are all corporate, so we only have fines in the bill. And Madam Speaker, I think we need to take a look at that and see if we shouldn't be pulling back the corporate veil where we have been able to identify, and I know this test won't be easy from a legal standpoint, but when we've been able to identify service providers who are abusing their responsibility to protect children, that we should be pulling back the corporate veil, and there should be the ability for police and prosecutors to prosecute as a crime individual members of whether it's the executive or the board of directors of those companies. Because I think we've been able to identify that there are in some cases where it's quite clear that we knew, the corporate entity knew about the sites and did nothing about it, just allowed them to continue on. And I think if we have that kind of a scenario, that kind of a series of conduct, then we in fact should be going after individuals, not just the corporate. I think my time is waning. I'll continue my speech after question period. Thank you, Madam Speaker.
The honourable member will have about 5.5 minutes with his plus questions and comments. Statements by members. The honourable member for McLeod.
Thank you, Madam Speaker. Some Canadians voluntarily put their lives on the line to help others. They are our volunteer firefighters. Cities and towns across Canada have volunteer firefighters who, when the call comes for help, they answer. They answer these calls while they're at their regular jobs, spending time with their family and friends, or in the middle of the night. They use their training, done on their own time, with equipment they've helped fundraise for to save lives and property. This happens while their families wait at home hoping for their safe return. These dedicated volunteers do all this and much more to make our communities safer. This was highlighted by a fatal car crash in my riding last weekend that claimed the lives of 4 young women. Our thoughts and prayers are with their families. First on the scene were our volunteer firefighters who helped save the life of the sole survivor of the head-on collision, a 6-month-old baby girl. Their brave response to such a terrible tragedy is to be commended, and we remind them that all our efforts are not in vain. Thank you.
The Honourable Member for Etobicoke Centre.
The Holodomor, the Kremlin-engineered famine genocide in Ukraine of 1932-33. Zina, a village girl, wrote to her city-dwelling uncle, "We have neither bread nor anything else to eat. Dad is completely exhausted from hunger, unable to get to his feet. Mother is blind from the hunger. Uncle, please do take me, please. I'm still young, and I want so much to live a while. Here, I will surely die, for everyone else is dying." When the uncle received the letter, he was told of her death. 100 by 100, 1,000 by 1,000, million upon million lay down their starved skin and bone bodies and became one with Ukraine's fertile black soils, life extinguished. On November 28th, we memorialize the Holodomor. All our resolutions, our statements of responsibility to protect are nothing more than fine-sounding rhetoric unless each of us makes a pledge of responsibility to intervene, to act when genocidal crimes occur. Mr. Speaker, Bish Nikole, never again.
The Honourable Member for Rimouski-Neigette-Témiscouata-les-Basques. Madam Speaker, thanks to the effort that has been made in the agricultural and forestry sectors, I can say with pride that on October 17th, Madame Francine Ouellette from Sainte Rita in Basse-Saint-Laurent was named Farmer of the Year 2009 at a Saturn Gala held by the Fédération des Agricultrices du Québec, which was held in Drummondville. This multi-talented woman is also co-owner of a sugar bush called April and Ouellette. She is able to showcase her talents as a leader and has done much for the bioproducts in Saint Rita and the growth and harvesting of medicinal plants. But this is only one part of the talent of this lady. She is a leader who is also mayor of Saint Rita in the MRC of Les Basques. I would like to congratulate her on her entrepreneurship and leadership.
Mountain. With the Christmas season fast approaching, I'm really looking forward to watching a Charlie Brown's Christmas again. Part of it is to remind me of my childhood, but this year in particular it's because I find myself asking the same question as Charlie Brown, who spent the whole episode wondering why Christmas is so commercialized. Isn't there anyone who knows what Christmas is all about? The Conservative government sure doesn't. It wants Canadians to go out and spend anywhere on anything as long as consumer spending gets us out of the recession. But that's asking the victims of the recession to fix the recession. Many Canadians are barely scraping by. Adding to their difficulties by encouraging rampant spending is irresponsible, especially when this government has done nothing to regulate the credit card interest rates that will make life even harder once the bills come in. It is fun to have people over, go to parties and to give and receive gifts, but let's help each other in the process whenever possible. Let's support charities, buy local, buy union, or buy green. And above all, let's remember that all of that is really secondary to what the season is really about. Charlie Brown know it, and we know it too. Merry Christmas.
The Honourable Member for Edmonton East.
Madam Speaker, today we remember Ukraine's Holodomor, truly a genocide, a crime against humanity that the world had chosen to forget. More than 7 million souls perished in Ukraine in a forced famine created by Stalin's despotic 1930s regime. This annihilation was not caused by the ravages of nature, nor the scourge of pestilence, nor by the obliteration of war, but by the hand of a dictator consumed with hatred. Why mankind wreaks death and destruction on its own in such unimaginable numbers might not even have the understanding of it by the Almighty in the hereafter. The millions of Ukrainians starved to death in the breadbasket of Europe are being remembered in ceremonies across Canada and around the world. We remember today the victims of the Holodomor, of the dark side of humanity, and by remembering, we help the world guard against those who would repeat such genocide.
The Honourable Member for Bramalea-Gormal.
The Conservative government had claimed that 90% of the economic stimulus package was already underway and creating jobs. However, every day we are witnessing more and more Canadians suffering from job losses. Since October last year, approximately 500,000 Canadians have lost their employment. The recession's tool and the government's inaction is being seen in record increases in the use of food banks. In March alone, almost 790,000 Canadians visited a food bank, which is an increase of 18% from March 2008. 37% of those assisted were children. This government needs to wake up, stop spending money on shameless party promotion, and focus instead on the Canadians who are having serious difficulty meeting ends meet, and immediately reform the employment insurance. Thank you.
The Honourable Member for Beauce. Thank you very much, Madam Speaker. After wrongly beating the BC Lions last week, our heroes, the Montreal Alouettes, are going back out on the field next Sunday to participate in Calgary in the 97th Grey Cup. For the Alouettes, this is the second time they're at the Grey Cup in 2 years. Last year it was a home game. Mr. Speaker, I want to wish them well. I hope they have as great a victory against the Saskatchewan Roughriders in Calgary as the one they had in Montreal in the Eastern Ship Finals. As a former football player and as a sportsman myself, I say to the Roughriders, get ready to meet a tough team. As an Alouette supporter, I want to offer the best of luck. You've got everything that you need to win the Grey Cup. Go, Alouettes, go. I'm looking forward to seeing you parade the Grey Cup through the streets of Montreal. The Honourable Member for Laurentides-Labelle. Mr. Speaker, on Tuesday, my colleague from Chicoutimi-Les-Fjords and myself brought some 3,000 postcards in support of Bill C-288 to the Office of the Minister of State responsible for economic development in the regions in Canada, Quebec region. C-288 is proposing the implementation of a tax credit to encourage young graduates to go back to their regions and to help out the industries, the secondary and tertiary processing industries in their regions by giving entrepreneurs greater access to qualified labor. In the last Parliament, the Conservative government refused to bring in a measure like this to help youth in regions. While Bill C-288 is almost at committee stage, we want to say we hope that the Liberals and New Democrats will continue to support this bloc initiative and that the Conservatives will set aside their partisan ideology and promote the interests of young graduates in the regions. The Honourable Member for Beauport-Limoilou. Mr. Speaker, I should today like to salute the departure of a great parliamentarian in Canada, Senator Marcel Prudhomme. First elected to the House of Commons in 1964, he was re-elected 8 times thereafter. Appointed senator by Prime Minister Brian Mulroney on May 26, 1993, he has today completed 45 years in parliamentary life in a row. Embodying a veritable Canadian institutional memory, Senator Prudhomme has distinguished himself by his openness to the countries of the world and the importance of maintaining dialogue in the world. Convinced about the unique, original, and constructive role that Canada can play in the world, he is asking for more effort to be given and more time to be given on international matters. Senator Prudhomme, for your having defended your country passionately and represented it with integrity, all of Canada says thank you.
The Honourable Member for Davenport. Mr. Speaker, 1 year ago today we joined with people across the world in horror as we watched what was to be 2 days of terrorist action in the Indian city of Mumbai. Like so many other such assaults upon humanity, these terrorist attacks serve to remind us of the terrible hatred and extremism that still exists in our world today. Those innocent people who lost their lives in Mumbai will live in our memories forever.
Anyone doing these deeds can never win. However, because in the end, good people always triumph over evil. Mahatma Gandhi once said, "You must never despair of human nature. The world is full of good." We in Canada join with our brothers and sisters in India in commemorating this dark day. But more importantly, we remember those who left us and whose light will continue to shine forever. Our resolve will never falter as we join good and decent people everywhere in resisting hatred, intolerance, and destruction in our world. Thank you, Mr. Speaker.
The Honourable Member for Lotbinière-Chaudière. Yesterday, Mr. Speaker, I rose in the House to denounce the Bloc's attitude because in committee those members refused to give me my right to have documents translated from English into French. I rose to defend the rights of Francophones to work in their mother tongue. The fact of denouncing this attitude made for an attack on my integrity by the leader of the Bloc in a scrum, and he knows what he said. Is that the way to act, insulting a unilingual Francophone member because he wanted to stand up for the French language in Ottawa? French is my language, and I'm proud of it. Mr. Speaker, in reacting in that way, it is an insult for all Quebec Francophones who are unilingual that the leader of the Bloc is insulting. At home, in the regions, Francophone unilinguals are in the majority. We fight for our language and we fight for the values of the Quebec nation here in Ottawa.
The Honourable Member.
Order, please.
East. Order.
Mr. Speaker, I am honoured that the report of the parliamentary delegation to the West Bank and Gaza this past August is now presented. It was a significant and compelling experience, and I am committed to raising awareness about the worsening humanitarian disaster in Gaza and the need to end the blockade, normalize borders, and end the occupation of Palestinian lands. I am deeply concerned that the Conservative government has so politicized the situation in the Middle East and has gone so far as to attack MPs and organizations who criticize the actions of Israel as being anti-Semitic. Let's be clear, anti-Semitism has no place in Canada. The Conservative attacks are reminiscent of McCarthyism and also have no place in Canadian society. Rather than trying to silence and denigrate legitimate public debate, including its contempt of the Goldstone report, the Conservative government must stand up for international law, human rights, and the Fourth Geneva Convention. I hope all members will consider this report and ensure that Canada affirms its commitment to peace and justice for Palestinians and for a lasting...
The Honourable Member for Calgary East.
Hear, hear. Mr. Speaker, today Canada remembers the victims of last year's deadly attacks in Mumbai. A year ago, cowardly terrorist attacks took the life of 166 innocent civilians, including 2 Canadians. Our thoughts are with the families of the victims and with the survivors of this terrible tragedy. Last week, the Prime Minister, the Minister of Foreign Affairs and myself stayed in Mumbai at one of the hotels which was attacked. Mr. Speaker, Canada itself is not immune to terrorist attacks. Canadians lost their lives in the Air India bombings as well as the September 11th attacks in New York. Mr. Speaker, Canada has designated June 23rd as the National Day of Remembrance for Victims of Terrorism, which aims to denounce terrorism and honor the memory of its victims, such as those who lost their lives in the deadly attacks in Mumbai. Mr. Speaker, Canada and India have agreed to continue to fight against global terrorism.
The Honourable Member for Vaudreuil-Soulanges. Mr. Speaker, today I would like to pay homage to Senator Marcel Prudhomme. He was elected for the first time in the riding of Saint-Denis in Montreal on February the 10th, 1964, and was appointed senator in 1993. Marcel Prudhomme has served Parliament for 45 years in a row. He's the longest-sitting parliamentarian. Senator Prudhomme possesses an inestimable experience in political life and an excellent understanding of international affairs. He's also founded a variety of interparliamentary groups to promote participation in parliamentary dialogue. He wants to ensure that there is a future for humanity. This man has won the friendship of major figures in the world and has worked hard to ensure that understanding and friendship should prevail amongst peoples. He has defended peace, the rights, human rights, dignity, for all human beings. Mr. Senator Prudhomme, we wish you much joy and luck in your future projects.
L'honorable député.
The honourable member for
The Hull Aylmer.
The honourable member for Hull Aylmer. Order, please. Mr. Speaker, the Dean of this Parliament, the Honourable Senator from Montreal, Marcel Prudhomme, a member of the Privy Council, will be retiring in a few days. That is November 30th, the day that he celebrates his 75th birthday. After 45 years, 9 months, and 20 days as a member of this House, he won 9 consecutive elections between 64 and 93 in Saint-Denis under the Liberal banner. He became an independent senator on May 26, 1993. This man is a walking institutional memory. He's a proud francophone who has always believed in our federation and has fought bravely and patriotically for his interests to defend Canada internationally. We thank him for fighting to provide for equality between men and women. That constitutes a political heritage, a legacy that we must preserve. We wish him a great deal of success in his future undertakings in retirement.
The honourable member for Peterborough. Order.
Mr. Speaker, today a Liberal MP will stand on behalf of the Liberal leader and ask a question about detainees in Afghanistan. The Liberal leader's stand-in will throw mud, make allegations, smearing our armed forces and our mission. But no matter what the question or the answer, the Liberal leader has proven what we've been saying all along. He's just in it for himself, Mr. Speaker. He proved it because the Liberal leader is actually fundraising on this issue. My colleagues and I don't support this calculated cynicism, and we're not alone. The Liberal member from Vancouver South, when asked if this was an appropriate issue to fundraise on, said, no, it's not.
Good for him.
Mr. Speaker, shortly, mark my words, a Liberal member will stand on behalf of the Liberal leader and ask a question about Afghan detainees. But the question is, how long before the Liberal Party uses that torqued-up question to try and fill its war chest, Mr. Speaker? It's deplorable.
Order. Oral questions. Questions orales. The honourable member for Toronto Centre.
Mr. Speaker. Mr. Speaker, the Conservative government has put an end to the activities of the Complaints Commission under the military police, refused to renew the mandate of the commissioner, refused to allow witnesses to appear, and told Mr. Richard Colvin if he cooperated with the House committee, he risked going to prison. How does the government feel this is compatible with the need to look into these allegations of mistreatment? The Honourable Minister of Transport.
Toronto Centre, to the member for Toronto Centre, what is not compatible, what is shameless, what is a shameless attempt to raise money, it's for the Liberal Party, Mr. Speaker, to malign Canada, to question the actions of our public servants and our brave men and women in uniform. The Liberal Party, Mr. Speaker, is politicizing a very sensitive issue on the backs of our brave men and women in uniform. It's unwarranted, it's appalling, and it's absolutely shameful, Mr. Speaker.
The honourable member for Toronto Centre.
Speaker, the only party that has attacked the credibility of a public servant serving in Afghanistan is the Conservative Party of Canada, and they're attacking Richard Colvin. We're the only ones who've done it. But, Mr. Speaker, we now have the spectacle of Mr. Colvin, the three generals yesterday, and no doubt Mr. Mulrooney today, all having full and complete access to documents that members of Parliament, Mr. Speaker, cannot see. We are barred from having access to information that the government itself has full control of, that ministers and even retired generals can review, and we are asked to do our work blindfolded and in the dark. I'd like to ask the minister, does he not realize that only a public inquiry...
The Honourable Minister of Transport.
Mr. Speaker, to be very clear, we have and will continue to provide all legally available information to Parliament and to the committee, Mr. Speaker. We think That's important. But when the member opposite talks about darkness, Mr. Speaker, I'll tell you the darkness that Canadian members of the Armed Forces remember, the decade of darkness of the Liberals' time in power, Mr. Speaker. I know the member for the Toronto Centre. I know he would believe that raising money on the backs of our men and women uniform by maligning Canada is wrong, and I would call him to match the statements by the member for Vancouver South. Stand up in this place and call those type of shameless fundraising tactics wrong for what they are, Mr. Speaker.
Honourable member. Order. The honourable member for Toronto Centre. Sad fact remains, Mr. Speaker, that partially and heavily blacked out documents with key information missing are not disclosure. Non-answers in the House are not disclosure.
Threats are not disclosure.
Rhetorical, personal attacks, such as the Minister himself has just indulged in, are not disclosure and do not amount to disclosure. Mr. Speaker, we need to get at the truth. Why is the government afraid of a public inquiry to get at the truth? What is it about the truth that this government is afraid of, Mr. Speaker? The Honourable Minister of Transport. Order.
Great Canadian hero spoke to the House of Commons committee yesterday, Mr. Speaker. General Rick Hillier, a great Canadian hero himself, dismissed the claims against them as ludicrous and uninformed. We heard another general who said he was, quote, mortified at the questions being put by some members of the opposition, Mr. Speaker. Mr. Speaker, I know the member for Toronto Centre, and he was never more correct in his life than when he said in the House of Commons on June 10th, 1980, nothing embarrasses the Liberals because they do not know the meaning of shame. They are without shame, they are shameless. He was right then, and that's just as right today, Mr. Speaker.
The honourable member. Order. The honourable member for Vancouver South.
Mr. Speaker.
Order. Order. The honourable member for Vancouver South has the floor.
Mr.
Order.
Speaker, for years there has been a compelling body of evidence on the risk of torture in Afghan jails in the public domain. The U.S. State Department, the UN, Human Rights Watch, Amnesty International, the Afghan Independent Human Rights Commission, the Red Cross, and even DFATE itself, to name just a few sources, Mr. Speaker. The Dutch were so worried that they wanted to build a NATO prison to ensure the proper treatment of prisoners. Why the cover-up? Why no disclosure? Why not a public inquiry?
Right. The Honourable Minister of National Defence.
Well, as we've indicated a number of times, Mr. Speaker, when we had credible allegations, we acted. When we had evidence which substantiated concerns, we moved, we invested, we helped Afghans. But let's take a look at what General Gauthier, a highly decorated 36-year veteran of the Canadian Forces, had to say yesterday. I can safely say there is nothing in any of these 2006 reports that caused any of the subject matter experts on my staff, nor by extension me, to be alerted to either the fact of torture or of a very high risk of torture. Nothing. That's what the General had to say, Mr. Speaker. I'll take his word over that of the member opposite any day.
The honourable member for Vancouver South.
General Gauthier also said release the documents because that would prove that this government is continuing to transfer detainees to the risk of torture in Afghan jails. Canadian Federal Court, Mr. Speaker, said in February 08, quote, the evidence clearly established the existence of real and very serious concerns as to the effectiveness of the steps that have been taken thus far to ensure that the detainees transferred by the Canadian forces to the custody of Afghan authorities are not mistreated. Unquote. I ask, why the cover-up? Why no disclosure? And why not a public inquiry? What does this government, this accountable and honest government, have to fear from the truth?
The Honourable Minister of National Defence.
Well, more verbiage and volume from the member opposite, Mr. Speaker, adds nothing, and I thank him for pointing out that we are an accountable and honest government. But let's look again, Mr. Speaker. Let's get beyond the rhetorical flourish. Let's get beyond those who are in partisan mode. Let's look at what a highly decorated, recognized former Chief of the Defence Staff had to say. We didn't base our actions upon people making statements like all detainees were tortured. How ludicrous a statement is that from one single individual who really has no knowledge to be able to say something like that, Mr. Speaker? We're putting documents out, documents that are legally obliged, Mr. Speaker. We'll continue to do so.
The Honourable Member for Laurier-Sainte-Marie. Mr. Speaker, the government has always denied receiving information about allegations of torture against Afghan prisoners. Two former senior officers of the Army repeated that yesterday in the Parliamentary Committee, but Richard Colvin sent emails in May and June 2006 to the Minister of Foreign Affairs saying that the Red Cross lost any trace of prisoners once they were transferred to Afghan authorities, and all sorts of things happened. Why has the Prime Minister always denied receiving these kinds of warnings? The Honourable Minister of Transport.
Credible evidence, the government acts, Mr. Speaker, but we require proven, substantiated, and credible evidence task. Yesterday, the House of Commons Committee heard from two great Canadian heroes, General Rick Hillier, who called the allegations ludicrous, Mr. Speaker. We heard from one 36-year veteran of the Canadian Forces, Lieutenant General Michel Gauthier, who said that he felt mortified to see members of the opposition basically label the troops as war criminals, Mr. Speaker. That is a disgrace and that is shameful.
The Honourable Member for Laurier-Sainte-Marie. Order, please. Mr. Speaker, for security reasons, the government is refusing to provide the opposition parties with the reports on torture allegations involving Afghan prisoners. But former military officers who are now back in civil society did receive these reports and had them before coming before the committee, even though they are no longer in the armed forces. Will the Prime Minister admit that security is just an excuse and allows the government to save face, and that the government has lost all credibility? Honourable Minister of Transport.
Exactly what this government has been saying all along and in this House for more than a week. They dismiss the allegations against themselves and the government as completely baseless, Mr. Speaker. And I would encourage the member opposite to accept that. If we have to hear from people, there is no more credible Canadian on this issue than General Rick Hillier. I believe what General Hillier says. I support our men and women in troops, and those of us on this side of the House will never, ever, ever do anything that will not ensure the complete security of our men and women in uniform.
The Honourable Minister for Saint-Jean. Mr. Speaker, the government has done everything to block the truth from coming out. Without immunity, diplomat Richard Colvin is unwilling to provide his reports on torture to the Parliamentary Committee. The government lawyers are even threatening him with reprisals up to and including imprisonment. I ask the government to confirm in this House that Mr. Colvin has immunity like all witnesses do and has the right to provide the committee with all documents he feels are appropriate. The Honourable Minister of National Defence.
Testimony. That testimony was the subject of cross-examination, as was the testimony given yesterday by three top generals. And Mr. Speaker, with respect to this question of emails and communications, Mr. Speaker, we've answered this question a number of times. When our military, when our diplomats, when individuals involved in the mission received information, they acted. They acted quickly, they acted decisively. We've invested to improve in the Afghan system, Mr. Speaker. Disparaging remarks, rhetorical flourishes are not going to help us get to the bottom of this issue. We're cooperating with the Parliamentary Committee. We'll continue to do so.
The Honourable Member for Saint-Jean. Mr. Speaker, we are at the heart of what needs to happen over the next few days with the witnesses. Not only do we not have the documents, but the witnesses are being threatened with not having immunity when they appear. So my question is whether, if Mr. Colvin comes and provides the documents, does he risk imprisonment? And if so, that is absolutely unacceptable. The Honourable Minister of National Defence.
Again, has been said a number of times, documents that are legally required to be made available will be made available, Mr. Speaker. The committee has passed motions just yesterday, I note, with reference to requests for information. We'll respond appropriately, but appropriately keeping within the laws of Canada, within the laws of the evidence, Mr. Speaker, the National Defence Act, protecting national security, Mr. Speaker. The honourable member opposite may not be concerned with that. I would have thought that former members of government would have an understanding of the need to protect national security, but apparently not.
The Honourable Member for Toronto Danforth.
Mr. Speaker, the Minister of Defense has told this House that he didn't even know who Richard Colvin was. Then he called him a Taliban dupe. And last week he said he may have received a report to which Mr. Colvin contributed, but he didn't bother to read it. Today he stands up and says that he's cooperating with the Standing Committee, but then he enumerates just now a whole list of excuses about why certain documents are not going to be provided. And, of course, they're going to wrap it up in so-called security concerns. Why won't they go agree with our call for a public inquiry?
The Honourable Minister of Transport.
The government's been very clear that we'll continue. We have and will continue to provide all legally available information, Mr. Speaker. We think national security is important. We also think the safety of our men and women in uniform is paramount, and that is something we will never, ever negotiate on, Mr. Speaker. Our government stands solidly behind our men and women in uniform, and we make absolutely no apologies for that whatsoever.
Honourable Member for Toronto, Danforth.
Mr. Speaker, the Copenhagen Conference to reduce greenhouse gases is extremely important for the future of our planet. The American president will be there. The German Chancellor, the British and Australian Prime Ministers, as well as the Brazilian and French presidents will be there. Over 66 presidents and heads of state will be there and have confirmed that. Will the Prime Minister confirm that he will be in Copenhagen to deal with this extremely important issue for now and for the future?
Is committed to a successful climate change outcome in Canada. The Prime Minister stood up in this House yesterday and said if a significant amount of other world leaders were attending, he would, and in fact he will be in Copenhagen, Mr. Speaker.
The Honourable Member for Toronto, Danforth.
Well, we're glad that the Prime Minister is finally taking this issue seriously, and he's taken his head out of the tar sands. The question is he going to go with any kind of a plan? So far, we've seen no plan, even though it was promised by the Minister of the Environment. You know, Canada's true north is at risk. That's why we need to be more concerned about this than perhaps even some other countries. We've got the permafrost melting. We've got infrastructures that are falling apart. We've got Aboriginal people and their way of life being threatened fundamentally. Mr. Speaker, where's the plan? Why is this government disappointing Canadians and the world on climate?
The Honourable Minister of Transport.
As I said, Canada is committed to a successful climate change outcome in Copenhagen. The many government officials, the Minister of the Environment, even the Prime Minister will be there to forcefully argue for a strong agreement. Mr. Speaker, we believe that agreement must be effective. We believe an agreement must be ambitious and must include all emitters, Mr. Speaker. And due to the integrated nature of economies, the Prime Minister and the Minister of the Environment are working very closely with the Obama administration and will continue to work that in the days and weeks ahead, Mr. Speaker.
The Honourable Member for Papineau. Mr. Speaker, we now are witnessing a very sad spectacle with Mr. Richard Colvin. We had the former generals and probably Mr. Mulroney today who have access to documents that the opposition cannot consult. We are being blocked from seeing information that the government has full control over, information that ministers and even retired generals can look at, and we are working in the dark. This is a flagrant case of such obstruction. How can the government keep going with this masquerade?
Honourable member, if he feels he's in the dark, Mr. Speaker, but what I can tell you is that the committee yesterday, just yesterday, passed a motion asking that legally available information be tabled. That will happen. The committee, of course, passed a motion just yesterday seeking those documents. As would be expected in issues that involve security, national security, sensitive information that could affect troops in the field, Mr. Speaker, it will be looked at as far as the Canada Evidence Act is concerned, the National Defence Act, always keeping national security front and center. Thank you, Mr. Speaker.
The Honourable Member for Papineau. Mr. Speaker, these partial documents that have been censored and important information being left out is not full disclosure, and as well personal attacks, rhetoric, and accusations in the House are not disclosure. We need to discover the truth. The reputation of Canada and its troops around the world is at stake. Why is the government afraid of a public inquiry that would get to the bottom of things? The Honourable Minister of Defence.
This matter is being aired in a parliamentary committee. It's been heard by the Military Police Complaints Commission until it was shut down by the chair. There have been other bodies, arm's-length bodies, that have looked at the issue. But with respect to the highly sought-after reports, Mr. Speaker, this is what General Hillier had to say. The allegations that officials turned a blind eye to torture are ludicrous and absolutely untrue. That's a high-ranking general. Nothing about abuse, nothing about torture, or anything else that would have caught my attention, or indeed the attention of others, was in those reports, Mr. Speaker. This, again, from a trusted general, not a partisan opposition.
The honourable member for St. John's South Mount Pearl.
Yesterday, the Afghanistan Committee was told there was nothing in Mr. Colvin's reports that would set off alarm bells with ordinary Canadians. Well, let me quote one of Mr. Colvin's reports. They hit us with cables and wires. One detainee reported he was, quote, shocked with electricity, and personally showed Mr. Colvin a number of scars on his legs he said were caused by the beating. The report predates Canada's decision to halt transfers. How is it that information would not set off alarm bells with this government?
The Honourable Minister of National Defence.
Well, Mr. Speaker, I guess the obvious question is, was it a Canadian transferred detainee? That would be the question that I would have. We would certainly have general concerns, as we did, which is why we acted, why we invested in the prison system, why we began to train prison officials and police, why we invested in the physical infrastructure. $132 million, taxpayers' dollars, went into improving that situation. That's how seriously we took it, Mr. Speaker. But let's look at it. We didn't base our actions upon people making statements like all detainees were tortured. How ludicrous a statement is that from one single individual who really had no knowledge to be able to say something like that? General Hillier, Mr. Speaker, not the member opposite.
The honourable member for St. John's South Mount Pearl.
I don't know is not a responsible answer. The report also notes that Afghan officials had no list of Canadian detainees and that he only had, quote, reasonable confidence that the detainees interviewed were transferred by Canadians. Will the minister tell the House that he can account for the whereabouts, the treatment, and the status of each and every Canadian transferred detainee? Does he know that information up to date today?
The Honourable Minister of National Defence.
Now, clearly, Mr. Speaker, she doesn't know. So that is a question that she may have for herself. Here's what General Hillier had to say about the reports. Nothing about abuse, nothing about torture, or anything else that would have caught my attention, or indeed the attention of others, Mr. Speaker. These are generals, highly respected leaders in the Canadian Forces, on the ground during the period in question, who cast serious doubt over the allegations of one individual who's given testimony. Let's wait for others, like the generals yesterday, to have a full picture of what took place during the period in question, not the partisan attacks, not the righteous indignation, not the feigned concern of the member opposite.
The honourable member for Rosemont-la-Petite-Patrie. Mr. Speaker, the Roundtable on the Environment and the Economy has sent a serious warning to the government. Canada needs not only to reduce its emissions, but change its policies to adapt to climate change that is already underway, especially in the Arctic, where temperatures are rising twice as high as anywhere else in the world. Will the Minister of the Environment listen to this call and finally present an ambitious plan to reduce GHGs and deal with climate change? The Honourable Minister of the Environment.
That as a northern country, Canada is particularly vulnerable to climate change and is interested in adaptation. That's why the Hydro B project, the Mayo B project in the Yukon, was in fact the first project approved by this government on the Green Infrastructure Plan, Mr. Speaker, a $71 million hydro project. Since 2007, this government has invested over $85 million to help Canadians adapt to climate change, $21 million, Mr. Speaker, of which has actually been invested in the north. In addition, we have the mass expansion of the Nahanni, protection of the east arm of Great Slave Lake, and other things that the government is doing to deal with the...
The Honourable Member for Rosemont-la-Petite-Patrie. Mr. Speaker, the government has to admit that a greenhouse gas reduction plan based on 2005-2006 as a reference year rather than 1990 penalizes companies that have taken their responsibilities in the past, like the manufacturing sector in Quebec. That kind of plan would reward industrial sectors that have dragged their feet for 15 years. Instead of rewarding oil companies and the auto sector, will the Conservative government come up with a plan that will recognize the efforts made in Quebec? Honourable Minister of Environment. We have a strategy and a policy, Mr. Speaker. Last night I met with my colleagues from the provinces and territories to finish our preparation for the Copenhagen conference. Canada hopes that an agreement will be drawn up in Copenhagen that will involve all players. We only have a single voice in Copenhagen, and we want to make sure that the agreement reflects our realities.
The Honourable Member for Saint-Lambert. Mr. Speaker, the former Chief Actuary of EI, Michel Bédard, says that the contribution rate of Quebec independent workers of $1.36 for every $100 is too much, and it should be 41 cents. Will the Minister finally admit that the contribution rate for independent workers in Quebec is 3 times too high than the real costs would necessitate, and that for the real benefits this bill would give them? The Honourable Minister. Mr. Speaker, I'm happy to see that the Bloc Québécois is finally agreeing that we're doing something positive to support independent workers by offering them these rates and benefits. Our system was done while respecting the particularities in Quebec for independent workers. And we've done this with Quebec and in proper form. The Honourable Member for Chambly-Bordura. Mr. Speaker, I have here the document of the former Chief Actuary of Employment Insurance, and which confirms that, as we thought, the contribution rate for independent workers is excessive with respect to the real costs of benefits. The Bloc Québécois has proposed an amendment which would correct this problem. Will the government go beyond partisan politics and support our amendment so that independent workers can have justice and can have parental leave? The Honourable Minister. Mr. Speaker, as you know, this is the 4th measure our government brought in to help independent workers. This, furthermore, has to do with our election campaign commitment to improve EI benefits for independent workers. And independent workers are very happy that we put these measures in place to help them.
Order.
Mr. Speaker, Canadian provinces want to have their say on climate change. Many provinces have cut emissions by more than 14%, 5 times more, or 5% more than the federal government has proposed. Will the government not show leadership in Copenhagen? Let's be serious. They don't have a plan. They have nothing. We are the laughingstock of the entire world. The Honourable Minister.
Kyoto, the party of the carbon tax, the party of European targets superimposed on a continental North American cap-and-trade system, Mr. Speaker. I don't think so. I'd ask the Honourable Member this. I quote, he said a few weeks ago, we need to hear more about the American position before we decide. He's now heard the American position. It's identical to the Canadian position. Why won't he adopt it? Why does he insist on a position that will isolate Canada, Mr. Speaker?
Order, please. The Honourable Member for Ottawa South.
minister can duck and hide, he can bob and weave, he can say whatever pops into his head. But the fact is, he has no plan. After 4 years and 3 ministers, Canada has no plan. We are entering the most important negotiations ever, and our businesses, our provinces, and our municipalities have been left to fend for themselves. Now that the Prime Minister has been reeled out of his corner and done an about-face on Copenhagen, will he now show just a smidgen, just a bit of leadership, and order this minister to do his job and get a plan for Canada?
The Honourable Minister of the Environment.
Mr. Speaker, I think Canadians know the only ones really offending for themselves are the Liberal Party, and it's not going so well, Mr. Speaker, with their on-again, off-again carbon tax. Our plans will be harmonized on a continental basic, domestic policies harmonized on a continental basis, Mr. Speaker, integrated with an international treaty that we are currently negotiating at Copenhagen. One thing the Conservative government will never do, Mr. Speaker, is fly over to Copenhagen, pull a target out of the air that's ill-suited to our industrial base, to our geography, and agree to it damaging the Canadian economy. That won't happen on our watch, Mr. Speaker.
Honourable Member. Order. The Honourable Member for Dartmouth Cole Harbour.
Mr. Speaker, perhaps the saddest thing about the comments from the member from South Shore St. Margaret's is that they weren't totally surprising, given the history of smears by Conservatives. The member called the unemployed no good. The member from Nepean Carleton has suggested that Aboriginals need to develop the values of hard work. The member from Saskatoon-Wanuskewin makes offence toward women and their right of choice. And the member from Lumsden Lake Centre has his legendary list of A's and B's. How can the Prime Minister sit quietly and allow these comments to go without an apology? Is his continued silence an indication that he actually agrees with these outrageous comments?
The Honourable Minister of Human Resources and Skills Development. Order.
Well, Mr. Speaker, I think what's truly, truly disturbing is the level of smears that have been coming from the party opposite. I was a victim of that myself earlier this week by the Honourable Member himself. But, Mr. Speaker, recently, the Liberal Party have been sending out flyers to homes that have been smearing our good men and women serving in our armed forces, smearing their credibility, smearing their integrity. They should be ashamed of that.
The Honourable Member for Dartmouth Cole Harbour.
Mr. Speaker, this country is shedding jobs. Food bank use is skyrocketing. People are worried and the government offers insults. The Prime Minister's failure to stand up and apologize for comments made by his MPs, comments that offend women, the poor, the homeless, the unemployed, Aboriginals, homosexuals, can only mean he agrees with them. Or is the reason he won't stand up his own sorry record, his smear when he referred to Atlantic Canadians as having a culture of defeat? Is that the reason the Prime Minister won't stand up and apologize for those outrageous comments?
The Honourable Minister of Human Resources and Skills Development. Order.
Mr. Speaker, I have to wonder whether the Honourable Member thinks that sending out flyers trying to smear the integrity and the good name of our brave men and women who are serving in our armed forces so that the party opposite can try to raise funds off of that for their own partisan purposes. Does he really think that that's acceptable? Does he think that that's the decent thing to do? Because if he does, that explains why he's sitting there.
The Honourable Member for Lambton, Kent, Middlesex.
Thank you, Mr. Speaker. Canadians expect that when serious crime is committed, the individual responsible for the crime actually should face the appropriate sentence. Canadians are rightly concerned that when they perceive the rights of criminals being placed ahead of the rights of abiding citizens. I'm wondering if the Minister of Justice would remind the members of this House just how this government's legislation to amend the Transfer of Offenders Act will help protect Canadians.
Honourable Minister of Justice.
Speaker, I would be glad to, Mr. Speaker. Our government believes that those who commit serious crime must face serious consequences, and that's why today the Minister of Public Safety has introduced legislation to provide additional factors that the Minister can consider when making a decision on the transfer of a criminal to Canada. Under this legislation, the government commits to making the protection of society a guiding principle in decisions affecting the correction system. This legislation will do that by emphasizing offender responsibility when assessing requests for transfer from other countries. We're putting public safety first. I hope this has the support of all honourable members of the House, Mr. Speaker.
Honourable Member for Winnipeg North.
Canadian families with newborns can't test all of the products for safety. They rely on the government to protect them 3 entrapments and 43 incident reports should be enough to set off all the alarm bells in the department and to give lots of warning to Canadians. And you know, Mr. Speaker, we took the government at its word when it said a year ago it had tightened its complaint protocol. But the government knew about unsafe cribs for 14 long years. Could the minister have lived with herself if one of our children had died because the warnings came too late?
Honourable Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, every complaint that is filed by consumers to us in regards to any product is investigated. Once the full scope of the problem is determined, actions and necessary actions are taken. Under the current legislation, it is the legislation that we have right now is currently not adequate for under the surveillance. The surveillance system is very weak. Under the current legislation, we also have to negotiate a voluntary recall with a company whenever we discover a product is safe. This is unacceptable to Canadians, and that is why the Liberal senators need to pass a Canada Consumer Product Safety.
The Honourable Member for Winnipeg North.
We have complaints about crib safety going back 14 years, and Canadians are wondering if the list of safety complaints not acted on by Health Canada now really goes back 40 years. For 40 years, the government has had the tools to protect Canadians, to investigate complaints, to issue warnings and advisories. Yet after 43 incidents and dozens of complaints, it failed to use those tools. So Canadians are wondering, what other dangerous products do they know about but are not telling Canadians?
The Honourable Minister of Health. Order.
Thank you, Mr. Speaker. Mr. Speaker, again, the current legislation that we have in place is not adequate under surveillance. The surveillance system is weak. There is no mandatory reporting from the industry to us whenever there is an incident with any product that they sell. We rely on the consumers to provide information to us when incidences happen, and we investigate every single one of those incidences and make a determination on how to respond, which is why, again, we recognize it's not adequate, which is why we introduced C6, and which is why the Liberal senators need to pass that legislation so we can protect the health and
The Honourable Member for Jean-Lebert. Mr. Speaker, in his factum presented before the Federal Court, the Deputy Attorney General of Canada attacked the use of French at the IRB. Now, the Deputy Attorney General said textually that he was acting on behalf of the Minister of Citizenship and Immigration. Does the Minister realize he can no longer hide behind the arm's-length status of the IRB, and that he is responsible for this guerrilla warfare against French in Montreal? The Honourable Minister of Citizenship and Immigration. Mr. Speaker, the member should calm down. In the process, there was a process that started in English, and then the lawyer began speaking French, even though the person was not French speaking. Then the lawyer wanted all the border agency's documents to be translated into French, although it had been accepted originally in the first language. Mr. Speaker, this is according to official languages. The Honourable Member for Abitibi-Témiscamingue. Mr. Speaker, for 2 years now, Native communities in Quebec have been asking for a meeting with the minister to present their grievances. They didn't even get an acknowledgement that their letter had been received. They are here today. Will the minister have the decency to meet with them? The Honourable Minister of Indian Affairs.
Mr. Speaker, we continue to have good success with 3 Innu communities up on the coast, Mr. Speaker, working with the Quebec government, and negotiations are proceeding well. Mr. Speaker, of course, we are prepared at all times to meet with the Mamuitun Tribal Council to discuss ways that we could move forward with them in some sort of an agreement as well. Mr. Speaker, we've that offer stands, and of course we'd be delighted. And Mr. Speaker, if I could, one of those communities, I'm very pleased that today that we're able to announce the completion of their water system, Mr. Speaker, that was built over the last year, and that's evidence, Mr. Speaker, that we can work together.
The Honourable Member for Notre-Dame-de-Grâce-Lachine. Mr. Speaker, 2 elections ago, the Conservatives tried unsuccessfully to get national expenses accepted as local expenses. The Conservatives are the only to have used this stratagem. They are the only to have had to be searched by the RCMP, to have their general headquarters searched by the RCMP. Their arguments are so feeble that only the Parliamentary Secretary of the Prime Minister dares use them in public. And that says quite a bit about their credibility, doesn't it? The Honourable Parliamentary Secretary to the Prime Minister.
The Honourable Member poses a question about party financing. Unfortunately, I have in my hands a letter that the Liberal Party is using to fill its party war chest. It's a letter that raises money on behalf, on the backs of our soldiers who are sacrificing so much to serve our country abroad. My honourable Liberal friend would increase her own credibility on matters of party financing if she would now rise and apologize on behalf of the Liberal Party.
Here, here. Honourable Member for Mississauga, Streetsville. Order.
Member does over and over again doesn't make it the truth, and Canadians want the truth. We have Conservative candidates admitting to electoral wrongdoing and apologizing for it. We have a federal agency doing its job and bringing this to light. Yet, we have a government that thinks it's above the law. The Conservatives should simply do the right thing. When will the Prime Minister order his party to stop wasting taxpayer dollars, respect Elections Canada, and cooperate with real electoral reform?
Honourable Parliamentary Secretary to the Prime Minister.
Mr. Speaker, I would like to give the Liberal Party a second chance to apologize for this very unfortunate letter. Mr. Speaker, this is a letter that seeks to raise money off the backs of the reputation of our soldiers, at
smearing the reputation,
great expense to the morale of our men and women in uniform. This is not the way that parties should be raising funding. We accept their right to pose questions about Taliban prisoners, but please don't raise money on the backs of our soldiers.
The Honourable Member for Burnaby Douglas.
Mr. Speaker, Uganda's anti-homosexuality bill is reprehensible, vile, and hateful. It violates human rights by imposing life in prison on gays and lesbians and a death sentence for those who are gay and have AIDS. It will jail anyone who fails to report people they know to be gay. At the Commonwealth meeting, will the Prime Minister meet face-to-face with Uganda's Prime Minister to help stop this bill? And will he make gay, lesbian, and trans rights essential to development and educational work supported by Canadian foreign aid in Uganda and elsewhere?
The Honourable Minister of Transport.
Thank you very much, Mr. Speaker. Mr. Speaker, the current legislation before Parliament in Uganda is vile, it's abhorrent, it's offensive, it offends Canadian values, it offends decency, Mr. Speaker. We strongly condemn that, and the Prime Minister will make that strong condemnation as well.
The Honourable Member for Hamilton East, Stony Creek. Order.
Indian citizen Hussein Jalil has been imprisoned in China on trumped-up charges since 2006. Before the Prime Minister heads to China, I want to remind him of his own words on the Jalil case. And I quote the Prime Minister when he said, "I don't think Canadians want us to sell out important Canadian values. They don't want us to sell that out to the almighty dollar." And Canadians agree. So will the Prime Minister use this trip to China to do what he knows Canadians expect and ask for the release of Mr. Jalil?
The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Mr. Speaker, Mrs. Jalil's case remains a top priority for this government. We are deeply concerned at China's refusal to recognize the Canadian citizenship and permit Canadian consular access to visit him. Mr. Speaker, we continue to raise Mr. Jalil's case with senior Chinese officials, in particular the issues of respect for his human right, consular access, and due process. We will continue, Mr. Speaker, to be in contact with Mr. Salih's family and provide them with all councillor access. Thank you, Mr. Speaker.
Honourable Member for Kildonan St. Paul.
Mr. Speaker, this morning as Chair of the Health Committee, I tabled a report back from committee urging Liberal senators to pass Bill C-6. This bill is about protecting Canadian children from consumer products such as cribs, which have been found to be dangerous. The Liberal senators have been delaying the passage of this important piece of legislation and keep finding reasons why they can't proceed to cause by clause. Can the Minister of Health please tell us why it is so crucial to pass this legislation?
Honourable Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, the Liberal leaders should encourage the Liberal senator to pass Bill C-6, the Canada Consumer Product Safety Act. This bill is currently in Senate committee, where Liberal senators have been delaying clause-by-clause consideration since early November, Mr. Speaker. Without Bill C-6, our government does not have the authority to order a product recall when companies fail to act on safety concerns. Without Bill C-6, we do not have the tools needed to protect Canadians and their families. The Liberal leaders should encourage their senators to follow the fine examples of all MPs in this House who passed it unanimously.
The Honourable Member for Random, Buren St. George's.
Mr. Speaker, in March of 2008, the Federation of Newfoundland Indians and this government signed an agreement to establish a non-reserve Mi'kmaq band in the province. The deadline to register is November the 30th. 20,000 Mi'kmaq submitted their applications, and to date, less than half of these applications have been processed. 11,000 Mi'kmaq are still waiting. With the deadline just 3 days away, it is obvious all of the applications won't get done. I ask the Minister of Indian Affairs if he will agree, in fairness, to have the deadline extended.
The Honourable Minister of Indian Affairs.
Thank you, Mr. Speaker. Of course, it was a very historic moment when we signed that agreement with the Mi'kmaq in Newfoundland. It was something that had been waiting for generations, Mr. Speaker, and it was an honour to be there for that important ceremony. Mr. Speaker, I do know that there is a process that we have to work through as far as the actual adjudication and the committee work that is necessary to make sure all the people that apply have Mi'kmaq heritage. We don't control that entirely, but by all means I'm willing to talk to the chair of that committee, which is not the federal government, and see if there are arrangements we can make to get as many people registered as possible.
The Honourable Member for Laval. Mr. Speaker, yesterday the Minister responsible for status of women refused to denounce the unacceptable statements made by a Conservative MP who implied that abortions contributed to the development of breast cancer. Besides being wrong medically, this assertion is meant to make women feel guilty. We would expect that the Minister would defend women and the right to abortion with vigor rather than saying things worthy of Sarah Palin. When will the Minister stop protecting the dinosaurs in her party to the detriment of women's rights? Order, please. Order. The Honourable Minister of State. Order, please.
Question very clearly in the House yesterday. This member is actually fully aware that there are elected members in this House who have said very similar things at different times. Members in this House represent their constituencies, and they are free to have any opinion that they choose to. It does not mean that it represents the government. But please let me highlight one of our most recent achievements to protect women across this country. Recently, we revised our citizenship guide. I'd like to recognize the Minister for Citizenship and Immigration for the great work he's done in specifically outlining that barbaric practices like female genital mutilation are not tolerated in Canada.
Order. Order. I would like to draw to the attention of honourable members the presence in the gallery of the Honourable Bob MacLeod, Minister of Human Resources, Minister of Industry, Tourism and Investment, and Minister responsible for the Public Utilities Board for the Northwest Territories. And I would like to draw to the attention of all honourable members the presence in the gallery of the Dean of Parliamentarians, the Honourable Marcel Prudhomme,
Senator Prudhomme was first elected as the Liberal member for Saint-Denis, now Papineau, in 1964, and was re-elected an impressive 8 times. In 1993, having never lost an election, he was appointed to the other place, and our loss was its gain, although I was often pleased to see him in the Senate gallery watching the proceedings in the House with, I would like to think, a sense of nostalgia. Aujourd'hui, nous le remercions.
Today we thank him for his wisdom, his experience, and his sense of justice, and we salute this man who over the years became the institutional memory of Parliament Hill. Thank you, Marcel.
And now, it being Thursday, I believe the honourable member for Wascana has a question.
Thank you, Mr. Speaker. My question to the Government House Leader obviously has to do with the work over the next 2 weeks until the normal adjournment at Christmas. In that remainder of the supply period, there need to be 2 more supply days allocated, and I wonder if the House Leader is in a position to indicate precisely when he expects those to come. Secondly, there have been some discussions among House leaders about the appropriate steps to take in the House to mark the 20th anniversary of the tragedy at l'École Polytechnique. And I wonder if the House Leader is in a position to indicate on what day that commemoration is likely to be held. And finally, we are closing in on the deadline for some changes to the standing orders having to do with the allocation of supply days in the calendar year 2010. And I again ask the Government House Leader if he is in a position to make a proposal with respect to that matter, pursuant to the motion that was adopted by this House in January, or in June, rather.
Honourable Government House Leader.
Thank you, Mr. Speaker. I thank my honourable colleague, the official opposition House Leader, for his question this Thursday. And obviously, Mr. Speaker, I will contain myself mainly to the traditional question, which is the business ahead for the next week for the House of Commons. Mr. Speaker, this week we're focusing yet again on the government's justice bills. Yesterday we completed the final reading of C-36, the Serious Time for Serious Crime Bill. We expect to send C-58, the Child Protection Act, to committee later today. In fact, Mr. Speaker, I had hoped that the debate might have collapsed before question period and that bill have already been on its way to committee, but hopefully that'll happen this afternoon. We will then be debating at second reading C-31, an act to amend the Criminal Code, the Corruption of Foreign Public Officials Act and the Identification of Criminals Act, and to make a consequential amendment to another act. We're hopeful that debate will conclude on this bill as well today. Other bills scheduled for debate this week are C-54, an act to amend the Criminal Code to make consequential amendments to the National Defence Act, and C-55, an act to amend the Criminal Code, which is the response to the Supreme Court of Canada decision in R versus Soccer Act. Next week we'll be calling for debate C-27, anti-spam, at third reading, C-44, the Canada Post Remailers Bill, at second reading, C-57, Canada-Jordan Free Trade Act, at second reading, C-56, Fairness for the Self-Employed Act, report stage and third reading on that bill, Mr. Speaker, and of course, as always, I will give a consideration to any bill that's reported back from committee. My honourable colleague asked about allotted days. Next Tuesday would be my intention to have the next allotted day. And yesterday, Mr. Speaker, pursuant to an order made Friday, June 19th, 2009, which again the honourable House Leader for the Liberal Party just mentioned, you tabled a proposed formula for the distribution of allotted days in each of the supply periods of 2010. There have been discussion amongst all parties, Mr. Speaker, and
and we're in agreement with your proposal. Therefore, I believe you'll find unanimous consent for the following motion. That for the calendar year 2010, in the present Parliament, Standing Order 8110A be amended as follows. 8110A. In 2010, 7 sitting days shall be allotted to the business of supply in the period ending not later than March 26th. 8 additional days shall be allotted to the business of supply in the period ending not later than June 23rd, and 7 additional days shall be allotted to the business of supply for the period ending not later than December 10th, provided that the number of sitting days so allotted may be altered pursuant to paragraph B or C of this section. These 22 days are to be designated as allotted days. In 2010, no more than 1/5 of all the allotted days shall fall on a Wednesday, and no more than 1/5, therefore, shall fall on a Friday. Commencing on the first sitting day of any supply period, no less than 1 and no more than 2 allotted days shall be designated in each 10 sitting day period of the said supply period, except pursuant to paragraph C or section 11 of this standing order. Thank you, Mr. Speaker.
Does the Honourable Government House Leader have the unanimous consent of the House to propose this motion? Agreed. La Chambre l'a entendu.
The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed?
Je déclare la motion.
I declare the motion carried.
The Honourable Minister of Indian Affairs is rising on a point of order.
Thank you, Mr. Speaker. Mr. Speaker, during the course of question period, in response to a question that I received from my critic on the block side, talking specifically about some Innu communities on the coast, I mentioned by name the Mamuitun Tribal Council. And Mr. Speaker, although I don't have the blues in front of me, I fear I may have mixed up the two groups. The Mamuitun Tribal Council is currently in a final land claim negotiation with the Quebec government and ourselves, whereas the Innu Strategic Alliance, who I believe are on the Hill today, are not in negotiations. So again, Mr. Speaker, if I could just rephrase my answer to just repeat that Canada continues to be open to exploring ways to resume discussions, and with the Innu Strategic Alliance, Mr. Speaker, then my answer would stand. Thank you.
The Honourable House Leader is on a point of order.
Thank you, Mr. Speaker. Mr. Speaker, I was also remiss to address the one other issue that my honourable colleague, the official opposition House Leader, raised, which was an inquiry about whether there had been agreement between all the parties as to a process to commemorate the terrible tragedy represented by the 20th anniversary of the massacre at the Polytechnique. And it's my understanding, Mr. Speaker, that there is unanimous agreement to recognize that next Wednesday, December the 2nd, with statements from all parties.
I presume we'll hear about the details of that in due course. L'Honorable Député de Joliette.
The Honourable Member for Joliette on a point of order. Thank you, Mr. Speaker. I'd like unanimous consent to table the document received by the member for Chambly-Bordua that he was referring to during question period, that comes from the former Chief Actuary for Employment Insurance from 1991 to 2003, Michel Bédard, and he analyzed the premium rates in light of C56, which demonstrates that these premium rates are much too high given the coverage proposed in the bill. So I'd like to table this in both official languages. Does the Honourable Member for Joliette have unanimous consent from the House to table these documents?
There is no consent. L'Honorable
The Honourable Member for Jeanne-Lebert on a point of order. Mr. Speaker, during the exchange between the Minister of Citizenship and Immigration and I, we referred to a memo tabled to the Attorney General of Canada and for the benefit of all my colleagues here, I thought that tabling this memo would be a good idea since the Minister did not capture all the finer points. So I'd like to seek a unanimous consent. Does the Honourable Member for Jeanne-Lebert have unanimous consent to table this document? Obviously not. All right. That's the end of points of order for today.
prepared to rule on the question of privilege raised on November 19, 2009 by the Honourable Member for Mount Royal concerning the mailing of a 10%er to some of his constituents by the Honourable Member for Elgin, Middlesex, London, comparing the positions of the Conservative Party of Canada and the Liberal Party of Canada on certain aspects of Canada's policy in the Middle East.
I would like to thank the Honourable Member for Mount Royal for having raised this important matter. I would also like to thank the Parliamentary Secretary to the Prime Minister and to the Minister of Intergovernmental Affairs, the Whip of the Bloc Québécois, the Member for Windsor West, the Member for Saint-Laurent-Cartierville, the Government House Leader, and the Member for Eglinton-Lawrence for their comments.
In outlining his case, the Honourable Member for Mount Royal stated that a mailing purporting to contain information on 3 issues, namely fighting anti-Semitism, fighting terrorism, and supporting Israel, was sent to some of his constituents as well as to other ridings with identifiable Jewish communities. The member went on to claim that this mailing was not only, in the words of the Honourable Member, false and misleading, but also, and I quote, slanderous, damaging, and prejudicial, unquote, to the Liberal Party and by extension himself.
This argument was supported by the Whip for the Bloc Québécois, the Honourable Member for Windsor West, the Honourable Member for Saint-Laurent-Cartierville, and the Honourable Member for Eglinton-Lawrence. In response, the Honourable Parliamentary Secretary to the Prime Minister explained in some detail the content of the 10%er in question and defended its veracity. For his part, the Honourable Government House Leader pointed out that all parties are engaged in this style of communication.
Honourable members know, in deciding on a question of privilege, the Speaker is not charged with determining the facts. The Chair's ruling is limited to whether, on first impression, prima facie, the matter before the House merits priority consideration. In cases where a member alleges that he has experienced interference in the performance of his parliamentary duties, the Speaker's task is particularly difficult. As O'Brien Bosque states at page 111, it
is impossible to codify all incidents which might be interpreted as matters of obstruction, interference, molestation, or intimidation, and as such constitute prima facie cases of privilege. However, some matters found to be prima facie include the damaging of a member's reputation, the usurpation of the title Member of Parliament, the intimidation of members and their staff and of witnesses before committees, and the provision of misleading information.
The Chair has examined the numerous documents submitted in this case. Having heard all the arguments presented, I must agree with several members who suggested that there is no denying the critical role that context played in shaping the cumulative net effect of the words used in this mailing. In my view, the end result was a negative effect that spilled over to the member for Mount Royal in a very direct and personal way. It's not for the Chair to comment either way on the accuracy or inaccuracy of the comparisons drawn in the bulk mailing complained of by the member for Mount Royal. That said, however, the Chair has no difficulty concluding that any reasonable person reading the mailing in question, and this would of course include the constituents of Mount Royal, have likely been left with an impression at variance with the member's long-standing and well-known position on these matters. And therefore I must conclude that the member for Mount Royal, on the face of it, has presented a convincing argument that the mailing constitutes interference with his ability to perform his parliamentary functions, in that its content is damaging to his reputation and his credibility. And consistent with the ruling given on November 19, 2009 in relation to the Honourable Member for Sackville Eastern Shore, and with other rulings in relation to mailings in 2005, and I suggest honourable members look at a ruling on November the 3rd, 2005 at page 9,489 to 90 of the debates for that day. The Chair finds that a prima facie question of privilege does exist, and I therefore invite the honourable member for Mount Royal to move his motion.
Seconded by the member for Winnipeg South Centre. The matter of the question of privilege raised by the member for Mount Royal be now referred to the Standing Committee on Procedure and House Affairs. Mr. Speaker, shortly after I raised the question of privilege on November 19th, on which you have now ruled, you ruled on another question of privilege raised by the member of Sackville Eastern Shore, to which you have now referred. Accordingly, in the light of that ruling, Mr. Speaker, and your ruling today, and in support of the motion to refer, I wish to tender the following submissions in support of the motion to refer, and which incorporate as well the rulings that you have made, Mr. Speaker, and which adduce as well, for the benefit of the members of this House and the committee to which it will be referred, new evidence which has emerged that supports your ruling and supports this motion of referral. As you have mentioned in your references that sometimes it may be difficult to codify the criteria, but you have set forth in the ruling today and in the ruling of November 19th specific and relevant criteria, and I'd like to now relate to those and to the evidence that can be adduced to support, as I said, your ruling and the motion. Mr. Speaker, in your ruling of November 19th, in the matter of the member for Sackville Eastern Shore, you found, and I quote, "Having reviewed the material submitted, as well as the arguments made, the Chair can only conclude that the mailings sent to the constituents of Sackville Eastern Shore did distort their members' true position on the long gun registry and at the very least had the potential to create confusion in their minds. It may also have had the effect of unjustly damaging his reputation and his credibility with the voters of his riding, and as such infringing on his privileges by affecting his ability to function as a member." Mr. Speaker, as this House will recall, my question...
I think the honourable member, I don't know whether he's going on for some time or not, but he's proposed a motion. I think we should put the motion to the House. So if he'd send me the motion that he read, I think that I need that, and I'll put the question to the House, and then we can proceed. Somebody's coming to get it. She's not here, though. Who seconded it? Okay. Mr. Conkler, seconded by Mrs. Jennings, moves that the matter of the question of privilege raised by the member for Mount Royal be now referred to the Standing Committee on Procedure and House Affairs. Now, is the honourable member rising to address the motion? Right. The honourable member for Mount Royal then can continue his remarks.
Thank you, Mr. Speaker. As this House will recall, my original question of privilege was in regard to Conservative 10%ers targeting Jewish constituents in urban areas, such as in my riding of Mount Royal. Indeed, these 10%ers, Mr. Speaker, and they go to a larger question of subvention from public funds, also were an abuse of process in the use of coupling to target more than 10% through the aggregate use of this 10%er abuse of process. Moreover, as I attested to in the House, the contents of these 10%ers contain serious falsehoods and misrepresentations that not only, and this is putting it mildly, Mr. Speaker, but I want to relate to the criteria that you have enunciated both today and in your ruling of November 19th. And I quote, "Distort their members' true position and at the very least had the potential to create confusion in the minds of constituents," as per your ruling. But I may add, Mr. Speaker, and again quoting from your rulings, they may also have had the effect of unjustly damaging the reputation of the member and the member's credibility with the voters of his riding, and as such infringing on his privileges by affecting his ability to function as a member, unquote. Indeed, what is specifically damaging, Mr. Speaker, and wherein the breach of privilege is most evident, is in the false and cruel characterizations of my party and myself, and I quote, and this is the only allegation I will deal with, as willingly participating in overtly anti-Semitic Durban 1, unquote. This, Mr. Speaker, is a particularly outrageous accusation to be made to ridings that are targeted because of their Jewish community, as Durban has emerged for Jews in my own riding and in others as a metaphor for virulent anti-Semitism. Accordingly, to identify any political party, let alone a Jewish MP, Mr. Speaker, with willingly participating in such an anti-Semitic event is a most loathsome and dangerous accusation that one can make against that party and that member. Indeed, Mr. Speaker, and this is the important point in respect of your rulings on breach of privilege and in support of the motion now to refer this prima facie breach to the House Committee. These accusations have already had damaging and prejudicial effects on my reputation and standing in my constituency, to use your criteria, as the composite of the three accusations in the flyer constitute the most damning accusations one could make. These were attacks on me as a person, as an MP, and as a member of the Jewish community, and as a member of the party to which I am a member. It not only had sowed confusion, Mr. Speaker, to use your criteria, but anger amongst some of my constituents. It not only unjustly damaged my reputation and credibility, though that would be bad enough just to use your criteria again, Mr. Speaker, but clearly infringed in my privileges and prejudicially affected my ability to function as a member. I might add, Mr. Speaker, that the responses to the flyers in my riding, some of them called upon me to leave Parliament, to, in fact, even leave the Jewish community, as I had betrayed that community. Mr. Speaker, there could not be a more pernicious and prejudicial fallout from this damaging flyer as that which I have quoted, and I can tender the evidence to you, Mr. Speaker, for the record. In that regard, Mr. Speaker, I refer this House to the ruling of Speaker Fraser of May 6, 1985, wherein he said that, and I quote, "Anything tending to cause confusion as to a member's identity can impede a member in the discharge of his duties and constitute a breach of privilege." Let me quote the full statement of Speaker Fraser. "It should go without saying that a member of Parliament needs to perform his functions effectively, and that anything tending to cause confusion as to a member's identity creates the possibility of an impediment to the fulfilment of that member's functions. Any action that impedes or tends to impede a member in the discharge of his duties is a breach of privilege. There are ample citations and precedents to bear this out, and, Mr. Speaker, in your ruling today and in your previous ruling for the member of Sackville Eastern Shore, you have in fact contributed to these principles and precedents. Mr. Speaker, I bring up the issue of identity referred to in the ruling of Speaker Fraser, because in my case there can perhaps be no greater betrayal for people of the Jewish religion than the portrayal of one of their own as anti-Semitic, and that holds true as well for the member of Winnipeg South Centre. This accusation, as set forth in the 10%ers, is absolutely abhorrent. Constituents have reported even receiving this same mailing in their household more than once. Indeed, Mr. Speaker, they have asked how could I remain with a party that is anti-Semitic, or how as a Jew I could be engaging in such self-hatred. Again, Mr. Speaker, just some of the evidence respecting the prejudicial fallout and supporting the breach of privilege on its face. Mr. Speaker, even my wife, if I may make reference, herself a constituent, and who, as it turns out, received a flyer, 10%er, from the President of the Treasury Board, Mr. Speaker, felt compelled to write an op-ed for the National Post on this issue, again evincing the tumult and prejudicial fallout from these flyers. As I wrote, and it bears again on the question of privilege, quote, "This week I received the Conservative 10%er mailing from the President of the Treasury Board targeting assumed Jewish households across Montreal's Mount Royal riding. The mailing makes misleading statements about what the Liberals, including my husband, who has represented this riding for 10 years, did or did not do regarding matters of value to Jewish community members. It is presumptuous enough to assume that Canadian Jews only vote on these issues, regardless of concerns over health care, the environment, social justice, poverty, and that they vote as a bloc. In fact, so far as I know, no other religious community in our riding has been so targeted. But even on the Jewish values issue, the flyer is a series of false and arguably slanderous statements." I will end the reference here to her op-ed. I think it makes the point as to how this constituted a breach of privilege and the prejudicial fallout that it has caused. May I move, Mr. Speaker, to one other point, and with this I will close. There is this other point that may also impede a member in the discharge of his duties and constitute thereby a breach of privilege. I'm referring to how the targeting of Jewish residents was compiled and their reaction to being so targeted, and the concern of a violation of privacy in the creation of such lists. While I find it offensive enough that the Jewish community is reduced to a single-issue voting bloc by the contents of this flyer, I realize that this matter, standing alone, is not an issue of privilege, but what may well be an issue of privilege and breach of privilege, Mr. Speaker, and where members may be impeded in their duties, is where constituents may become hesitant to communicate with us if they feel their personal information is somehow being compiled and manipulated. The targeting of specific and identifiable communities on issues of pressing importance to them may not only be regarded by them as an abuse of parliamentary resources, which it clearly is, but one that violates privacy expectations as well as further impeding the member in the discharge of his duties. Mr. Speaker, the Leader of the Opposition has written to you as Chair of the Board of Internal Economy on the issue of 10%ers. Should the Board become seized of this matter, and should the motion be referred to the Standing Committee on Procedure and House Affairs, I would be prepared, Mr. Speaker, to go before to present this case study of 10% misuse and abuse and how it can have prejudicial and damaging effects on members and their ability to discharge their functions. Thank you, Mr. Speaker.
The Honourable Minister of Citizenship and Immigration is rising to say something on this point, this debate.
In response, Mr. Speaker, I understand that Your Honour has found in favour of a prima facie case of privilege with respect to the document in question, and the matter can and will be further reviewed at committee as it should be. I would, however, like to put on the record certain clarifications and corrections. First of all, Mr. Speaker, the document in question does not mention any member of this place. The document in question, first of all, let me say, Mr. Speaker, the respected and learned member for Mount Royal, for whom I have great regard, went on at length about supposedly targeting people from a particular community with this 10%er. Mr. Speaker, I will leave to the Board of Internal Economy the rules and regulations of distribution of parliamentary communications, including 10%ers. But I would point out to my learned friend that his colleague, the member for Eglinton Lawrence, circulated similar 10%ers, arguing that the official opposition's record on issues of concern to the Jewish community was superior to that of the government. And that 10%er appeared to have been distributed in areas with a particularly large Jewish population. So everything the member just said with respect to distribution of these materials in respect of the flyer in question could equally be said of the distribution of materials from a flyer from the member for Eglinton Lawrence. I therefore underscore at what is at best a basic inconsistency. I would secondly point out that the flyers in question from the member from Eglinton Lawrence were distributed several weeks before the flyer in question. Now, I didn't see any members of the government rising to their feet in complaining about matters of privilege because of the very similar communications tactic, effectively the identical communications tactic being used by members of the official opposition. So apparently for them, what's good for the goose is not good for the gander, Mr. Speaker. There should be one set of rules for official opposition MPs and another set of rules for government MPs when it comes to distribution of these 10% documents. Having said that, Mr. Speaker, to move on to some of the substance of the member's allegations, I find spurious and reject completely I think, terribly mistaken inference that he draws from the document in question that it alleges that he or any other member of this place is anti-Semitic. What the document says is that the Durban Conference was overtly anti-Semitic. Now, Mr. Speaker, I'm sure that members will be able to present copious evidence in support of that contention. I think that is essentially almost a widely accepted fact that's hardly contentious to allege that there were, to claim and that there were many acts of overt anti-Semitism, displays of overt anti-Semitism at the first Durban Conference. And it is furthermore a fact, not an opinion, that the previous government decided to participate at Durban 1, knowing full well about the charged environment of anti-Semitism at that conference. And so I can make these other points.
Yes, I have neglected to say to the Minister when he got up that we're on questions and comments following this. I wasn't sure whether the member for Mount Royal was on a point of order. It appears it was a speech consequent on the motion, which turned into when I put the motion to the House. So we're on technically a 10-minute question and comment period. So perhaps he'd like to put a question based on his comments, but he'll have an opportunity to say more later if he wishes, because after the question and comment period is over, we'll resume debate. So I invite the Minister to bear that in mind, given the length of his comment already.
Thank you for the clarification, Mr. Speaker. Well, in that case, I will present my substantive response in the next speaking slot. I'll just terminate with the question. First, an assertion, then a question. Mr. Speaker, I am disturbed by the suggestion that there was any accusation found in that document that any member is anti-Semitic. That is clearly outrageous, and the fact that the previous government decided to participate at Durban, knowing full well the atmosphere of anti-Semitism that surrounded it, and the member knows very well because he was there, is a statement of fact. And it's equally a statement of fact that this government was the first in the world to decide to withdraw from Durban 2 because of those concerns. Now, that, in my judgment, is a legitimate policy difference. And that's what public debate involves. But, Mr. Speaker, my question for the member is this. In the year 2000, former Minister of Immigration, my predecessor here in the Liberal government in the year 2000, said that my party was filled with, and I quote, racists, bigots, anti-Semites, and Holocaust deniers, close quotes. Now, this was not an argument over who attended a conference or the nature of a conference. This wasn't a conventional political debate about facts. This was truly the most vile kind of defamatory slur against tens of thousands of members of my party, myself included, and the millions of Canadians who voted for it, who she accused of being filled with, quotes, racists, bigots, anti-Semites, and Holocaust deniers, close quotes. I do not recall a single member of the Liberal Party standing up and condemning those remarks or even offering any kind of apology for those remarks. That member was promoted in the subsequent cabinet, Mr. Speaker. Now, I don't recall, perhaps this member, he makes a lot of comments that aren't on the public record. Perhaps he made some private condemnation of those remarks. But I would challenge him, Mr. Speaker, if he really wants to get into these issues, Mr. Speaker, and I hope he's aware of the consequences of this. If he really wants to get into these issues, Mr. Speaker, would he stand in this place and point out where any member of his party condemned the outrageous defamatory slurs of Eleanor Kaplan, a former Liberal MP?
Honourable member for Mount Royal. 3 minutes max.
Mr. Speaker, just want to say for the record that I did, in a public forum, condemn those statements. That's number one. And I believe there are, but the point is, Mr. Speaker, we are talking here, and this changing of the channel is trying to take us off the issue. What we are speaking about, Mr. Speaker, is a breach of privilege in the use and abuse of 10%ers, which tends to or has the effect of impeding the work of the members of Parliament. What a member said, which was not a 10%er, which deserved all the criticism in the world, is a very different issue. If that wanted to be raised at the time as a breach of privilege, it could have been raised as a breach of privilege. But the honourable member and no one else did raise it at the time because it was not the kind of character of the targeting of a riding with 10%ers with that kind of malicious statement. And let me say, Mr. Speaker, and the honourable member should know better, it was not just saying that Durban was anti-Semitic, Mr. Speaker. It was saying that the Liberals willingly participated in the anti-Semitic Durban one. That is the calumny to which we are objecting. And I want to tell you, Mr. Speaker, yes, the Liberals went there, as did every other government in the international community. That is not mentioned by the honourable member. And it is not mentioned that you just referred to Israel, that the State of Israel commended the Canadian delegation for condemning the anti-Semitism at Durban. So at least, Mr. Speaker, if you want to deal with facts, put facts. Don't continue the calumnies as a matter of public record. I find that outrageous that this statement is being continued and this calumny is still being poured into the public record. For shame.
Questions and comments, l'honorable député de Joliette.
The honourable member for Joliette. Thank you, Mr. Speaker. I'd like to join my voice to that of those who feel that the committee should be seized with the motion before us. We all agree here on the fact that the use of these 10%ers, these things we can send to our constituents to explain the debates that are underway and the policies that are at stake. But over the past few weeks, we have seen the government, the Conservative government, act in a way that has led to a catastrophe where our fellow citizens are asking questions about the very usefulness of these 10%ers, and I think that if we don't want to have to do away with this very important means of communicating with our constituents, then we have to immediately rectify the situation.
Now, in 1 week, you've recognised two questions of privilege with respect to 10%ers, and I think that this is bordering on demagogy. The honourable member from Mount Royal has a short response, perhaps? No.
The Honourable Minister of Citizenship and Immigration.
Thanks, Mr. Speaker. I hope not to be too long. I'll just finish where I began in questions and comments. Now, Mr. Speaker, I have to correct the record again. My learned friend from Mount Royal, whose dedication to these issues, of course, is legendary and who is a valued member of this place, I think just misspoke himself, and I'm sure he'll agree that he did so when he said the entire world community withdrew from the Durban 1 conference. That is factually incorrect. The State of Israel and the United States, exactly what he said. The State of Israel and the United States withdrew, Mr. Speaker. There were calls within Canada for Canada to withdraw. In fact, let me quote from an editorial that appeared in the Victoria Times Colonist, September the 5th, 2001. The continued presence at the conference of Canada's Secretary of State for Multiculturalism, now the member for Vancouver Centre, no longer serves any useful purpose and, in fact, helps to legitimize what has become a propaganda forum for some of the worst anti-Jewish hate-mongering since the Second World War, close quotes. That was the editorial board of the Victoria Times Colonist in September 5th, 2001. Now, why do I quote that, Madam Speaker? Simply to point out that the sentiment expressed in the 10%er in question was a commonly held view and continues to be a matter of legitimate public debate, not an accusation of anti-Semitism, but rather an accusation that the government made the previous Liberal government, of which the member was a part, made the wrong decision. They did not make the decision to withdraw from Durban. They made the decision to stay. And in the words of not the Conservative Party, but the Victorian Times Colonist and many others, to legitimize the Durban process, which was filled with overt expressions of anti-Semitism. So the point, Madam Chairman, is that what we have here is the discomfort. What we hear here is the reflection of the discomfort of certain members of the official opposition when presented with the bold facts of their own record. And so consequently, an effort to deflect from those facts by inventing charges of anti-Semitism, which of course are very explosive. Now, Madam Speaker, let me be clear. If I heard any member of my caucus or party accusing any party in this place or any member in this place unjustifiably of harboring anti-Semitic views, I would condemn it. If I thought this document in question made such an accusation, I would without hesitation condemn it. But it makes no such accusation. That is a completely trumped-up allegation, Madam Chairman. I understand the discomfort of the member opposite. I respect his views on these issues. I disagree, however, with the decision of the government of which he was a part to stay at Durban 1 and thereby to legitimize it. Now, he says members of his constituency and community are disturbed to think that his party's government did so. Well, I would say rightfully so. They should be so disturbed. And that's a natural political reaction, Madam Speaker. So I think we need to make a very clear distinction here between the trumped-up allegation that this document somehow alleges anti-Semitism, which it does not. The anti-Semitism of which it speaks is not anti-Semitism of a member of this place or of a party in this place, but rather of the Durban I Conference. And I submit that's basically an uncontrovertible fact. Now, it also goes on, Madam Speaker, by the way, I now have in my hand, the member goes on at great length about his consternation that a 10%er went to homes of Jewish Canadian voters. I have here in my hand a 10%er distributed by the member for Eglinton and Lawrence. Last I checked, he was a member of the Liberal caucus, entitled "Does Only One Canadian Political Party Support Israel?" And it goes through here criticizing Prime Minister Harper, the Prime Minister, for not attending, for not visiting Israel. It talks about the Liberal Party's voting record at the United Nations on Israel. It has a Canadian and Israeli flag on the top, Madam Speaker, just in case you think that there's any lack of subtlety here. Now, I'm willing to accept, perhaps the member has legitimate concerns about the distribution of one 10%er, but then I'm sure his concerns are equally directed at the 10%er distributed in a number of electoral districts by members of his own caucus. And he continues to be absolutely mute on that point, Madam Speaker. And this is the fundamental hypocrisy of the Liberal Party on these issues. Now, the 10%er in question, Madam Speaker, for instance, says that the Conservative government was the first government in the world to withdraw support from the Hamas-led Palestinian Authority. And on the other side, it says that the Liberals opposed this government's defunding of the Hamas-led PA and actually called for an increase in that funding. That's not a fact. It's not a slur. It's not an allegation of hatred. It's not any of those trumped-up, ridiculous overstatements that we're hearing from members of the opposition. It is, Madam Speaker, a fact. When the Prime Minister and this government announced that it was removing funding from the Hamas-led PA following the election of the Hamas government, or pseudo-government, in March of 2006, the member for, the then Foreign Affairs critic, and now former leader of the Liberal Party, said that the government should right away commit itself to maintaining the $52 million in help. The social problems in the territories are awful. In fact, Canada should do more, not less. So to cut $7 million would be a mistake. Now, I know that it's uncomfortable for that member. It's uncomfortable for him that some of his constituents now realize that his party wanted us to increase funding to the Hamas-led PA. But, Madam Speaker, that discomfort constitutes a legitimate part of political debate. Here's the record. This government, the first in the world to cut funding for the Hamas-led PA, the Liberal Party, in favor of that funding, demanding an increase in it. Is that somehow slurring members of the opposition by stating their record? I think that reflects a lot. Now, furthermore, the 10%er question says, on support for Israel, strongly backed, the Conservatives, quote, strongly backed Israel's right to self-defense against Hezbollah during 2006 conflict. I think that's an uncontrovertible fact. Prime Minister was much criticized for that, including in this place. On the other side, it says the leader of the opposition accused Israel of committing war crimes. That's not a slur. It's a statement of fact. It's a legitimate point of debate in public discourse. And what's our source? Well, when he was on le programme, l'émission Tout le monde en parle, the leader...
The Tout le monde en parle program, the leader of the opposition was just the member for Etobicoke Lakeshore, and he said, and I quote, I believe that war crimes were committed in Lebanon by Israel, end of quote.
And so what we have here, Madam Speaker, I submit, I say with great respect for that member, is a conventional political communication, the kind that we all engage in as robust participants in a public debate. This is not an allegation that that member or any of his colleagues are anti-Semitic. It is, and I would condemn any such outrageous allegation. It is, on the other hand, a legitimate point of information. And Madam Speaker, I would simply close by saying, if the member is that concerned about having to defend the record of his party on these issues, maybe he has to ask himself some questions rather than trying to conflate this into a false debate about anti-Semitism, which it is not.
Questions and comments? The Honourable Member for Mount Royal.
Thank you, Madam Speaker. I just want to say to the Honourable Member that if the flyer had condemned Durban 1 as being anti-Semitic, I would have no problem. Indeed, as I've said elsewhere in this House, I have written and spoken as much about that as any Member of Parliament in any parliamentary forum in the world. But the calumny is that in a flyer which compares the positions of Liberals and Conservatives, it specifically says that the Liberals willingly participated in the anti-Semitic Durban 1. The clear inference is to associate the Liberal Party with anti-Semitism. And let me just quote from what my wife wrote on this issue in response to that. And I quote, "On the Jewish values issue, the flyer is a series of false and arguably slanderous statements. The flyer accuses Liberals of, quote, willingly participating in the overtly anti-Semitic Durban 1 conference in 2001, by thereby associating the Liberals and my husband with support for anti-Semitism. That is condemnable on its own. But the facts are," and I'd like to be able to conclude it without being...
Order, please. Order. I ask all members to exercise some moderation, and those who can't wait till questions and comments to please leave the House. Otherwise, this member has the floor for now.
Thank you, Madam Speaker. And I continue with what was written by my wife in the op-ed. But the facts are that Erwin Kotler, along with representatives of the Canadian Jewish Congress and B'nai B'rith, remained at Durban 1 at the request of the Israeli and other governments to combat a poisoned atmosphere that descended into vitriol and hate. That, taking, as the honourable member did, this matter out of context regarding the representation, all, let me repeat so that there be no ambiguity and so that he does not misrepresent this again. All governments went to Durban because it was the first anti-racism conference in the 21st century. And we went there with the hope and with the view of condemning racism. But that conference turned into a conference of racism against Israel and the Jews. That's when we stood up. That's when we were asked to remain. That's what we did. And we were praised for having been the party that most condemned anti-Semitism at that Durban 1 conference. Thank you, Madam Speaker.
The Honourable Minister of Citizenship and Immigration.
Well, I would only ask the member to tell this place, Madam Chair, whether he agreed with the position of the government at the time. I have information that, in fact, he's introducing irrelevant issues, quite frankly. He's contending that the government of Israel asked the Canadian government to stay. I have information to the contrary, Madam Speaker. And if I'm not mistaken, the member opposite himself left Durban in disgust before its end and couldn't persuade the government of Canada to do the same. Now, I understand his frustration, Madam President, Madam Speaker. But what he's talking about are issues of normal public debate. Now, I quote again the Victoria Times columnist that the presence of the previous government, right to the bitter end at Durban, helped to legitimize what had become a propaganda forum from some of the worst anti-Semitism, anti-Jewish hate-mongering, since the Second World War. That's a legitimate point of view. It's my point of view. It's the point of view of millions of Canadians. It's the point of view of many of his constituents. And he's just uncomfortable with that fact, and I understand his discomfort, Madam Chairman.
Questions and comments? The Honourable Member for Moncton Riverview, Dia.
Thank you, Madam President. Madam Chair, it seems to me that the word uncomfortable came up, I think, at least 7 times in the minister's speech. And, I could ask him if he's uncomfortable with the fact that his own Prime Minister called my people, people from Atlantic Canada, people with a culture of defeat. I could ask him if he's uncomfortable with the member from St. Margaret's South Shore's comments regarding the people on the streets of Halifax. I could ask him if he's uncomfortable with the slurs against gays that a member from Saskatchewan posited on the public recently. And I'd love to know what his sincere response to that was. If he's such a defender of what is wrong, what is said by members that is wrong in his own party, where was he standing up when those things were said? One of the questions that arises from this motion, that arises from the ruling on the prima facie case of privilege, is the means by which a population in Canada was targeted. The member from Mount Royal made a very good point in making that a very big part of his point of privilege. I want to ask then, because I know he won't answer those first questions, how did his party target the people of Mount Royal? Are they willing to table the documents which prove the modus operandi of the service on the Jewish population of Mount Royal with their 10%er in the efforts of having a full discussion of what 10%ers, it is quite apparent, Madam Speaker, are doing to decimate, I think, the public process here?
Minister of Citizenship and Immigration.
Well, first of all, Madam Speaker, I am not a specialist in distribution of 10%ers, and that's not the issue. Secondly, I think these are issues of interest to all Canadians, not just to Jewish Canadians. They're certainly of interest to me. I've spent much of my parliamentary career as a non-Jew working on these issues, Madam Speaker. Thirdly, I presume the answer to his question is that the means used to select the constituencies and areas for distribution of this 10%er were precisely the same as the 10%er with the Israeli flag on it, distributed by Liberal members of Parliament on the same issues, Madam Speaker. You know, sometimes the fog of hypocrisy is so thick in here, people can't even hear. Madam Speaker, the 10%er in question was distributed after a 10%er on issues of concern to the Jewish community by members of the official opposition. If you'd like an investigation into how that was distributed, I suggest he speaks to people in the Liberal Research Bureau, Madam Speaker.
Questions and comments? Resuming debate.
Oh, questions and comments. Okay. The Honourable Member for Scarborough Rouge River.
Yes,
because... excuse me. Okay, go ahead, sir.
Because the Honourable Minister who has just spoken raised the matter of a 10%er in the riding of Eglinton Lawrence, I thought it was worthwhile making a distinction that that particular 10%er was a 10%er from the member himself to his constituents. It was not a regrouped or party-type 10%er. And no, I'm actually looking at it right here. However, I wanted to put that on the record, and perhaps the minister could, maybe he doesn't think that's a difference. But I think in this case, Madam Speaker, we are dealing with a party-generated, regrouped, multi-distributed, printed, duplicated, distributed 10%er, as opposed to a communication by a member of Parliament to his or her own constituents.
The Honourable Minister.
Yes, Madam Speaker, I am aware that, for example, the 10%er in question issued by the Liberal Caucus group was issued in the riding of Thornhill and other constituencies in that part of the Greater Toronto Area, Madam Speaker. So I'm simply saying that this is really quite ridiculous. That members opposite are trying to make a capital case out of a conventional political communication using the same tactics and distribution that they use all the time, even on the same set of issues, where basically uncontroverted facts are presented that are matters of conventional political debate. And Madam Speaker, if the Liberal Party is not comfortable with the fact that their leader accused Israel of war crimes, if they're not comfortable with the fact that they have members of their caucus who called for the delisting of Hezbollah, if they're not comfortable for the fact that they called for an increase in funding for the Hamas-led PA when we eliminated that funding, if they're not comfortable with the fact that they decided to stay at Durban 1 till the bitter end, after the withdrawal of other countries, in so doing, legitimizing the process in the words of the Victoria Times columnist. If they're not comfortable with the facts, I say, too bad.
Resuming debate, the Honourable Member for Scarborough Rouge River.
Thank you, Madam Speaker. I didn't expect to get up that quickly in the debate here, but I feel quite engaged in this issue. I want to suggest that the issue is partly that of libel or a near libel, and partly that of the use of the 10%ers. If this particular issue had happened out on the street, disconnected from Parliament, it might or might not give rise to a libel or slander action. But because it involves material prepared and printed, or at least printed by the House of Commons, distributed through the post office, through House of Commons means, it becomes a parliamentary matter. And the issue has actually been lurking. Perhaps I am one of those who actually considers it a kind of an ugly administrative issue for Parliament, not a happy issue. And that part of it is the way the parties have now taken the privilege of individual members to communicate with constituents and turned it into a massive political communications mechanism involving the use of tons of paper and millions of dollars. And I remember when I first came to this place, I think I can remember, and I remember a rule around here that did not allow us at the time when we communicated using House of Commons facilities to communicate with our constituents. We weren't allowed to use our party symbols. We weren't allowed, I don't think we were allowed to even use the name of our party. And I recall getting kickback one or two times on things that I wrote to my constituents where I used the name I used the word liberal. And it came back crossed out, so you can't use it. So eventually, I actually kind of thought it was a pretty good rule, and didn't really try to abuse it. But over time, I think the House of Commons staff had difficulty enforcing the rules, and they eventually gave up. And the case was made that the House of Commons should not be a censor of what MPs were sending to their constituents. And so party affiliation came to be accepted in communications between the members of Parliament and their constituents. So that is the second big part of this privilege matter that we're now debating. The way in which the use of what we call 10%ers has evolved from being a communication between an MP and his or her constituents, and it's gone way beyond that now. It's gone way beyond it, and in a sense, the parties in the House, and in this case, conspicuously by the government party, have essentially co-opted that and turned it into a kind of an ugly vehicle of a libel or near libel. So I want to address that piece first, and I suppose I should be fair and say that I haven't really concluded that this is fully a libel, and I realize I can say things here in the House of Commons and not have to account for it out on the street. So I use the term in quotes. But as I read this particular 10% that we're discussing here, I just couldn't help but think that I, as a member of the Liberal Party, was being labeled as an anti-Semite. And just to use the words, the words are right there. It says, on fighting anti-Semitism abroad, the Liberals willingly participated in overtly anti-Semitic Durban 1. Now, I am a Liberal, and this essentially says that, and that's why I call it a libel or near libel. To my knowledge, I have never done or said anything, even thought anything that was even close to being anti-Semitic. And this particular 10%er, clearly on the face of it, this is designed by professionals. It just didn't happen. It was carefully designed to convey a message. And I'll go back to what I said further. This 10%er vehicle is no longer just a communication from an MP to constituents. It's actually used by parties, and it involves design and costs of design, careful design, involving all kinds of resources, millions of dollars, and all because it's political. It's become a political vehicle, no longer an information vehicle. It's political. And on this document, there's a picture of the Prime Minister, and it's kind of sad, really, Madam Speaker, that a document that suggests that I and my party are anti-Semitic it stands over a picture of the Prime Minister with a big smile. Now that is, well, let's just say I'm not happy with that. And there is no member of the House who could be happy with that. Now, having gone through this, the conservative operators behind the scenes, because it should be noted that probably no member of the House here has participated in the design of this or other 10%ers. And the same is probably true of the 10%ers that come out from all the other parties, because at this point in time, all the political parties mail out these 10%ers. And, you know, in this particular case, this particular 10%er, and I don't know who takes authorship. I don't think that's been determined. The member who moved the motion here doesn't know who actually designed or wrote this. It appears as though the minister who just spoke is taking some ownership of it. He says it's just facts. It is not facts, it's political propaganda, and it purports to rewrite our history. It purports to rewrite Canada's role at Durban 1. Now, with 20/20 hindsight, we can all see how ugly Durban 1 was. But you don't know how ugly it was until it was over. Before it started, all the major countries of the world were participating. As the thing went on, there was a whole level of discomfort developed as a number of representatives from different countries began to express their anti-Israeli views. And I say anti-Israel. I don't want to get into anti-Jewish or anti-Semitic, but it was clearly anti-Israel. And that became a huge problem for Durban 1, and it was a huge problem for Durban 2, and it was a huge problem for everybody. But I think it is simply wrong, and it attempts to rewrite history and malign everybody who was in Durban 1 on day 1, that somehow they were all willingly participating in an anti-Semitic exercise. And I wasn't there, but my government, and this essentially maligns all Canadians. It says our government was participating in an anti-Semitic, openly, what's the word? Overtly anti-Semitic Durban 1 exercise. Our government, Canadians. I mean, I don't think the minister realizes the significance of that type of an allegation, not designed by him, but by those cutesy writers in the back rooms of the Conservative Party, writing cute stuff that they can send out politically to Canadians at no cost. And there are 3 parts to this, and the minister can say, oh, they're just little facts, but everyone knows in this place you can take a fact in isolation and twist it to make it look different. And the overall impact of this 10%er was exactly what has been described by my colleague from Mount Royal, exactly as the Speaker has accepted the initial application from the floor here. and the impact is still the same. It's not just a collection of random facts. It's just not a little letter from an MP to his or her constituents. This is a political diatribe, one that's wrong, misleading, and as I say, it is close to libel. It's near libel, and I'm saying that it libels me. It libels me and my party. I'm a part of the party, and if it just said that we turned right instead of turning left, then you could say, well, okay, maybe. But the subject matter here is anti-Semitism. And in the whole history of the human race, going back, not the whole history, let's go back 2,000 years, there is actually, we could probably make a list of some very ugly things in terms of man's inhumanity to man. And we would find on that list anti-Semitism. Everybody knows that. It is still a problem in our societies. Wherever it shows its ugly head, we condemn it. It shouldn't have a chance of existence in our country or any country. And yet this 10%er alleges it. It is what is alleged, which is just important as the vehicle that was used to allege it. And in so doing, and I want my remarks to be taken, I hope that when the committee looks at this, that they will be looking at both the issue and how it was put in the design of this 10%er, but also look at the 10%er thing. Because I want to say here today that the use of the 10%ers generally, the way it has evolved, is bringing the House into disrepute. It brings members into disrepute. Members are relied upon by their party whips to turn over, to allow the party whips to use the 10%er privilege so that the whips can combine all of the mailing rights and mail this stuff out by the thousands or millions, essentially for no cost to the party. And members, in a sense, their privileges are being co-opted by the parties so that they can use this. And just for the record, as I understand it, the cost of this is all borne by the taxpayer. Because it's not a normal type MP communication, I think the breakdown is the parties themselves pay for the postage, but Madam Speaker, you know how they pay for it? They pay for it by the pound. It's weighed. There's an employee of the post office that actually works now in the House of Commons precincts, and his job, I know this because I spoke with him, is to weigh the 10%. They weigh them. They don't put stamps on them. They don't count them. They mail it by, I guess it's the kilogram. They mail them by weight. They're so voluminous. And the party whips pay by the pound, by the kilogram, to send the stuff to the post office. Now, who pays for the printing? That's paid by the House of Commons. That's paid by the House. And I understand that this fiscal year they're short of money. Why? Because our parties in this House have gobbled up the tens of millions of dollars already allocated for this, and it's gone over budget. And oh my goodness, what a terrible thing if our parties were not able to send out these pieces of junk mail. Now, if they were just junk mail, the taxpayers would be irritated. But when they're libelous, when it contains a libel, they should be angry. And when it contains a libel related to one of the more ugly continuing scourges on the list of man's inhumanity to man, that is anti-Semitism, they ought to be doubly angry. And I think our House should be angry, and I think we've got to make changes and put an end to it. And the way to put an end to it is simply to remove the regrouping. I don't want to impair any particular member's right to communicate with his or her constituents. We might even allow a mailing or two beyond the constituency. I know in some urban areas the ridings are close together, and who knows where the political boundaries are. So you might want to mail something to all of East Side Ottawa. But the point is that I think the committee, in looking at this, should be cognizant of the fact that the 10%er privilege that we all have has now been taken over by our parties, and there's a whole team of professionals writing and zinging these stuff around the countries by the kilogram, and our constituents are receiving it and thinking, boy, who's paying for all this junk mail? Who's paying for all this junk? And the answer, Madam Speaker, is the constituents are paying. The taxpayer is paying. So I'm going to wrap up here. I think I've made my views known, but I couldn't be stronger in my view that this particular 10%er went way over the line, was libelous in a manner that brings the House into disrepute and the system of 10%ers in disrepute, and I think it has to be fixed. Thank you, Madam Speaker.
Questions and comments? The Honourable Member for Nepean Carleton.
Thank you, Madam Chair. I understand that this is a difficult issue for a lot of members. When issues like the Middle East are debated in the House of Commons, issues on which the Liberal Party and the Conservative Party take opposite positions, the debate can sometimes become heated. So my goal is to unpackage some of that disagreement in the hopes that we might find common ground. The distinction is that this current Conservative Prime Minister led the entire world in walking out on the Durban 2 hate festival, because we knew that it was an anti-Semitic and racist event. And because of the leadership of this Conservative Prime Minister, the rest of the world followed Canada in acknowledging that. Country after country followed this country, our Canada, and this Prime Minister in making that decision. By contrast, the Liberal government decided to stay at the Durban 1 conference, even when the hideous facts of that conference became apparent. Now, the member for Mount Royal has said that that the Liberal government could not have left because they didn't know what was going on, and they had to stay until the end to find out. But that didn't stop Israel and the United States from doing the courageous thing to walk out. Now, I understand it was easier for the Liberals to stay at Durban 1, but sometimes courage is difficult. And I'd like to commend the United States and Israel, who made the right decision to walk out at that conference. At the time, the Conservative predecessor parties called on the Liberals to leave, but they refused. In the latest conflict with between Israel and Hezbollah, our government stood with Israel against terrorism. The Liberal leader said Israel had committed war crimes. That is the record, and the member for Mount Royal cannot change the facts, nor can he silence those who are making those facts known. Thank you.
The Honourable Member for Scarborough Rouge River.
Well, I would just invite the member to not change the channel. The issue is what was in the 10%er, and what was in the 10%er was Durban 1. And it says that Liberals willingly participated in overtly anti-Semitic Durban 1. And it would have been a lot easier to walk out of Durban 1, to be honest with him, in my view. A lot easier to walk out with some of our allies, the few that did walk out. But some of our allies prevailed upon us to stay, to have someone at the conference with some hand on the tiller, somebody still there able to participate. And so I invite him not to change the channel to deal with the issues involved in the 10%er itself.
Questions and comments? The Honourable Member for Windsor-Tecumseh.
Yes,
I don't intend to give a speech here, Madam Speaker, and I wish other people would follow that policy. But a question. It seems to me around the whole issue of 10%ers, and I hope that the committee, when reviewing this, will look at it from this perspective. There's an issue of, the circulation of 10%ers, that is, should we continue to allow the regrouping and the widespread circulation? That's one issue, or should we either limit or prohibit? The other issue with the 10%ers is content. And that, I think, is more pertinent to the this 10%er that was sent out in this case, not only to the member from Mount Royal, his riding, but to a number of other ones. And I wonder if my colleague could just comment as to whether he agrees that that is where the debate should be going, that is, both those issues should be addressed, and any comments he may have on restricting the material that could be contained in 10%ers, not only across the whole country, but in individual ridings.
The Honourable Member for Scarborough Rouge River.
Well, I don't have too many solutions. The member quite fairly raises issues involving the rights of members to communicate with their constituents. I think we ought to max that. I think we ought to repress or contain the ability of parties to use those privileges. And yes, I do agree with them fully that the big issue here is the content of the 10%er. That's what's brought it to the floor here. But I think that as the committee deals with this, should the House vote in favor of the motion, that they should deal with the structural issue of the regrouped 10%ers.
Questions and comments? The Honourable Member for Mount Royal.
Thank you, Madam Speaker. The issue is not the positions taken on matters relating to Israel and the Jewish community. I don't mind if the Conservative Party sets forth the positive positions that they have taken with respect to Israel and the Middle East. I don't mind if they want to take credit for walking out on Durban 2. I just might add parenthetically that our party supported that and supported that publicly. That's not the point. The point is that rather than make statements, truthful statements, about one's own party's record, one is making malicious and false and slanderous statements about another party's record and the members in that party. The issue, and it's not only that, Madam Speaker, really what it gets down to, that the issue is the use and abuse of 10%ers using public funds, targeting a Jewish community to make these false and misleading and slanderous statements. That's what the issue is, and that's why the Speaker found a prima facie breach of privilege, because it tended to prejudice also the work of the member in his riding and thereby diminished his reputation and standing. Those are the Speaker's criteria. That's what we should be debating as applied to the facts and not positions on the Middle East. That's changing the channel and that's misleading the public once again. They should apologize for their statements rather than continue to mislead the House.
The Honourable Member from the Scarborough Rouge River.
Well, there aren't very many occasions when I can improve on the remarks from the member for Mount Royal, given his other job as he's recognized around the world as a leader in human rights and as a lawyer, and he's a teacher to boot. So I really can't improve on that. I do agree that the focus, perhaps my own remarks may have gone a bit further afield in looking at the whole 10%er issue, the broader distribution issue. But I think the member for Mount Royal has brought appropriate focus to it. And at some point, depending on how the House votes and the committee deals with this, there may be room for an apology. But I would hope that the process would allow the House to come together a little bit on the problem, because it's not going to get any better as time goes on. It just seems to be heating up over the months, and we got a problem we all have to deal with here.
Questions and comments? The Honourable Member for Edmonton Millwood Beaumont.
Very good. Well, thank you, Madam Speaker. And I'm having a little trouble with the level of hypocrisy in this debate. I have a 10%er that came to my riding from the member from Scarborough Pickering East under the title "A Track Record of Hypocrisy." Now, the honourable member used the words political machinery referring to us, and I think cutesy graphics, talked about cutesy graphics or something like this. And this 10%er coming from this Liberal member, there's a nice big Liberal logo on the bottom, and in place of the postage stamp, a picture of Lester Pearson. And last I recall, the honourable member from Pickering Scarborough East is not also the honourable member in my riding. I am. And and I don't know how he distributed these, but unless he came to my riding and distributed them door to door, I believe that he probably used the mail system to send them out as well. But coming back to the topic at hand here, which is this 10%er, I have a couple of questions regarding this 10%er. Now, there's been a couple of members talk as though they were specifically named in the document. So
I apologize to interrupt, but I would like to give the honourable member time to respond, and there's less than a minute left. The honourable member for Scarborough Rouge River.
Yeah, I concede, as will all members, that all four parties, recognized parties in the House, send out 10%ers. And most of it is designed by the parties. By professionals, and they are filled with facts, political invective, party logos. I get them I receive them at my apartment in Ottawa from different parties. Let's just say different parties. I don't have to. Well, all the parties do it, and this is an issue for us. But in this particular debate today, as my colleague from Mount Royal points out, the issue is the content of this one 10%er that directly, indirectly, by innuendo, alleges that my party has participated in an anti-Semitic exercise. And that is grossly unfair. There's no ability for a member to rebut these types of allegations. And I don't like this scenario at all. It must be fixed, and I'm quite sure the Procedure and House Affairs Committee will look at that as they review this.
Okay. Resuming debate, the honourable member for Nepean Carleton.
Thank you very much, Madam Chair. Now, the member across the way from Scarborough has said that this is a discussion about the contents of the particular 10%er in question. And, of course, the 10%er in question refers to policy differences on the Middle East. And as has been pointed out in the past, Madam Chair, there is a vast disagreement between the Liberal Party and the Conservative Party on the question of the Middle East. We mentioned earlier the issue of the Durban I conference. The Prime Minister, under this Conservative government, made the principled decision to pull Canada out of the Durban process before it even began, because it became clear to this government that it was going to be a forum for hatred and meanness. The rest of the world followed this Conservative Prime Minister in making that decision. That was a very sharp distinction from the way in which the previous Liberal government behaved at the similarly odious Durban I conference. And, Madam Chair, I'll quote what the Victoria Times columnist said at that time. The continued presence at the conference of Canada's Secretary of State for Multiculturalism no longer serves any useful purpose, and in fact helps legitimize what has become a propaganda forum for some of the worst anti-Jewish hate-mongering since the Second World War. Now, it was clear that was on September 5th, 2001. Now, it was clear at that time that this conference was not worthy of Canada's participation. But the previous Liberal government did the easy thing and stayed at the conference, lent Canada's legitimacy to that conference. Our party disagreed with that decision. And Israel, the United States of America, took the courageous position to pull out entirely. The member for Mount Royal has made a very curious claim that Israel wanted Canada to stay at the Durban 1 conference. I've seen not one shred of evidence that that is the case. And in fact, it would seem to be explicitly contradicted by the fact that Israel itself pulled out of the conference, and so would have no reason to advise others to stay behind. Madam Speaker, I move on now to the subject of the conflict between Hezbollah terrorists and our democratic allies in Israel in the summer of 2006. During that conflict, this conservative prime minister stood with our democratic allies in Israel and backed them up when it was very difficult to do so. By contrast, the current liberal leader used the occasion to accuse Israel of war crimes. Members of the Liberal caucus marched in the streets with Hezbollah flags blowing in the wind behind them. And one Liberal MP even said that that was a good time for Hezbollah to be legalized in this country. And that was the position of the Liberal Party. And I respect the right of the Liberal Party to take that position. I disagree with it, but it is wrong for the member for Mount Royal to subsequently demand that others be silenced when they point to those facts. On the subject of Hezbollah, I would like to take a moment to recognize the Minister of International Trade who is here, the member for Okanagan-Coquihalla. He is here in the chamber, and when he was in the House of Commons as a member of the opposition, he stood in the House of Commons and relentlessly called upon the Liberal government to back down and ban Hezbollah as a terrorist organization. Exactly. Now, there was tremendous Liberal resistance to his call. The Liberal Party argued that Hezbollah was a social program and that it needed to remain legal. But because of the relentless efforts of the member for Okanagan-Coquihalla, who is currently serving as the Conservative International Trade Minister, the Liberals were reversed and Hezbollah was banned. Now, Madam Chair, I think that we continue to look at the record of the Conservative government. We will see that this government has led the way in the global effort to defeat terrorism. And our position has been dramatically different from those of the Liberal Party. Now, these are facts, Madam Chair. They are irrefutable as facts. The member for Mount Royal might not like these facts, but he cannot change them. And he cannot suppress others from making them known. So, Madam Chair, I thank you for the occasion to speak in this House, and I honor the great tradition, Canadian tradition of free speech, where members of all parties can contribute their point of view. And I humbly suggest in conclusion that as opposed to trying to suppress the facts about his party, that the honourable Liberal member for Mount Royal might renounce the positions that his party has taken and commit that he and his party will start anew on these issues. In that spirit of renewal, I think we could all come together. Thank you.
Before proceeding to questions and comments, it's my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Laval on Labour, l'Honorable Député de Cap.
The Honourable Member for Cape Breton Council on the Royal Canadian Mint. The Honourable Member for Willowdale on Government Communications.
Questions and comments. The Honourable Member for Western Arctic.
Thank you, Madam Speaker. And, I'd like to enter into this debate. I think quite clearly that the debate, as the Honourable Member from Mount Royal has said, is about the nature of 10%ers and the content within it. And of course, you know, in my riding as well, I mean, I've had 10%ers from Conservative MPs in the last while that have accused me of voting in certain ways when I never had the opportunity to vote on those issues at all. And to my mind, the patterning of this behavior on the part of the Conservative Party and its members of Parliament is really fundamentally what's going on here. This behavior is, as we're starting to see, unacceptable, that information given through the auspices of the House of Commons must be accurate. That's the kind of ruling that I've heard today. It's the kind of ruling that the Speaker has made on other 10%ers, and I suppose we could continue to bring these up one by one as points of privilege and occupy the time of this House in debate that doesn't really have to take place if we can see that the parties can agree that these 10%ers must be used for legitimate purposes, for purposes that are not slanderous or that do not contain non-factual material. And to my honourable colleague across, can he not see that there's an importance here in coming out with a position from his party as well as every other party to ensure that this does not happen again?
The honourable member.
Madam Chair, the 10%er in question was strictly factual, and that is the approach that this government takes. Thanks.
Apologies. The honourable member for Mount Royal on questions and comments.
Yes, Mr. Speaker, the member for Nepean Carleton speaks about his party's position on the Middle East. He argues that it's more favourable than the latter of the Liberal Party. He's entitled to that view. That is not the issue, Madam Speaker, before this House. That is not the ruling of the Speaker finding a prima facie breach of privilege. The issue before this House, and the member for Nepean Carleton never referenced it at all, is the use and abuse of 10%ers targeting identifiable religious minority and using misleading, false, pernicious and slanderous content in that 10%er, having the effect, as the Speaker found in his ruling, of damaging the reputation and the credibility and the standing of a member of this House. That's what we are debating, Madam Speaker. That's what they are ignoring. That's how they're changing the channel, and they are in fact continuing to abuse this House, to abuse the processes of the breach of privilege debate in order to bring in misleading and irrelevant references to debates on the Middle East. We're not debating the Middle East. I'm prepared to do that any time outside this chamber. We're talking about false, misleading, pernicious, slanderous 10%ers targeting a community and prejudicially affecting a party, the Liberal Party, and each and all of its members. That's what the issue is all about, and that's where the issue of facts come in. False, pernicious, misleading, defamatory statements made in that flyer. You can't escape it. It's there on its face. The Speaker made a ruling, and I would like the honourable member for Nepean Carleton to acknowledge that.
The honourable member for Nepean Carleton.
I acknowledge that the honourable member says that his credibility has been damaged, and I respectfully remind him that that is not the result of a 10%er, but rather the result of the positions that his party has taken.
Questions and comments? The honourable member for Moncton Riverview, Dieppe.
I'd like to ask the Prime Minister's Parliamentary Secretary a couple of questions. You know, it's ironic, he's speaking with this vein in that he made such disparaging comments himself about Aboriginals for which he was forced to apologize. So he knows all about saying something and then having to backtrack. I want to ask him if he understands what defamation is. I know that he has no legal training. I know he went to various universities before making career politics and drive-by smear his life's blood. But does he understand that defamation includes publishing a comment, coupled with a damaging comment, coupled with a lack of a qualified privilege, which this publication would not have, in distributing non-truth? Does he agree with the words of the Speaker, who wrote at 3:16 this afternoon that the critical role that context played in shaping the cumulative net effect of the words was damaging?
The Honourable Member for Nepean Carleton.
I believe the matter is that the facts of the Liberal Party's position on the Middle East are damaging to the Liberal Party. But that is not the responsibility of anyone other than the Liberal Party itself.
Questions and comments? L'Honorable.
The Honourable Member for Ottawa Orleans. Thank you, Madam Speaker. I've been following the debate very carefully this afternoon, and I understand full well just the anguish of the member for Montreal, because this member has an unblemished record. But his anxiety, his anguish exists because various members in his party are not like him, especially his leader. And to bring the question back to today's debate, I'd like to put a question to the member from Nepean Carleton.
10%ers from members of other parties, particularly members of the official opposition, and I find those quite reprehensible. And I avoid sending them into their constituencies. I wonder if the honourable member for Nepean Carleton has received in his district 10%ers signed and approved by members of other political parties. Thank you.
The Honourable Member for Nepean Carleton.
Yes, I believe that some of our colleagues in the Liberal Party have sent 10%ers that Canadian soldiers have found disparaging of their vocation. Another member of the Liberal caucus was forced to apologize for a regrettable 10%er that she sent, in which she made references to body bags, and I know that the Aboriginal community was very offended and hurt by that particular 10%er. Madam Chair, now we learn that the Liberal Party is using the issue of Taliban prisoners as part of its efforts to raise money at the expense of the reputations of our soldiers and diplomats who are serving so courageously abroad. So there have been instances where political parties have misused their mailing privileges and have misused they've sent out literature that is unacceptable. I'd like also to recognize the very good work of the member for Ottawa Orleans in serving his constituents. He has been a real model of hard work and of the parliamentarian spirit in the way that he serves people around this House, and I think that members of all sides would agree with me that he is an inspiration to his community and that he acts as a real leader in this House of Commons. I think we can give him a round of applause for that.
Resuming debate, the Honourable Member for Vancouver Quadra.
Thank you, Madam Speaker. Well, I'm sad and I am disappointed to be rising to speak to this issue because this regrettable set of 10%ers and this breach of privilege through misleading, false, pernicious, defamatory information targeting a religious community is so damaging in so many ways that it is a sad day that it was a very sad day when these were sent into our communities, and it's a sad day that we have to hear from the members opposite a defense of this completely outrageous and undermining project. These 10%ers undermine people's trust in government. They feed into the very kind of mistrust that the public has of their elected representatives. They undermine democracy. We're at a time when barely 60% of the public bothers to vote. Why? Because they do not trust their political representatives. And, Madam Speaker, in my view, every parliamentarian should be aware at every moment of their work that it is our job to restore that trust, because that means restoring our democracy. And to see the members of that House deliberately and sneeringly undermine the public's trust with this kind of divisive, totally distorted smear piece is very sad for our democracy. These 10%ers, I think the previous speakers have pointed out where the information is loaded with mistruths, where it's propaganda of the worst kind aimed at a religious group. Those in itself are more than disappointing. They're outrageous. To then use the public's dollars to do that certainly is, I don't want to say icing on the cake, because there is nothing good about this. The undermining of the public's trust is a huge breach of the contract that we have with the public. So to use the public taxpayer dollars for this is completely and utterly unacceptable. And Madam Speaker, this is part of a pattern with this government. This is a government that talked about Kyoto and climate change as being a socialist plot to take money out of people's pockets, and then turned around and now pretends to care about climate change, though we know that with an absence of a plan in 4 years, they actually don't. So hypocrisy, undermining the public's trust. These 10%ers are an illustration of hypocrisy that undermines the public, that undermines the public's belief in their...
On a point of order, the Member of Parliament for Mess.
Thank you, Madam Speaker, and correct me if I'm wrong, but the issue of climate change is not the content of the 10%er in question. So I would certainly instruct, well, we're talking about a specific 10%er and its content here in the debate, Madam Speaker. Now we're off talking about climate change. I would at least ask you to advise the member to stick to the discussion at hand. Thank you.
Order, please. Order. I have heard members from both sides of the House wander considerably from the subject close at hand, but I would urge members to come back to the point of these 10%ers, and specifically as raised from all sides of the House.
Thank you, Madam Speaker. I'm using that example to underline the hypocrisy of these 10%ers, and I would point out that the Parliamentary Secretary to the Prime Minister spoke on a range of issues that was not directly related. And, Madam Speaker, one of the things that these 10%ers do to undermine the members, the Liberals that are whose reputations are imputed here, and the particularly the member who has been speaking on this from Montreal, the undermining of the fight against anti-Semitism is what makes me beyond disappointed but angry. The members opposite, including the Minister of Immigration, went to London under the leadership of a Liberal of a Liberal member of Parliament to go to a conference to fight anti-Semitism. And out of that came an agreement that anti-Semitism is far too important to be a partisan issue, that we need to fight it together. This 10%er is completely the opposite message. This 10%er says we will use anti-Semitism as a partisan issue, as an issue to wedge Canadians and to drive dissension in the Jewish community, because there are certainly differences of opinion on the appropriateness of the 10%er. So having slanderously defaming materials after having agreed that this issue is too important to be partisan on undermines other activities of this House. And one of those activities is the inquiry into anti-Semitism, of which I am a panel member. To have this kind of materials go across the country, sent into opposition members' ridings, targeting Liberal opposition members, and at the same time expecting the public to believe that this inquiry, for which eminent scholars are coming from London, from places around the world to give testimony into anti-Semitism, makes a mockery, unfortunately, of the inquiry's work. And it is very difficult to hold up our heads as a country in which anti-Semitism is so important that it's a nonpartisan issue, that we are going to inquire into the incidences and the causes so we can help to reduce and we can combat anti-Semitism, when if at the same time this House allows this kind of breach of privilege and this kind of defamation of the Liberal Party, this kind of targeting of a religious community, these kinds of statements which are deliberately misleading. So, Madam Chair, I would really encourage the members on the opposite side of the House, who are part of the Canadian Parliamentary Committee combating anti-Semitism, to think about how they hold their heads high as we bring people in from thousands of miles away to talk to us about this very important issue, this issue of human rights, this issue of racism, this issue that is worth anyone with humanity, anyone with compassion, anyone who cares about human rights, to have this kind of breach of privilege going on at the same time undermines the work that we're doing in that inquiry, and that's very discouraging. I know members spend hours a week on this issue because they care about it, because racism is not acceptable, because anti-Semitism is not acceptable. And if Canada can't show a way to be working together with dignity on this issue, with determination on this issue, Canada has a parliamentary group of some 20 people who are working very hard to combat anti-Semitism. And if on the side some of those members believe that it's acceptable to be targeting members of the opposition with this kind of pernicious taxpayer-funded garbage, I find that very unfortunate. And I know that the public, when they get this kind of literature which is clearly distorting, clearly untrue, clearly taking out of context, smearing honorable members who have a life's work of fighting anti-Semitism, when the members of the public see this, what must they think about this Parliament? What must they think about our commitment to fighting anti-Semitism together? Parliamentarians went to London, most of them on their own dime, to attend a conference. In the UK, parliamentarians worked together on an inquiry to look into anti-Semitism, and it was a very important piece of work that came up with very important conclusions, that anti-Semitism was not being tracked properly, that it needed to be tracked so we could tell what's happening and we can prevent it. And never did we hear a breath of implication that those members were undermining and smearing each other on a side initiative like this. Madam Speaker, that's simply not the case. So this makes it an embarrassment to be a Canadian, just as it's an embarrassment to be a Canadian when we have a government that blocks action on climate change. So, Madam Speaker, this is an example of complete hypocrisy, that on the one hand you have a Minister of Immigration who goes to London under the leadership, mind you, of our Liberal member from Mount Royal, and then comes and sits in this House and defends this kind of garbage. Unfortunately, that then reflects on the quality of the Executive Council of the Government of Canada. And I find that very unfortunate, because what we all need to be doing is restoring the public's trust in their political representatives. So, Madam Speaker, this is just one of a number of examples where hypocrisy, whether it's accountability for public dollars is the claim, and then public money spent on advertising, failed economic policies, whether it's we won't tax income trusts and then turning around and doing just that, the kind of hypocrisy that this represents with these flyers going into people's front doors and into their mail slots, people that may not be getting their information may not have access to thoughtful information on these issues, people that may not be reading the newspapers or the websites and getting both kinds of views on it. People that think because they see the Prime Minister's picture on a flyer that what's on there must be true. And there are many people like that out there across Canada. People seeing the Prime Minister's picture and thinking this stuff must be true. Well, that is a huge undermining of the public trust, and each and every member opposite should be embarrassed by something like this, with these kinds of slanderous statements, falsehoods, misrepresentations, and out-and-out defamatory claims. So, Madam Speaker, I'll just conclude by saying it's very disappointing to me personally, who in good faith has been working with Conservative members, Bloc members, and NDP members to combat anti-Semitism. And it does make me question, next week, should I resume my role as a panelist on the panel of inquiry into anti-Semitism that was set up under the principle that this issue is too important to be partisan? That's exactly what all of the parliamentarians involved in that issue decided. This issue is too important to be partisan. Let's all work together on this. Let's put partisanship aside on the issue of anti-Semitism. Now, does that make sense to the members opposite? It certainly did to the members who came to this inquiry panel, be part of the inquiry panel and part of the parliamentarians, the Association to Combat Anti-Semitism. And I will point out that the Minister of Immigration is a member of that group. This is a member of a group that said this issue is too important to be partisan with. So I would ask the Minister of Immigration and the members opposite, is this no longer an important enough issue to be nonpartisan? Do you believe that this issue is just one more thing to use divisive partisan tactics on? Is this human rights? Is this racism? Is this disgusting, historic, human failing and weakness that we call anti-Semitism? Does this not matter to you anymore? Is this not one of the things that you think is worth countering? Because how can anyone take you seriously? How can anyone take the members opposite seriously when this kind of drivel goes out to neighborhood and to household after household across this country? So I will challenge any of the members opposite that agree with me to make public their disgust at these materials. Any of the members that agree that anti-Semitism is too important to be partisan with. Any of the members that appreciate that we have Liberals that are leaders on this issue who include members of all parties to work together in a collaborative fashion to draw in members of community leaders, people from outside of Canada, experts, academics, to bring their views and their studies, their case studies, their analysis, their statistics, their sociological understanding of anti-Semitism. I will challenge those members to say publicly that this is not acceptable. This 10% or this breach of trust of the public, this breach of privilege, is not part, I hope, of their Conservative Party, because it is certainly not part of our Liberal Party. The Liberal Party, one of whose members has created an international definition of the new anti-Semitism that is accepted and respected around the world. People fighting anti-Semitism around the world work with this Liberal member from Mount Royal. So to implicate that member in this defamatory breach of privilege, I find is gone beyond anything that this Conservative Party has done to date, with all of the other hypocritical stances they've taken. Whether it's about claiming to be for accountability, and then the RCMP has to raid their offices because of alleged attempts to cheat on election advertising rules. There is a long list of hypocritic actions on the part of this government, but this is the lowest. This is absolutely the lowest, because whether it's about advertising or tax, yes, that hurts people, but this is about anti-Semitism. This ties into the kind of prejudice and hatred that we have no place for in Canada. This ties into human behavior that is from the darkest side of humanity. Behavior that has, as we know, caused unspeakable tragedies in other parts of the world in other eras. Tragedies that we must never forget and we must work towards ensuring never happen again. And one way that we've been doing that as an interparliamentary group is through the Coalition to Combat Anti-Semitism. And it's through the inquiry to find out what's happening on campuses, what's happening on the streets. Are people of the Jewish faith able to feel safe in their communities? That's what the inquiry is looking into. And what can we do about it so all Canadians can feel safe and all Canadians can be protected by the rule of law, our human rights, have their differences and their religion respected. We're working on that together, or we were, Madam Speaker. We were working on that together. But it is very difficult to see how that group can work together day after day, week after week, and have the trust and have the confidence and have the support of respected academics and respected leaders from the United States, from Britain, from around the world come and help us work on this. How can we expect that with this kind of breach of privilege happening, this kind of disgusting piece of abuse of taxpayer dollars? How can we expect them to take Canadian parliamentarians seriously? How can we expect them to take the parliamentary inquiry into anti-Semitism seriously when this kind of abuse is taking place?
Perhaps I regret to interrupt. Perhaps the honourable member can continue her comments and questions and comments. The honourable member for Edmonton Millwoods Beaumont.
Well, thank you so much, Madam Speaker, and I do agree with at least one thing that the honourable member said, that all 308 members of this House should stand strongly against anti-Semitism. I do agree with that. However, the subject matter at hand today is this 10%er that went out, and there seems to be particular focus on the of the three clauses of the 10%er, the three arguments in terms of the Liberals' position. There seems to be particular focus from the Liberal members on the phrase that says willingly participated, that the Liberals willingly participated in overtly anti-Semitic Durban 1. So what I would ask the honourable member to specifically answer is which part of that phrase is untrue, according to her, because she's went on at considerable length about how this is untrue. Is it the part that the Durban 1 was overtly anti-Semitic, or is it the part that says the Liberals willingly participated? I'm just curious which of the two parts, because she's made it very clear that she feels that that phrase is untrue. Is it that the Liberals willingly participated that is untrue, or is it the part that Durban 1 is anti-Semitic?
The Honourable Member for Vancouver Quadra.
Thank you, Madam Speaker. I'll in turn ask the member opposite a question. How can he actually assert that all members of this House are committed to fighting anti-Semitism when that member and his government is undermining the very process that's been put in place by parliamentarians to fight anti-Semitism, the very credibility of this parliament, and the very capability of that process to have any kind of justification or credibility in the minds of the scholars and the leaders who care about this issue and who we need to help us to reduce anti-Semitism. How can he claim that? Thank you.
Questions and comments? Questions and comments? The Honourable Member for Moncton Riverview, Dieppe.
I thank the Honourable Member for her comments. I wonder if she'd agree with me that it's interesting that the Minister of Citizenship and Immigration, in his opening defense of these egregious 10%ers, made some interesting comments which were along this line, and whether she agrees with this. It is interesting, isn't it, that the minister would say he condemns anti-Semitism. Then he says we, as Liberals, participated in an anti-Semitic conference. But then he finishes by maintaining that, or he will not say, that we are anti-Semitic. How does he get himself out of that? If he says that we all participated willingly in an anti-Semitic conference, and that's, of course, the impression that was left with the voters of Mount Royal, which is why the Speaker has ruled about the contextual aspect of the 10%er. If he says we supported and participated willingly in an anti-Semitic conference, how can he not conclude that we are anti-Semitic, and why wouldn't he say it? He knows it's not true. That's the question.
The Honourable Member for Vancouver Quadra.
Much of what we've heard from the other side of the House is not true. Much of it is hypocritical. And that's the exact point that I've been making. We all know that the member from Mount Royal is the flag bearer for combating anti-Semitism. And we know that he is sought after as a speaker around the world because of his scholarly and his parliamentary work to counter anti-Semitism. And the members on the other side of the House know that as well. And they know very well that his presence at Durban was a constructive one, and that he stayed because he was asked to stay to bear witness to what was going on there. And they know very well that he spoke up publicly and loudly against participating in Durban 2, and I heard him do that personally in London in the conference to combat anti-Semitism. So I am very struck by how we have a member of the governing council who is willing to be this hypocritical, and the mistruths, as just pointed out by my colleague, are staggering for someone who should take his responsibility to the people of Canada seriously, and his responsibility to the Jewish community.
I would just like to warn members about calling, attributing motives like hypocritical to other members of the House. It verges on the unparliamentary. Questions and comments? The Honourable Member for Mount Royal.
Thank you, Madam Speaker. I just want to make a point that perhaps is getting overlooked in this debate, and that is that the flyer that was sent out was in the form of a ballot. That kind of flyer outside an election campaign is itself an abuse of process, and an abuse of process on public funds. And that flyer asks which of the two parties, Liberal or Conservative, better represents issues of value, of concern to the Jewish community. And then that flyer purports to compare the position of the two parties, not what individual members in each of the parties might have said, but the position of the two parties as a matter of record. And the member for Nepean Carleton says we should be looking at the facts. And that is the point, Madam Speaker. What was said as a matter of fact, and as I said, I have no quarrel with a Conservative government setting forth their position on these matters and even setting forth their own position favourably. But that is not what that flyer did. That flyer perniciously and falsely misled the targeted ridings as to what the positions of the Liberal Party were and the members of that party. So when the Honourable Member for Nepean Carleton says, well, it's the facts that caused the Honourable Member from Montreal or others to have their standing reduced because of their party's position on these issues. No, Madam Speaker. It was the misleading and pernicious misrepresentation of those facts, as the Speaker would found in his ruling. That is what reduced the standing and reputation. When the Honourable Member gets up and says that the Liberal Party, as a party, sought the delisting of Hezbollah, as a fact, Madam Speaker, it was the Liberal government that put Hamas and Hezbollah on the terrorist list, which they avoid. When they say that the Liberal Party and government was at Durban willingly participating in an anti-Semitic conference, that is associating us and identifying us with anti-Semitism. That is the misleading and false allegations and accusations made by them that undermined us as a party and undermined every individual member's standing and reputation. For that, they still owe an apology to this House, and they owe an apology to each of the constituents in each of the ridings that received on public funds those false, misleading and malicious flyers.
The Honourable Member for Vancouver Quadra for a response.
I agree. So I call on the members opposite to make that apology. And I will also remind the members opposite that each of those that went to London agreed to this, that parliamentarians should return to their legislatures or Parliament, establish inquiry scrutiny panels that are tasked with determining the existing nature and state of anti-Semitism in their countries, and develop recommendations for governments and civil society action. That's what those of us that went to London agreed to. We agreed to do it in a nonpartisan way. We were not agreeing and instructed to take materials on taxpayers' dollars and circulate pernicious falsehoods about a previous government and an opposition party for partisan gain. So I think that those members should be ashamed of these and they should apologize. Thank you.
Resuming debate, the Honourable Member for Windsor-Tecumseh.
Thank you, Madam Speaker. I'm pleased to rise on this motion and the ruling by the Speaker, Madam Speaker. I quite frankly have been, and I say this both as on a personal basis as a member of Parliament, but also on behalf of my party, been extremely offended by the tactic and the content of this, the use of the tactic in the use of this 10%er and the content of this 10%er. I have to say I've been here 9 years tomorrow, and this is absolutely the worst 10%er I've seen go out. And I say that without any reservation. It is absolutely the worst one. Madam Speaker, there may be one good thing that comes out of this. And I really want to praise the Speaker for his ruling. I think it was absolutely appropriate. And I'll come back to that in a minute. But I'm hoping, Madam Speaker, that out of this, when it gets to the committee and they review it and come back to this House with recommendations as to how the breach of the privilege should be dealt with, that we may in fact clean up the process around the 10%ers, their use at taxpayers' expense, and that we never have to face this type of material going out at taxpayers' expense in the future. So that should be our goal. I think that should be the goal of all sides of the House coming out of this experience. Madam Speaker, I do want to go back and again praise the Speaker for his ruling. I think he was absolutely right to look at this material in its general context. We can play semantical games with this kind of material. If you take it out of context, try to limit it in its scope by using semantics, you can argue that it's not what in fact it is. And what in fact it is a document that to any objective observer reading it, it's a document that accuses the Liberals of being anti-Semitic. There's no other way of interpreting this if you take the whole context. If you look at the writings that it was sent into, if you look at some of the people who were targeted, some of the Liberal members who were targeted. I will say in that regard, Madam Speaker, I've had the pleasure, I hope this doesn't show up in a 10% or a householder at some time, but the pleasure of working fairly closely with both the member from Mount Royal and the member from Winnipeg South Centre. They were two of the ridings that were targeted. And Madam Speaker, to accuse them, given their long history, both of them, of fighting for human rights, fighting for civil liberties, fighting for a just society, is just quite frankly inexcusable. And I think the same could probably be said for some of the other members. It's just that I know those two, I think, better than the others. And to send it into those ridings, again, it's an all-time low for this House. And then, I mean, doubly, Madam Speaker, you can almost see, Madam Speaker, how this comes up. It's really political people, it's party people who write these things. And that's probably maybe something that should be changed by all the political parties. We should take a look at the orientation. But you could see this coming out in a pamphlet during the course of an election written by people who go over the top in political parties in attacking other members of this House and other candidates and other political parties. But when you recognize this is a document that's going out at the expense of taxpayers, it's a document that's going out under the authority of this House, it's the only way these are allowed to go out. Again, the content is really just reprehensible. It should not have happened. And Madam Speaker, when you look at it, and I want to go back to the contextual argument, because the Speaker was right on doing this. When you look at that, there's another discrimination that's going on here by targeting specific ridings where it is known to have a large Jewish community. It's discriminatory to them, to the members of those constituencies, because it makes presumptions on how they vote, on what their biases may be, and what their orientations may be. And it presumes, and I think this is where the discrimination comes, it presumes how they're going to react based on their faith, their ethnic background, whatever. And in this case, particularly on their faith. And that type of targeting, again, should not be allowed, shouldn't be allowed in any context, but certainly, again, if it's a document that's being paid for by taxpayers, being authorized by this House, it simply should not go out. Madam Speaker, and this is probably more appropriate for the committee to be taken into account, but I want to go back to my opening statement about looking for some good coming out of here. I have to say to you, Madam Speaker, and to this House, I would not be satisfied if the recommendation coming back from the committee is simply an apology. An apology is acceptable if there's been a mistake made and a factual mistake made. But that's not the case here. This goes way beyond that. You can't argue that somebody preparing this material and then sending it out did not know, did not intentionally know what the consequences were going to be and how it would be interpreted, how it would be seen by the recipients of this material. So an apology, in my opinion, in this case, is not sufficient. It should be forthcoming from the government. In fact, it should be forthcoming today. It should have been when it first came to the public's attention. But that alone is not sufficient. There has to be some other consequence for this type of egregious behavior. And Madam Speaker, one of the suggestions I can tell you we'll be putting forward to that committee is that the cost of this to the Canadian taxpayers be reimbursed to the Canadian government by the Conservative Party. And I think that would be a much more appropriate penalty, not just for the riding of Mount Royal, but for all 10 or 12, whichever number of ridings that it went to. That'll be a fairly expensive penalty, Madam Speaker, but maybe the message will get through. Not only to the Conservatives, because I think there have been other political parties from time to time who have crossed the line. Again, as I said earlier, not as bad as this one, but the message will go out. And then the final point that I would make is that hopefully there will also be recommendations as to the content of 10%ers in the future, of how we restrict that so these types of attacks of a discriminatory, bigoted, those kind of allegations would never be allowed again. Madam Speaker, those are all the comments I have. Again, I want to praise the Speaker for his ruling. I think it's just been an excellent one, and maybe it will bring us to some conclusion that will help this House to function more efficiently and fairly in the future. Thank you.
Questions and comments? Questions and comments? The Honourable Member for Thunder Bay, Rainy River.
Thank you very much, Madam Speaker, and I thank my colleague for his remarks. One of the things that I'd like to make clear is that as a relatively new member of the House, is that I do find these mailings to be important for a couple of reasons. One is that they help a democratic debate. They help to explain policy. They help to explain other people's policy. And while we're talking about this particular issue in the House today, which I'm sure the government will admit was an error, I wouldn't like to see the program stymied in any way, because I find it very important in terms of getting my message out. And I just wonder if my colleague would like to make a comment on the value of these 10%ers.
The Honourable Member for Windsor-Tecumseh.
I'm glad he asked that question, Madam Speaker, because it was a point I meant to make in my address. There is no question that the 10%ers are a valuable tool for us to be able to communicate, not only with our own constituents, but with the country as a whole. It should be, and in a lot of cases has been, a tool to educate, to share information with the general public on issues that are in the public domain currently. Madam Speaker, I think it's additionally important, and this is what the point I really wanted to make in my speech. I know the Liberal Party has been out publicly wanting to stop the regrouping and not allowing the 10%ers to be sent by individual members or by party leaders to other ridings other than their own. Madam Speaker, I think that ignores, or perhaps it does ignore the reality of political parties in this country having regional areas that they don't have any representatives in. And so those areas would be, in effect, deprived of the arguments, the issues, the policies of that party that has no representation in that area. And so I think it's important to continue that ability. My argument is very strong. We have all sorts of laws that restrict what you can say in terms of libel. And I think we have to look at that and put some parameters. I want to say that it's my understanding, and I intend to do some more research on this, that the Ontario government has a mail-out program for their members who sit in that House. But there are restrictions on what the content can be. And I think we need to look at that as well. And that would hopefully be another recommendation coming from the Procedure and House Affairs Committee when they review this issue of privilege. Thank you.
Questions and comments? The Honourable Member from Hamilton, Stony Creek.
Well, thank you, Madam Speaker. And I'd like to make a couple of points to the Honourable Member. I concur with your view of the member from Mount Royal. I have spoken with that member on a number of important issues. I've worked with him on a committee. And for anybody to infer in any fashion that that individual is anti-Semitic is just so outrageous and ludicrous, is beyond belief. And I just wanted to reaffirm for the record my view of that member and the high regard I hold for him. Beyond that, on the issue of 10%ers and the value of 10%ers, in my case, I refer it as my report card to the constituents I represent. I send them these tidbits of information about what we're doing in this House because irrespective of the bubble we live in here, the people back home many times don't know what we're doing, and I oftentimes leave a space for them to mail back to me to raise their concerns and their points, and on occasion they disagree with me. I know that's hard to believe, Madam Speaker, but it does happen. But that allows me to generate the debate. And once my 10%ers have gone to my community, the next day or so when I'm home, I have 3 or 4 or 5 people who actually stop me and refer to them. And to open that dialogue and keep it continuing with the people you represent, I believe, is very important.
The Honourable Member for Windsor-Tecumseh.
Well, I thoroughly agree with my colleague from Hamilton that it is a very useful tool. He's added another dimension to it in terms of the ability of our constituents to respond. I think we, from time to time, all do that, have a mail back to see whether they agree with the position we've taken in the 10%er, give us additional feedback, maybe on points that we haven't covered. And I think it's extremely important that we keep this program going. But we do have to curtail its abuse, and I think it is possible to do that.
Questions and comments? Questions et commentaires?
Questions and comments?
Honourable Member for Winnipeg South Centre.
Thank you, Madam Speaker, and I thank you for the opportunity to speak here tonight. It's an important discussion, and I'm very pleased to stand in support of the Speaker's ruling today on the question of privilege on behalf of my colleague, the member from Mount Royal, because I also view it as a question of privilege for myself. Madam Speaker, I would have hoped and I would have expected a government, my government, the Government of Canada, to have stood here this evening or this afternoon after the Speaker's ruling to disavow the flyer that had gone out, to make an effort to bring people together, to apologize, which I would agree is not sufficient, rather than to demonize, to divide, to continue to draw a wedge among Canadians, to present information that they know to be misleading and not factual over and over again, and repeat it over and over again as though repeating it frequently will make it a truth. I want to put a few things on the record, Madam Speaker. It's important to note that it was a Liberal government in Canada that on the 29th of November 1947 helped to vote the State of Israel into being. And Canadian support for Israel's right to exist in peace and security has been a constant in Canadian foreign policy ever since. There have been times, no doubt, when reasonable people could disagree with the policies or actions of an Israeli government. After all, we all know that in Israel itself, there has always been opposition and disagreement with the government of the day. That goes with living in a democracy. Who knows, Madam Speaker, if Conservative backbenchers were allowed to do any thinking for themselves or deviate from script, they might occasionally be critical of an Israeli government or of their own without being thought anti-Semitic or anti-conservative. However, neither in Israel nor Canada has there ever been any question about Israel's right to a secure existence. In the 61 years since the creation of the State of Israel, Madam Speaker, 11 people have occupied the office of Prime Minister of Canada, and none until now has ever sought to turn that broad support for Israel into an issue of partisan politics. But this government and this Prime Minister try to govern on the principle of divide and conquer, divide and rule, and in this case they are doing it by singling out Canadian Jews for a special message. And it is a message that I would submit that's based on deception, innuendo, half-truths, and non-truths. For this government, such conduct seems to be instinctive, but I would submit again that it is not the Canadian way. A government which sees nothing wrong with a 10%er targeting Canadian Jews now will see nothing wrong with targeting Sikhs or Muslims or Serbs or Bosnians tomorrow. The manipulation of religious or ethnic minorities for short-term political gain, I would submit again, is a recipe for long-term disaster. A country like ours becomes ungovernable when a government seeks to mobilize or divide people on the basis of their culture and their religion. In this particular case, Madam Speaker, a 10%er targeted at Jews or any other minority is to turn them into political fodder, and the communities in which they live into someone else's battleground. I would say that as a Canadian Jew, we are quite capable of managing our own disagreements without the interference of the national government or any political party. And I want to reference the 10%ers which the parliamentary secretary spoke about. He talked about other parties submitting 10%ers. Well, I think it's important that we all realize that 69% of the 10%ers that go out from this House are sent out by the party opposite, most into ridings that they don't hold. 11% are sent out by the New Democratic Party, and 13% by the official opposition. These 10%ers as well, Madam Speaker, were targeted into the very ridings that the strongest advocates for good Canadian-Israel relations live in. The loudest voices against anti-Semitism are those individuals whose ridings were targeted. The flyers were sent to denigrate the members and denigrate their records and reputation. And I would say, Madam Speaker, that it's reprehensible. Moreover, singling out Jews and Jewish communities in this way is appalling, demeaning, and potentially dangerous. It's not flattering, Madam Speaker. It does not confer special status. Yet the party opposite has no scruples about playing off Jews one against another, or playing one group of Canadians against another, or singling out Jews for special attention and treatment. I think Jews with any historical memory ought to be very nervous when a government starts targeting them for special treatment or special messages. Now, Mr. Speaker, you've taken over, and I would say to you that we've been there before, and we're in very dangerous territory. Mr. Speaker, historically, Jews have been a marginalized, vulnerable, identifiable cultural group. The government should not be in the business of separating them, or indeed any minority of Canadians, from the general citizenry, and targeting them for its own security are not and should not be partisan issues. And yet, Mr. Speaker, through these flyers, that is what this government is offering, an appeal to fear that can only poison the wells within the Jewish community and between the Jewish community and the wider community of Canadians. I want to read into the record, and perhaps it's been done before I was in the House this afternoon, Mr. Speaker, the comments made by my leader, the member from Etobicoke, when he said at a Canadian Jewish Congress meeting, he said, "My party will never claim to be the only genuine defender of Israel in Canadian politics, because I don't want my party to be alone in the defense of Israel. I want all parties to be genuine defenders of Israel." Mr. Speaker, many of us, and I've referenced this before in a statement I made in the House the other day, many of us will have seen in films or in documentaries that very famous exchange between Senator Joe McCarthy and Joe Welch, who was chief counsel for the Army in the so-called Army versus McCarthy hearings. Wanting to discredit Welch, McCarthy tried to discredit a young lawyer in Welch's firm. Welch responded with words that have resonated down through the intervening years, and they are words that might be addressed to this government, Mr. Speaker. He said, and I quote, "Until this moment, Senator, I think I have never really gauged your cruelty or your recklessness. Have you no sense of decency? At long last, have you left your sense of decency?" Mr. Speaker, I would submit that if the Conservatives cannot see the value of having all parties standing together in support of Israel, I would say that perhaps their interests lie outside the Jewish community of Canada. Dividing a wedge among us is not the way to govern this country. Thank you.
Questions and comments. Questions et commentaires. The Honourable Member for Toronto Centre.
I want to congratulate my colleague from Winnipeg for a very fine presentation, and my good friend from Mount Royal with respect to the interventions that he made. I just want to read into the record a couple of things, Mr. Speaker, because I know a number of papers have been read in, but a recent editorial in the Toronto Star says this, and I'm quoting 3 times. "Through a deliberate twisting of the facts, the flyers suggested that the Liberals are anti-Semites." Goes on to say, quote, "What is really grating about these vile flyers is that they were delivered at taxpayers' expense," end quote. And a third quote, "Harper and his party should repudiate the flyers and apologize for having distributed them." Mr. Speaker, I do think that my friends opposite need to reflect on what's happened. I know that we all get engaged in partisan exchange, and we all get engaged in very vigorous political fights. And I think perhaps as somebody who's been through a few of those myself, and I've delivered a couple of blows, some of them unfair over 30 years, I think we would all say that there are times and moments when we might have wished that we had not said something that we'd said. And I do think this is a time for all of us to reflect on a couple of things. The first is the issue of substance before us, that is to say, the content of the leaflet which was distributed. And I find that I'm in agreement with the comments made by the Toronto Star with respect to the document. I do think it's vile. I do think it associates the Liberal Party with anti-Semitism. And I think when we come to understand a little better the history and meaning of that awful, terrible phenomenon in world history, we have to understand just simply how deeply wrong it is for a political party to accuse another political party of hosting or encouraging any such views. To put it in more accurate terms, anti-Semitism is Jew hatred. And the suggestion that members of this party engage in that kind of activity is frankly nauseating, Mr. Speaker. The second is the question of these flyers. And I'm happy to engage in a discussion with my colleague from Windsor with respect to the issue of what should we do about the 10%ers. But if anybody thinks that this can be allowed to continue at taxpayers' expense, Mr. Speaker, they're sadly mistaken.
the honourable member for Winnipeg South Centre.
Thank you, Mr. Speaker, and I welcome the opportunity to very briefly comment on my colleague's remarks. I'm glad that he named it is Jew hatred, and to submit that anybody on this side, most notably those whose ridings had the flyers dumped into their ridings, are haters of Jews, is vile and abhorrent.
Questions and comments, questions et commentaires. The honourable member for Cape Breton-Canso.
Mr. Speaker, we have a huge opportunity and a tremendous opportunity to serve in this House, and we serve along beside many great Canadians, and none greater than the member for Mount Royal who's brought this motion forward, and my colleague who's just addressed the House on this particular topic. Having had the privilege of coming to the House, whether 9 years ago, we're both in the class of 2000. We had a gathering last night, a group of us that still remain here from the class of 2000. And we talked about the highlights and the lowest points that we've experienced in the House over the course of 9 years, because there are many highs and there are many lows. I'm wondering if she'd take the opportunity to share her very lowest point with the people that are watching this debate at home and with those here in the gallery today.
The honourable member for Winnipeg South Centre.
Thank you, Madam Speaker. Mr. Speaker now, sorry. And I thank my colleague for the question. And I have to say that in answering it, it's a difficult one. It's a difficult one to answer. Last night, the class of 2000 played a game of talking about what were the highest moments in their 9 years here and the lowest moments in their 9 years here. We each submitted those memorable moments, some positive, some negative. And as the member well knows, my reference was this past week. This was, excuse me, for me, the lowest of the lowest that I've ever experienced in this House.
Questions and comments, questions et commentaires. Resuming debate. Reprise du débat. House is ready for the question. The question is as follows. Mr. Kotler, seconded by Mrs. Jennings, moved that the matter of the question of privilege raised by the member for Mount Royal be now referred to the Standing Committee on Procedure and House Affairs.
Is it the pleasure of the House to adopt the motion?
All those in favour will please say yea. All those opposed will please say nay. In my opinion, the nays have it. It's close. Call in the members. Accordingly, this vote stands deferred until Monday at the end of government orders. I see the sorry, point of order over here. I see the Chief Government House Leader rising on a point of order.
I'm not a chief, but I am the Government House Leader last time I checked. Thank you, Mr. Speaker. Mr. Speaker, even though we are past the normal time for private members' business, I think if you seek it, you would find consent amongst all the members in the House to proceed to private members' business as ordinarily would have happened at 5:30.
See, the clock is 5:30. It's going backwards instead of forwards. I've got a point of order. Government House Leader has asked me to seek and ask consent first. So I'll see if there's consent for that, and then I'll hear the member for Davenport. Is there unanimous consent of the House to proceed to private members' hour? Yep. Agreed? Agreed. Orders of the day? Should I go to... Okay, we'll read the order first. And then
Orders of the day. Private members' business. Resuming debate at second reading of Bill S-216, an act to amend the Federal Sustainable Development Act and the Auditor General Act, involvement of Parliament, standing in the name of Mr. Woodworth.
sorry, I see the member for Davenport is rising on a point of order.
Thank you, Mr. Speaker.
Maybe I need sort of a further clarification from you, but I had put my name down with the table office to speak to the question of privilege that was raised by the member from Mount Royal in his motion. And I was getting up to speak when you asked for other speakers, and then you moved on right away into other matters. And I'm not sure what happened there, but I believe that I had a right to speak at that time when you had asked for speakers.
The member is quite right. He did have a right to speak. The chair had been informed that there would be no other speakers from the whip's desk. I did call for further speakers. I looked around, I said, is the House ready for the question? And then I proceeded to put the question. So I didn't see the member rise. I did call for further speakers. And I did say, is the House ready for the question, as is normal? And then I proceeded to read the question. At no point did the member for Davenport indicate that he wanted to speak. So the matter has been dealt with now, and we're on to private members' hour.
I think that you did. I apologize, but I did get up, and I think if there was a matter that maybe you did not had an opportunity to notice me, but I did get up. You just moved on to the question, and unfortunately I was left out. My name is there for the record, and I did move, and I had my speech prepared as well. So I'm not sure why I was not recognized and not able to speak on the matter.
Well, I can only assure the member that I did call for further debate. I did, as is customary, glance around the chamber. I did ask if the House was ready for the question. Nobody indicated that the House wasn't ready for the question. Had the member stood up, I would have gladly recognized him, and the House would have heard him. So I think it's incumbent upon members to be aware of the progress of motions and the state that they're in. So we are now on private members' hour, and I understand on debate, the member for, is it Lac St. Louis? Is that right? Lac St. Louis? The honourable member for Lac St. Louis.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. It's my pleasure to rise this afternoon on Bill S-216, which is an act to amend a bill that was introduced in the final hours of the 39th Parliament. This bill was sponsored by a former colleague, John Godfrey, who left the House just prior to the 2008 fall election. Now, I remember at the Environment Committee that Mr. Godfrey went to great lengths to ensure that his bill would be adopted in committee and by the House by the spring of 2008, because he saw that the Prime Minister at the time was considering triggering elections, which is actually what did occur. Now, Mr. Godfrey's bill, the purpose of the bill, now it is legislation, is to require that of the federal government the development of a project for sustainable development for its departments and agencies. And there was a preliminary version of the bill introduced before the House, and it was subject to assessment, and then after the assessment, the preliminary version of the bill would become the final version. So the idea of the bill is to force the federal government to show leadership with respect to its own environmental activities. It would be a way of Canada leading by example on the world stage and showing how we should take steps to protect the environment and reduce greenhouse gas emissions. Bill S-216 aims to fill a number of gaps. The purpose of Bill S-216 is to amend Mr. Godfrey's legislation to make it mandatory to consult not only the House of Commons but also the Senate. So all sustainable development projects, if Bill S-216 does pass, well, the preliminary version would be tabled not only before a committee of the House, but also before a Senate committee. That seems quite clear to me, Mr. Speaker, that the Senate must play a role in assessing the sustainable development plan of this government and this country. Now I'm going to tell you why it's important for the Senate to play a role in assessing the federal government's sustainable development projects. To begin with, Mr. Speaker, there are many senators for whom the environment is a top priority. Many senators who are interested in the environment and who have been interested in the environment for many years. These senators have something to say about projects that are undertaken, and we must ensure that they are able to share their experience and knowledge in the development of the federal government's sustainable development projects. There are four that come to mind. Senator Grafstein, who's nearing retirement. I think he's going to leave the Senate before the holidays. Senator Grafstein is particularly interested in water. He's been working on this issue for years. There's Senator Lapointe, who's a very important Quebec artist and actor, a big Quebec star who's also interested in the environment. There's Senator Grant Mitchell from Alberta, for whom the environment is a priority, and Senator Banks, who a couple of years ago, when he was the chair of a Senate committee, I don't know if he's still chair of that committee, but he produced a very important report about the water situation in Manitoba, Saskatchewan and Alberta. The Senate, therefore, has a number of senators who are ready and willing to take a close and well-informed look at federal government sustainable development projects. Second point that I'd like to raise, Mr. Speaker. You know that senators are appointed, and in some ways the Senate is more representative than the House. For example, in the House of Commons there is 1.62% of Aboriginal representation, whereas in the Senate, Aboriginal senators account for almost 10% of the senators. Women are better represented in the Senate also. So we can observe that there's quite substantial diversity in the Senate, and as far as Aboriginals are concerned, well, these senators represent regions which unfortunately are subject to the most adverse effects of climate change. Senator Watt obviously represents the Arctic region, and unfortunately that region is very hard hit by climate change. So these Aboriginal senators often have quite a substantial interest in environmental issues. So there is tremendous diversity in the Senate, and therefore I think that it's extremely important to consult the Senate on these issues. Second matter, Mr. Speaker. Now, it's all fine and good to refer a sustainable development project to House of Commons committees, but we all know that House committees are swamped. At the committee that I sit on, we have a lot of business, and unfortunately there is a bit of a backlog that we are facing. It's a little bit like a traffic jam, if you will, like one that we see in the Turcotte highway interchange. It's a bit like that, a bit of a bottleneck. So we want to continue our studies with on the oil sands and water. We're looking at the Species at Risk Act. It's our duty to do so every 5 years. So there's many pieces of business like this. The House of Commons committees are very business, so why not call on the Senate and Senate committees in particular to also look at these issues? And that's the second reason why I believe the Senate should be involved in this process. Mr. Speaker, as I said earlier, at the very beginning of my remarks, Mr. Godfrey's legislation, which we are attempting to amend here, would obligate the federal government to play a leadership role in the area of the environment. It's the kind of leadership that the Liberal Party has always shown, especially in the area of climate change. And so I think it would be a very good thing for the country if the Senate were to be more engaged in this issue. Resuming debate.
Thank you, Mr. Speaker. I'm very pleased to rise today to speak to Bill S-216, a Senate bill. And I note that the summary of the bill describes the bill as an enactment amending the Federal Sustainable Development Act and the Auditor General Act to ensure the full participation of each House of Parliament. And clearly there was a mistake made some time back when the original legislation was brought in that is now being corrected with this bill. Mr. Speaker, Bill S-216 is sponsored by the member for Kitchener Centre from the government side. It amends the Federal Sustainable Development Act and the Auditor General Act, and the Federal Sustainable Development Act requires the government to produce and table a number of reports before the House. Bill S-216 proposes that the government table the same report before the Senate. So the bill gives the Commissioner of the Environment, Sustainable Development greater flexibility regarding the timing of the tabling of some of the reports under the Federal Sustainable Development Act. The bill also responds to an oversight that occurred, as I indicated before, occurred during the development of the Federal Sustainable Development Act, and this bill, in fact, corrects the oversight of that time. The Act, Mr. Speaker, also established a Sustainable Development Advisory Council, and there were a number of suggested groups that representatives would be drawn from to sit on this advisory council. We have the parliamentary secretary to the Minister of the Environment did speak on this bill at the first go round, and I took the time to reread the first hour of debate, so I am aware of what the other speakers in the first hour had to say regarding this bill. I must admit it was quite far-fetching. and it was certainly way off the topic of this bill in many, many ways. But nevertheless, the parliamentary secretary does make reference to new regulations for tailpipe emissions, and he says that, quote him, he says he's reduced emissions through stringent tailpipe emission standards in 2011. Well, I can recall the emission standards from the United States under Jimmy Carter. That would be 1980, and they were in place to make certain that the Detroit Big Three built their cars in much more energy efficient ways, and it was the election of Ronald Reagan and his the new Republican right, basically the forebears of the current Conservative Party, who in fact took the emission standards of Jimmy Carter as president and basically gave the car companies a pass. They were supposed to bring in certain emission standards by, such and such a date over, say, a 5-year period, and Ronald Reagan changed it so they had 10 to 20 years to bring in the same emission standards. So it's kind of interesting after 38 years in the political life. I've seen a lot of people change their positions over time, so I'm not used to having conservatives talk in the way they are right now. Certainly in the Hansard here, reading these speeches, I have to certainly get him in for some big surprises here. Also, he says that 90% of Canada's electricity will come from clean sources by 2020, and I applaud all of what he has to say. But I'd like to ask him whether he has any studies, like what sort of studies does he have to show that is in fact going to happen, because I don't know that they actually have control of all the levers that would be required to make certain that in fact would happen. I'd like to get the information from him on that. For example, his colleague, the Minister of Democratic Reform, who is a member from Winnipeg, as I am, has been wanting to, or has been pushing for, an east-west power grid, because we recognize that it is important in order to meet the Kyoto targets, in order to reduce the greenhouse gases. We want to have an east-west power grid so that we can bring developed power from hydroelectric power from Manitoba down rather than shipping it all to the United States on a north-south basis. We want to be able to send it east-west. We want to be able to send the power into Saskatchewan. We want to be able to send the power into Alberta, particularly in Saskatchewan, so they don't have to rely on their coal-fired generation, so that they don't have to do any further studying of the nuclear option, which they're looking at right now. So we want to be able to construct that east-west power grid to Ontario. And if we could do that, what we could do is provide hydroelectric power, clean power, to southern Ontario, and so that they could retire the coal-fired generators that are currently operating in southern Ontario. I forget the exact number now, whether it was 5 or 15, but there's a number of them still operating, and they're certainly heavy on the pollution side. So this is something that, but the fact of the matter is that this issue has been dealt with now since about 1991, when Premier Gary Filmon, who was a Conservative Premier, was in fact dealing with Bob Rae, who was the Premier of Ontario at the time, and the deal fell apart at that point in time, and there was talk of renegotiating or starting to look at it again later on, and things just aren't happening. And it seems to me that with a recession in progress with the United States, and I notice that the Conservatives now are talking about their strong connections with the Obama White House, that they are now taking a different sort of attitude. Well, if that is the case, why are they not putting up the money? Why are they not highlighting this east-west power grid as one of their major projects? I mean, I assume they're heavily interested in re-election, and if they want to do that, I mean, certainly not going to make them any less popular than they are right now if they were to announce we're going to do an east-west power grid from Manitoba to Ontario, and that we're going to sell power into the Ontario market. It's just such a no-brainer. We're putting the money into the north-south routings. As a matter of fact, Manitoba Hydro is getting close now to building its bipole 3, which will be the third bipole. And the debate, of course, in Manitoba is whether or not this thing should be built down the east side of Lake Winnipeg, or whether it should go all the way out to the Saskatchewan border and come back. And I think that if you were to, I think at some point over time, over the next, say, 100 years, we're going to have the bipole 3 is going to be built, and then we're going to be looking at a bipole 4 at a certain point. And there is some advantage to having them spread wide distance apart, because if you were to have an ice storm, for example, and the two bipoles were within, say, 30, 40, 50 miles of one another, they could both be taken down in an ice storm. So there is an advantage to having several of them and having them spread out. We know what happened in Quebec during the ice storm a few years ago, and it basically shut the whole province down for a certain amount of time. So I see absolutely nothing coming from the government side on this issue at any point in time. They've gone through an election now. The only person on that side who gives us any encouragement is the Minister for Democratic Reform, who on a couple of occasions now has said some pretty good things in support of the east-west power grid, but he doesn't seem to be getting anywhere with his member for Portage-La Prairie or Portage.
I'll have to stop the honourable member there. His 10 minutes have expired, so we'll move on to resuming debate. Reprise du débat. The member for Kitchener Centre is rising for his 5-minute right of reply.
Correct. That's what
All right. I'll go to the member for Kitchener Centre.
Thank you very much, Mr. Speaker. I rise to offer my concluding comments in the debate on Bill S-216, an act to amend the Federal Sustainable Development Act and Auditor General Act involvement of Parliament. And before I digress to that, I'd like to thank the member for Lac-Saint-Louis for his very positive remarks today. It's what I've come to expect of him. I also wish to thank the member for Elmwood-Transcona for his very generous praise today of the policies that were outlined by the Parliamentary Secretary, the environmental policies of this government. Mr. Speaker, why do I enthusiastically support this bill? Why should all members support this bill? It's because the proposed amendments seek to strengthen our capacity to progress towards sustainable development. They reinforce one of our government's most fundamental priorities, greater accountability and transparency. Our government has been working hard and has delivered many sustainable environmental measures. As you know, Mr. Speaker, the Federal Sustainable Development Act requires the government to produce a draft federal sustainable development strategy for consultation. The Act currently requires the government to share the draft federal strategy with the Canadian public, the Commissioner of the Environment and Sustainable Development, a Sustainable Development Advisory Council to be created under the Act, and a standing committee of the House of Commons. Indeed, the government will be embarking on broad consultations for the draft strategy in the coming months. And yet, a key institution is obviously missing from these consultations on the draft strategy: the Senate. Clearly, senators are entitled to offer analysis that could improve upon the draft strategy. And that's why I'm pleased that the proposed amendments before the House today add senators to review the draft strategy. The passage with all parties' support of the Federal Sustainable Development Act last year was an important illustration of our collective commitment to transparency and accountability in this area. In our collective enthusiasm for this legislation, however, some of the key elements were overlooked during the committee stage. The amendments before the House today will address these issues, strengthening the Act so that we can work more effectively towards our ultimate goal of sustainable development. Mr. Speaker, as mentioned, the existing Act requires the government to table a draft federal sustainable development strategy before the House. In the interests of fair treatment of the other place, Bill S-216 proposes the draft strategy also be tabled in that place. This is a sensible change that I trust will also enjoy all party support. In addition, Bill S-216 would give the Commissioner of the Environment and Sustainable Development more flexibility in the timing of his report on the fairness of the information contained in the government's Federal Sustainable Development Strategy Progress Report, thus ensuring its timeliness. It also ensures that other reports prepared by the Commissioner are tabled in the Senate. These reports could very well improve the impact of the government's work on sustainable development, and they would surely reinforce the goal of greater transparency and accountability. By extending the tabling of these reports to the Senate as well, there is the additional added value of improving the Auditor General Act. Let's show Canadians that we can all work together. For all these reasons, I ask all members to join with me in supporting Bill S-216. Our government is committed to delivering both sustainable development and greater transparency and accountability. Also, once again, I repeat my thanks to Senator Banks for originating this bill and for collaborating with me in this nonpartisan effort. Thank you, Mr. Speaker.
The question is as follows. Mr. Woodworth, seconded by Mrs. Smith, moved that Bill S-216, an act to amend the Federal Sustainable Development Act and the Auditor General Act, Involvement of Parliament, be now read a second time and referred to the Standing Committee on Environment and Sustainable Development. Is it the pleasure of the House to adopt the motion? Yes. Agreed? I declare the motion carried. Accordingly, the bill stands referred to the Standing Committee on Environment and Sustainable Development. The Honourable Parliamentary Secretary of the Government House Leader is right.
Thank you, Mr. Speaker. Mr. Speaker, I think if you sought it, you would find unanimous consent to see the clock at 6:30.
Is that agreed? D'accord?
Agreed.
In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn.
The Honourable Member for Laval. Thank you, Mr. Speaker. Mr. Speaker, on September 30th, I asked the Minister of Labour to take note of the fact that many women workers in Quebec who work under federal jurisdiction cannot make use of preventive withdrawal during pregnancy because if they do, they cannot be paid. They have to withdraw without pay. So at the time, the minister clearly stated that no, the worker who feared for her health or safety did not have to worry, that she could simply ask to be withdrawn from her job and that she would continue to be paid. We checked, Mr. Speaker, very carefully, the situation that prevails right now for women workers under federal jurisdiction, and it seems that what the minister said is a half-truth, in fact, because workers under federal jurisdiction can ask their employer if they feel worried about their own health or that of their fetus to be withdrawn if they do not want to continue working, and then the employer will say, she can withdraw from her job until an expert determines, a doctor determines whether or not she's correct. Once the worker withdraws, it is true that as long as the doctor has not made a decision, it is true that this worker will continue to be paid in full and doesn't have to worry. However, it appears that it doesn't take very long for an expert or a doctor to determine whether this situation is dangerous for that pregnant worker who's worried about her health. It doesn't take very long, and if she is withdrawn for 1 or 2 days, she will be paid. But when the expert or doctor comes back with a decision and has determined that, yes, this employee works at a job where it is dangerous for her to continue working, and she has to either be moved to another job, transferred, or sent home in order to take care of her health, that's when the problem arises. Because if the employer cannot transfer that worker, she has to go home. And from that point onward, she is not paid. From there on in, she gets no salary, and that's what we're worried about, Mr. Speaker. How can we make sure that all women are entitled to the same preventive withdrawal that is paid, so that they can be safe and go home and wait for their baby with greater serenity? Thank you, Mr. Speaker.
Parliament Secretary to the Minister of Transport.
Thank you, Mr. Speaker. I am very pleased to have this opportunity to provide further information in response to a question raised by the Honourable Member for Laval. The question raised concerned the treatment of workers under federal jurisdiction in Quebec in comparison to their provincial jurisdiction counterparts and in relation to preventative withdrawal provisions for pregnant and nursing employees. A very important issue indeed, Mr. Speaker. The Canada Labour Code gives pregnant and nursing workers who believe their job creates a risk for themselves or their unborn or nursing child the right to cease work and continue to receive pay while they seek a medical opinion. Very important, Mr. Speaker. Indeed, as we face the H1N1 pandemic, the protection of pregnant and nursing women is of particular concern. I thank the Honourable Member for her concern for women and for their unborn and nursing children. If the risk is confirmed by a doctor, Mr. Speaker, the pregnant or nursing worker is entitled to a reassignment to another position or to modification of her current job. This duty to accommodate is set out in both the Canada Labour Code and the Canadian Human Rights Act. Very important legislation, Mr. Speaker, and we should all be proud of the Canadian government for this legislation. It is important to note that under labour standards legislation, both provincially regulated employees and federally regulated employees in Quebec have substantially similar rights. That is, the right to be reassigned to different duties if possible, or to be granted a leave of absence if there is a danger to their health or that of their unborn or nursing child. But, Mr. Speaker, I also think we should put this discussion into context. Bluntly, that member has a concern that she wants to raise about women in Quebec, but while the Bloc Québécois is stuck in opposition benches, they cannot do anything for Quebecers. Our Conservative government and our members, our Conservative members from Quebec, are delivering the goods to Quebecers. Our government has significantly invested in childcare. We have given Canadian women raising young children choice in childcare through the universal childcare benefit available to all women with young children. We are extending maternity benefits to self-employed Canadian women, and we brought in proactive pay equity legislation for workers in federally regulated public sector as part of Canada's Economic Action Plan, Mr. Speaker, that has been so successful for Canada's economy, and which that member, quite frankly, voted against. A significant concern for many women also relates to criminal justice, Mr. Speaker, and you know that Conservatives on this side of the House stand up for the rights of victims rather than the rights of criminals. Yesterday was International Day for the Elimination of Violence Against Women, and I'm sure that all parties agree that we need to work hard to protect women and all persons from violence. That is why our Conservative government is strengthening our justice system, focusing on the rights of victims and of law-abiding citizens rather than that of the rights of criminals. We encourage all honourable members to join with us as we strengthen our justice system to protect women, and I would invite that member to talk to her leader and the rest of her members of the Bloc Québécois to vote with this government when it comes to the rights of women and protecting the vulnerable in our society.
The Honourable Member for Laval. Thank you, Mr. Speaker. I'm pleased to hear my colleague. I appreciate his remarks. Now, Mr. Speaker, you won't be surprised if I say that in large part, he's right. His government can take action. His government can make decisions. His government can be proactive. Well, Mr. Speaker, since the Bloc Québécois, in his opinion, can't do anything, why isn't the government proactive on this file? Why doesn't it make sure that women who want to avail themselves of preventive withdrawal be paid the same way as Quebec women under provincial jurisdiction are paid? I think we have to stop being partisan about this and stop the smoke and mirrors where you look at this in a cavalier way, the way my colleague said. He said everything I'd said, but he omitted to say the missing part here. That is, the whole thing that's forgotten is that the women who are forced to go home don't get paid. They are left by the wayside. The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker, and I thank the member again for her comments. But one key measure put forward by a member of this government, of this Conservative government, to protect women is Bill C-268, a private member's bill introduced by the member for Kildonan St. Paul, Bill 268, that protects women from human trafficking by introducing a mandatory minimum sentencing for the trafficking of minors, a disgusting situation that even exists in Canada, Mr. Speaker. I applaud the member for Kildonan St. Paul for her work on this issue and her continuous effort on this particular issue. That member, the member from Kildonan St. Paul, is standing up for the most vulnerable in our society and has done a lot to bring the issue of human trafficking to the attention of parliamentarians. Unfortunately, Mr. Speaker, again, the Bloc, although they talk the talk, they don't walk the walk. The member for Laval voted against Bill 268, and I'm sure that member had the best intentions. I know the member and I respect the member, but I do not know why, Mr. Speaker, that member who speaks so passionately would stand against.
The Honourable Member for Willowdale.
Thank you, Mr. Speaker. I'm here this evening to elaborate on questions asked earlier about the Government of Canada's advertising program, in particular the advertising engaged with regard to the Economic Action Plan. As we now know, very, very large amounts of money have been spent on government advertising, and I will be the first to acknowledge that certain aspects of government advertising are very important. Educational advertising, advertising required to inform Canadians of specific programs that they can take advantage of. Advertising, although it was insufficient for H1N1, are examples of government advertising that is in fact important, and we support that. But as we have seen, great amounts of money, millions of dollars have been spent on advertising by this government that is, rather than educational, purely self-congratulatory. And I would reinforce the concern that it is taxpayer money that pays for government advertising, and so in effect taxpayers across this country have paid for millions of dollars of self-congratulatory advertising by this government. Even worse, these millions of dollars of this self-congratulatory advertising has also been blurring the image of the Government of Canada with the image and the colours and slogans associated with the Conservative Party of Canada. That, Mr. Speaker, is in breach of several of our federal laws and guidelines, and I would list in particular the Treasury Board guidelines and communications policy, the Federal Identity Program, which requires that government advertising use specifically condone Government of Canada symbols. Those symbols do not include a number of the symbols and slogans and colors in particular that this advertising has included. And so, Mr. Speaker, I have several specific questions with respect to this advertising. So first, and I'll ask the honourable member opposite to keep track, because there are, in fact, 5 or 6 specific questions. Was the Prime Minister's office involved in any way in the creation of the Economic Action Plan brand? What direction was given by the government to communications and advertising agencies responsible for creating the brand and designing the marketing materials and strategies? Who approved of the use of specific colors, images, slogans, look and feel aspects, and other branding elements currently used in the Economic Action Plan brand and associated marketing materials? Who conceived of and who approved of the duplication, for example, of the cover of the 2008 Conservative Party election platform and used the exact same cover for the Government of Canada's 2009 speech from the throne? Who decided that the Economic Action Plan branded logo would use not just any blue, but out of a choice of millions of options of pigments, the exact same pigment of blue used by the Conservative Party of Canada? And what advice, if any, was received by the creators of the marketing materials, the logos, about the compliance of the branding elements of the Economic Action Plan that are currently in use with, so the question is, who was any advice, if any advice was given, what was that advice in terms of compliance with the Treasury Board Communication Policy Guidelines, the Federal Identity Program, compliance with the Conflict of Interest Act, the Conflict of Interest Code that applies to all of us as parliamentarians, and in fact any other laws that restrict conferring benefits on a political party. Thank you.
The Honourable Parliamentary Secretary to the President of the Treasury Board.
Thank you, Mr. Speaker. Mr. Speaker, I rise today in this House to speak to the government's record on communicating Canada's Economic Action Plan. This year, our government undertook unprecedented action to stimulate the Canadian economy and combat the global recession. The Economic Action Plan was and is critical to ensuring that Canadians are shielded from the worst impacts of this economic crisis. We are implementing more than $60 billion in stimulus measures, measures that are having a positive impact right now, and Canadians need to know about them. I mention this, Mr. Speaker, because those actions and our communications of the Economic Action Plan are at the heart of what we are discussing today. The government not only has a right to inform Canadians about our Economic Action Plan, about how to access its measures and benefits, it is also our obligation to do so. We want Canadians to have information about all of the important measures in our economic stimulus package, some of which are available for a limited time, like the home renovation tax credit. Through informing citizens of our actions, we also highlight our accountability for those actions. We have launched advertising campaigns, created a strong online presence, and traveled from coast to coast to coast, among many other activities, to ensure Canadians know about the support that is available. This government has a strong set of rules in place dictating how it communicates with Canadians. The communications policy of the Government of Canada ensures that Canadians receive timely, accurate, objective, and complete information about the government's policies, programs, services, and initiatives. Complementing the communications policy is the Federal Identity Program policy. The Federal Identity Program is about clear and consistent identification. It projects the government as a coherent, unified administration and enables Canadians to recognize at a glance where their government is at work for them. The Honourable Member is concerned about advertising. On that subject, the communications policy clearly states that departments and agencies may place advertisements to inform Canadians about their rights or responsibilities, about government policies, programs, services, or initiatives, or about dangers or risks to public health, safety, or the environment. It also states that departments and agencies must ensure advertising campaigns are aligned with government priorities and government themes and messages. The rules are quite clear. Departments and agencies must ensure that the design and presentation of advertisements conform to the communications policy and its procedures, as well as requirements of the Federal Identity Program policy. All advertising is reviewed by the Privy Council office. Furthermore, departments and agencies must not use public funds to purchase advertising in support of a political party. Mr. Speaker, make no mistake, in advertising the Economic Action Plan, in communicating it to Canadians, our government has followed these policies.
The honourable member for Willowdale.
Mr. Speaker, I was under the impression that this process allowed for elaboration of questions so that we could, in fact, obtain more in the way of answers from the government. The honourable member here has not answered a single one of my 6 questions, and in fact has arrived here for this process with a pre-prepared speech. How on earth could my friend opposite have pre-prepared answers to questions that I only came with this evening? I find it an abusive process is too strong a word, but very, very disappointing that I have come this evening with a list of questions to ask of the government, and my friend opposite has arrived with pre-prepared speech and therefore has not even acknowledged that I've added questions and has certainly not answered them. We have no argument with the government advertising specific information that Canadians need to access programs, but what has been engaged in here...
The Honourable Parliamentary Secretary.
Mr. Speaker, this government is fulfilling its responsibility to inform Canadians about the important economic stimulus programs and initiatives contained in our Economic Action Plan. The government is meeting its commitments by reporting on the use of funds in the tabling of the supplementary estimates and in quarterly reports to Parliament on the Economic Action Plan. The Action Plan website and advertising campaign further increases transparency and accountability to Canadians. We want Canadians to have information about all the important measures in our stimulus package, like the home renovation tax credit, which is only available for a limited time. Thank you, Mr. Speaker.
The honourable member for Cape Breton-Canso not being present to raise the matter for which adjournment notice has been given, the notice is therefore deemed withdrawn. The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24.
Thank you.